Yes.
May it please, my lord.
Yeah.
We're ready with.
Right.
May it please, my lord.
Yes. Yes.
My lords, we are ready with the written submissions, my lords. My colleague is there.
Yes.
He'll hand it over to the honorable court. My lords, we have tried to limit the number of pages, but unfortunately, I couldn't put it down below 20, my lords.
Thank you.
I'm sure we have scored there because it's 15 pages notes. But my lord, we'll have but we have a list of dates,
So
and
you
we
get
have
five brownie points. Yes.
Lord, we have a list of dates, and we have the judgments note, my lord.
Thank
We have segregated this, my lord.
Thank you so much. Thank you.
My lords, my judgments are embedded in the note itself.
Yes. Yes. Yes.
The references are there. In any case, my lords, I have not dealt greatly with judgments. My lords, I've already looked into it. I have not reproduced any paragraphs or anything, just the relevant.
Right. Thank you. So we are closing arguments on this. The written notes of arguments filed by the parties respectively be kept on record. Push up. Hearing is concluded. The matter is reserved for judgment. Thank you.
Very deeply.
I'm obliged, my lords. I'm obliged.
There's an execution petition which, my lord, is also
Execution
pending.
is there pending.
My lord.
Execution will not pass order right now.
Not sure.
Because that will be dependent on
this. Yes.
If the award remains, then we'll take up the execution case.
I'm very deeply obliged.
Thank
Obliged, Lord.
I'm obliged, my lords.
Thank you so much.
My lord, this is my contempt application.
Yes.
This is one of those matters which one doesn't really want to press, but we have no option. My lord had taken this up on the 27th of February.
Right.
And we had actually impleaded the company and not the persons in charge. So my lord had given us leave to implead the correct parties. We have done that, my lord, and served the amended contempt application on them. The affidavit of service may be taken into record, my lord. My lord, the gist of the matter, my lord, is that when my lord was taking up arbitration determination in section 11, my lord had appointed an arbitrator. Thereafter, the contemners, the company that they are in control of, they had filed a recall application before your lordship seeking to recall the order appointing the arbitrator. My lord had therein found that there were material suppression of facts, etc. And my lord was pleased to impose costs of rupees 50,000.
That has not yet been paid.
Not yet been paid. If page 37, my lord takes up.
Actually, your party number 4 is blank. There is no 4. Or you have missed out?
No, there is no fourth party, my lord.
So there are 3 only.
That is just a.
So you have served the notice in the notice. Did you?
Yes, it has been delivered, my lord.
Very good. A prima facie case of contempt has been made out inasmuch as the alleged contemptor has failed to comply with the direction of this court to pay costs of rupees 50,000 in terms of the order dated September 19, 2025, passed in IA number GA-COM1 of 2025 in AP-COM 824 of 2024 with IA number GA-COM2 of 2025 in AP-COM 824 of 2024. Who's up next para? Accordingly, a rule do issue calling upon the alleged contemptors to show cause as to why, for the aforementioned violation of the order of this court, the alleged contemptors should not be held as guilty of contempt of court and be penalized in terms of the prayers made in the contempt application. The rule is made returnable on May 8, 2026. The matter shall next be listed at the top of the list on the said returnable date.
There is some difficulty on May 8th, 1 week later.
So we'll keep it May 15. May 15. May 15th. May 15th at the top. Top, so that there is some certainty for them to know when to come.
Much obliged.
Thank you. After line tag add for the affidavit of service file to be kept on record.
Much obliged.
Thank you. Review application. This is item 4. You are appearing? Yes. You are the review petitioner?
I appear for the
This is
response.
that
This is review.
Yes, yes.
Lord, I am the review petitioner, and
Right.
last time, my lord, I had handed over a compilation.
Yes.
I was taking your lordship, my lord, through the decisions.
Right.
But just to recapitulate, because, my lord,
Yes.
2 weeks have passed, my lord.
Right.
This is a review from an order, my lord, passed by your lordship
Hmm.
in an application where I seek, my lord, restoration of the appeal so that, my lord, I can be transposed under Order 23, Rule 1A, because the appeal stood to be withdrawn.
Right.
My rights were not in conflict with the rights of the appellant. I am one of the respondents, and there was commonality of grounds. I derive my rights from the appellant also. And, my lord, since there were substantial questions to be decided between me and the respondent number 2, who is, according to us, my lord, if I may use the word, is the culprit in the entire process. Therefore, my lord, I was required to be transposed. And your lordship, my lord, on that day had the impugned order before your lordship today, my lord, is that your lordship has held that you should have filed an independent appeal. There are the 2 grounds of review, my lord, that independent appeal.
Yes.
And there are instances where court comes into the rescue to save a respondent when an order is passed in an appeal which gives rise to some right in your favor. But this is not that case. And therefore, my lord, my application was rejected. Now, of course, my lord, I did not specifically press the prayer C, which was for transposition. And my learned friend down the last hearing pointed out that today, my lord, the application was made before your lordship because that the notice says, my lord, if your lordship has, whichever court has dismissed the appeal, my lord, restoration must be before that court. That is why, my lord, the application had to be done before this court. And we did not make a piecemeal application that restoration here, transposition there. It was a composite application before your lordship. Perhaps, my lord, the transposition ought to have been decided by the 11F court, my lord, which 10F court, which has the determination. Perhaps. So, what, my lord, my application that day was, my lord, seeking with your lordship is prima facie. I had to show that there is some semblance of right to be transposed, because I have purchased the shares from the appellants. The appellants, my lord, came challenge the order of CLB, saying that the order should not have been passed, declaring the rights issue of 20,000 shares to be void.
Yes.
Consequently, my lord, my rights flow from there. I did not file an appeal, but I was willing to abide by the result of this appeal. I would have had a right to, my lord, argue and make out my case before the appeal court under Order 41, Rule 4. And Order 41, Rule 33, your lordship also held that if it was in their favor, then a subsequent order, my lord, could have been passed. For example, the 10F court, if it said that this order is bad, CLB order is bad, the shares are perfectly have been issued, and consequently the respondent number 10, that is me, my lord, rights are crystallized based on that. Now, my lord, that right to argue, my lord, has now been taken away in a very cryptic and strategic manner by this withdrawal. So, my lord, I come up with an application, albeit belatedly, because I say I did not have notice and etc. And I wasn't aware. Only when they came to NCLT, my lord, I came to know. But your lordship has not dismissed on the ground of delay. Today, the dismissal is because you did not have a right, so no restoration. So perhaps, my lord, within the scope of review, my lord, we cannot traverse into that arena as to whether I should have come on an earlier time or whether the other orders that were passed. There is another order of Justice Showman Sen, my lord, if your lordship recalls, for valuation. These are not within the scope, in my deepest of respect, my lord, my submission before your lordship. But before that, I want to just show one thing, my lord. The appeal that was preferred by the appellants. The appellants are Prayagdas Daga and the Daga family, few of the Daga family. Respondent number 2 is Sushila Daga, one of the branch. Her husband died, she's one. Now, I am somebody who has purchased from Prayagdas Daga and others, 3 persons. Sushila Daga, my lord, objected from the beginning. This, my purchase. And my lord went to the company law board in the first instance and said that this rights issue is bad. But then there she conceded. She said, very well, I am willing to walk out. I'll take my money and I'll come out. Then, my lord, she changed her stance. When an order was passed by the CLB in the first instance, 2013, she then, my lord, took a U-turn and preferred an appeal from that order herself. Now, Justice Sanjeev Banerjee, my lord, passed an order in 2014 recording that the respondent number 2, which is Mr. Mukhopadhyay, he is not here, his client, had admitted to walk out, but now she has changed her stance and therefore a remand was made to decide whether, my lord, the scope of what should be the valuation if she is coming out on that score. Now, my lord, when on the remand, my lord, the CLB then holds in 2016 that the rights issue is bad and everything is bad and holds it in the respondent number 2's favor and against the appellants, Prayagdas Daga and the other Daga family. Consequently, I am affected because in the meantime, my lord, I have already purchased. I am the ultimate beneficiary and the shareholder also of the company. Now, my lord, the Daga, the 3 Dagas from whom I have purchased, my lord, they prefer an appeal. In that appeal, my lord, they make specific allegations that the respondent number 2 ought not to have taken this stand or a U-turn. They also say that the shares were sold to me because the company, they run a petrol pump. They were, my lord, facing a dry out. So there are specific allegations by these appellants against the respondent number 2. I have the appeal, my lord, here with me. That is perhaps not there before your lordship today because we are in review, but in the course of hearing, it fell from your...
You can hand over a copy of the memo.
Yes,
Don't
extra
leave
copy.
that.
Here, my lord.
We handed over a copy.
You had handed over.
Yeah.
So then it's fine.
Yes, so here, my lord, there are specific allegations. My lord will kindly have a look at this
Memorandum to ache dekho to.
memorandum, na stay petition.
এখানেই আছে সব দেখে নিচ্ছি সার্ভিস তো আলাদা might have been returned to you. Just check up, please.
Stay petition.
Stay petition, it's annexed to the stay petition.
No, no, no. It
I-
is a separate.
I have the review,
It is not annexed.
GA1 and affidavit of service. এটাই টোটাল কাগজ তো না এখানে দেখে নিচ্ছি আমি আছে কিনা
My lord, I have the copy and it may have been returned, I guess.
might have been returned. I suppose I have returned because otherwise it would be in the records. So do you have an extra copy so that I can keep?
Yes.
Thank you.
Yes.
Yes, Ms. Banerjee.
Kindly, my lord, see the stand of the appellants, my lord, in the appeal. It's a very short stay petition, my lord. May I just take your lordship? The first paragraph, respondent number 2 instituted CP number such and such before the company law board for reliefs as would appear from the petition. Respondent number 2 is Mr. Mukhopadhyay's client, my lord, Sushila Daga. The appellants and particularly appellant 1 and 3 contested the petition. The basis of the petition before the CLB is this. Then, my lord,
You are trying to show that they were selling in the same boat as you. That their grounds were they related to your grounds also. I mean your premise of challenge.
no, I want to show that here we are the appellants by filing, my lord, an appeal
Yes.
to set aside the CLB order, which
No, unless you show that they are trying to espouse your cause also in a sense.
perhaps I don't need to show that because, my lord, with deepest of respect, this I'm showing that they were fighting against the respondent number 2, and now they have joined hands and withdrawn.
They have a right to do that. Unless they were espousing your cause, Ms. Banerjee. They are contesting, they choose not to contest anymore. That's their prerogative. But you have to show the court that yes, they were espousing, if not espousing your cause, they were at least selling on the same boat and the premises of their challenge and your proposed
Is
challenge was
same. Kindly, my lord,
same.
It must be same because if the
that is the only thing you have to show, because for vis-a-vis this argument of yours, now at present you are showing that you are under the impression that they were espousing your cause is to higher term probably, but they were
the filing,
preferring a challenge on the same.
yes,
In fact, you have your premise is that they were espousing your cause. Otherwise, you don't have a case in transposition.
by
Unless you show that
by filing the appeal
yes,
itself was espousing my cause, because if
suppose Ms. Banerjee, you are aggrieved, I am aggrieved. I prefer an appeal, then I choose not to proceed with the appeal. My choice, absolutely. Unless you show that I was also, there was any scope of your having an impression that I was espousing your cause also. Otherwise, you should have preferred an independent appeal. Two aggrieved persons can always file an appeal.
That is where, my lord, I join issue.
Yes.
Subject to, my lord, correction is in a situation where, my lord, I still have rights to be adjudicated. They cannot, my lord, withdraw, or even if they withdraw, my lord, I should be transferred. That is the law.
The order impugning the appeal was against you also.
No.
It had an effect on you. You could have taken out a leave application and preferred an appeal if you are not a party there. One. Secondly, if you are a party there, in any event, you could have preferred. It's always done, Ms. Banerjee. Every matter where any person aggrieved may prefer an appeal under Section 10F or any appeal for that matter. Any person aggrieved is the general language used. So you are aggrieved. If you are, unless you are aggrieved, there is no scope of transposition, your transposition at all.
My scope of transposition only arises.
So you must have been aggrieved in some manner.
Is if there are substantial questions to be decided.
No, substantial questions to be decided on that academic ground. Nobody has a right of appeal. I do not have a right of appeal under any law unless I am aggrieved in some manner, I am affected in some manner adversely. Otherwise, I don't have a right of appeal just to academically titillate the intellect of the court to say that this is a question of law, you should decide. No, so, I have to be aggrieved by an order to prefer an appeal.
Which is why, my lord, I did not prefer an appeal, because the order was setting aside the shares, rights issue shares.
If you are not aggrieved by the order, then you don't have a right of appeal. The inter premise of a review petition goes, because then you don't have any right of transposition in an appeal at all.
Perhaps that is not the position, my lord, which I have cited, my lord, those decisions, and I'll take your lordship. The what order one rule.
Nobody who is not aggrieved can file an appeal.
I am definitely aggrieved as a consequence.
Consequentially or directly, you are not bothered. But you must be aggrieved to prefer an appeal. The right of appeal only accrues to a person who is somehow affected by an order. Otherwise, that's a cardinal proposition of law, basic principle, first principle. I cannot prefer an appeal unless I am aggrieved by the order in some manner. Directly, indirectly is a different thing. If directly, then you could have outright preferred an appeal. If indirectly, you always can take out a leave application to prefer an appeal if you're not a party there, and you can prefer an appeal. Everybody does that, and that's done every day. Every other day, we have an application for leave to prefer an appeal. Yes. And that's granted as a matter of course. Almost.
So, in every case, my lord, if a party, if he's aggrieved, then, my lord, to avoid multiplicity, my lord, I have cited, my lord, decisions, so I need not file an independent appeal where my rights can be adjudicated in this one proceeding itself.
Yes.
Which is what I have done. What your lordship is saying is absolutely correct. If you are aggrieved, you should have filed. Yes. But
no, you are on a higher premise. You say, Ms. Banerjee, that not only I am aggrieved with the order, but you also say that you are all along under the impression that this appeal, the carriage of proceedings by the appellant, would take care of your grievance also.
Yes.
If that be so, then you have to show in the memorandum of appeal, your cause was also espoused by them.
So for
your cause means not cause as such, not the original cause, but your grievance.
Yes, yes, I bow down. And my grievance is only that the rights issue which were declared to be void should be set at naught and said not void. To that, if that is done, my lord, I am then not aggrieved anymore. Because if that, so by filing of the appeal itself, kindly, I'll show the
press. As of today, you want to get transposed. So, in effect, you want to prefer an appeal, or you want to continue with the appeal. You want to step into the shoes of the appellant.
Yes.
Therefore, you are in a similar position as you would have preferred an appeal. If you become an appellant, you are preferring the appeal. By definition, an appellant prefers the appeal.
Yes.
So if you want to get transposed as appellant, otherwise we can understand. I want to get transposed. I don't want to carry on with the appeal. I want to go to the respondent's footing. That's a different proposition. But if you want to be transposed as an appellant, then it's your appeal from then on if you are transposed. So you had a right to prefer an appeal, had to have a right to prefer an appeal in the first place, and you never preferred an appeal. That's why you have to show now that yes, there was some semblance of reason or some reason basis for your being under the impression that they were espousing your cause also. Otherwise, you should have preferred an appeal independently. You were aggrieved, you prefer an appeal. Who prevents you? You never preferred an appeal. You sat tight over the matter. Order 41 Rule 33 comes only if the appeal survives. But the appellant, no respondent or pro forma respondent or anybody for that matter can compel an appellant to pursue with his or her appeal or its appeal. No one can compel anybody to pursue. I can any day say that I don't want to proceed with the appeal. I give up. I don't prefer a challenge in it. For whatever reason, I am not required to give a reason. I am required to give a reason if I seek a leave to prefer an appeal on the self-same grounds. Otherwise, I am not required. Only exceptions, as I pointed out on the last occasion, certain cases, mostly in matrimonial cases where pending matters, pending arrears are there of alimony or some other accrued right has, some right has accrued in your favor.
This is what I want to say. What your
No right accrued by virtue of the appeal in your favor. No right accrued by virtue of the appeal in your favor. If an order was passed, a receiver was appointed, that goes, or something in your favor. Nothing accrued in your favor which has been taken away by their not pressing their appeal. They are the appellant, they are the dominus litis in the appeal. They are absolutely the master of the appeal.
Yes, and my lord,
They may choose not to proceed with the appeal. I have too much experiences. I don't want to proceed. I have entered into an understanding even with the other side. I don't want to press my appeal. So why didn't you prefer an appeal independently? That is, the court is in a quandary to understand.
Understand that, but perhaps, my lord, if I show the nature of the appeal and my lord, the compilation, I will have to
No,
take.
both of you may have common causes, common grounds in appeal.
Yes.
You are aggrieved, they are aggrieved. Two
Fine.
are different entities.
Very good.
There may be commonality in the grounds of challenge. Yes, we agree.
My lord, may I just say one thing? If I have already, my lord, purchased their entire shareholding by paying money,
You become the owner.
I become the owner now of their
Therefore,
share.
your vendor does not. Your vendor does not have any duty or liability.
Yet they file an appeal.
They do not have any liability or duty to protect your interest. No duty whatsoever. I sell you the property. I get rid of the property. I don't have any liability in law to protect your interest. My interest. There were two components in that. Your transfer comes later. Regarding the transfer of shares, this being held to be bad and all these things, they had a cause of action. True. But your right is consequential to that.
Yes.
So if they choose not to give up that appeal, your right goes. Your remedy may lie in damages against them. We don't want to elaborate one single word further on that because that will be advising. But your remedy may lie there.
So, my lordship will allow me to explain. If, my lord, today they had given everything away, the fact that, my lord, despite that, they could have washed their hands away then.
They did not.
There was
did not.
Now, my lord, I do not have any direct
country.
No, but the thing is that, my lord, I have been told, my lord, I don't have any documents to show. I have to show whether the legal fees of their counsels were paid by my client or not. We don't have those things. We can't go beyond. My lord, master.
No pleading also, anyway.
So these things we are in review, my lord. We can't, but we can understand at least this much, my lord, that the company, my lord, shareholders, they sell and they go away. And despite that, my lord, when I am the right, I don't prefer an appeal because the order, CLV order says the shares are declared void. So I go and tell them that you have to file an appeal because you are the dominus litis. It says that your rights issue was bad. So your housekeeping was wrong, which is why I have suffered. So you prefer an appeal. Now, my lord, I have to say this. In that situation, my lord, kindly appreciate in a commercial sense. They do that, my lord. Is it not plausible that I may have, my lord, also helped them in proceeding with the appeal, paid for that appeal?
First of all, that will be utter conjecture. Secondly, Ms. Banerjee, they had a cause of action independently of you also, in the sense that the transfers made by them, if that is held to be void, they may be liable to action from you, the purchaser. They may be like, I sell you a property, certain shares. Now, by relying on some transfers in my favor or whatever, transfer in my favor, not whatever, transfers in my favor. So those transfers also go. And the consequential things which I may be liable to action from my purchases. So therefore, they might have an independent cause of action of you regarding the transfer of shares. Because when the transfers occurred, you are not there in the picture. Your right is consequential to that. Your right is it's not co-genetic. The genesis is not
simultaneously, right?
no. Your right is not simultaneous.
The right.
They purchase the shares and then sold those to you.
No, they did not purchase. I mean,
The shares were transferred to them.
yes,
Rights issue, the shares were transferred. Those right issue, the basis of the right issue in their favor, that is what they are agreed with. That is being set aside.
that is set aside, and those rights issues were made to give it to me. Kindly see the appeal.
That is what. Now, those rights issues, your rights are consequential to those rights issues. You come into the picture later. Suppose it might very well have been that those rights were issued, but they did not sell it to you. They could have sold to XYZ, someone else.
No.
So your right comes after, not simultaneously. I have to have something to sell it to you, right? So unless those rights were issued in their favor, first rights are issued in their favor, then there is a hiatus between the two. Then they transfer it to you.
Yes.
Even if there's a momentary gap, there's a gap. It's a discrete thing. Rights are issued in my favor, I sell. It's not a continuum. Not simultaneous cause of action. Your cause of action is subsequent. Immediately subsequent maybe, but subsequent.
Rights issue, and in the appeal they say that this was done in order to sell it to me.
So their cause of action was on the rights issue being set aside. Rights issue in their favor. That may have other consequences than merely they are selling it to you. There might be other consequences. They might have taken other action also on the basis of that rights issue in their favor. So they are independently also aggrieved with the rights issue being set aside.
Then, my lord, they would not withdraw. The purpose of the withdrawal is to
Then they are entered
strategically
into an understanding.
defeat the right.
Entered into an understanding with the respondent. Who prevents? How can you prevent
Now,
them?
that is why I want to show that decision, that when this happens, what your lordship is saying, if this happens, then, my lord, I should be transported not under 23(1)(a), also under 151. Because the court must then step in and render justice. Today, my lord, your lordship is also seeing that assuming for a moment, I keep aside the fact that, yes, it's a fact I have not preferred an appeal. But even if there is some remnants of some right which may be defeated
A very
by...
crucial question comes in. Transposition, was there a transposition application on record when the appeal was withdrawn? Nothing was there.
No.
Most of the judgments you will find transposition does not come afterwards. In a dead appeal, it's deadwood as used by Justice Nariman in a different context. In a dead appeal, the appeal is no longer alive. Who will transpose? Where will he be transposed?
So,
I can only transpose in a live appeal.
wait, my lord, kindly on that. Then, my lord, now this issue, if I have a right to be transferred, the question now is when. Now, question now is then when.
Where? If I suppose an appeal is withdrawn today, day after tomorrow I come and file an application for transposition. That transposition will be effected in what?
So that
In
is
air.
why my
There is no appeal.
that is why my prayer was to restore the appeal and transpose. Even though Kerala says in a situation like this, restoration is not required, and there are several Kerala decisions. To do substantial justice, my lord, for a technical ground that there is...
The Chief Justice of the Kerala High Court, when he was sitting here, he recorded in an order that you had said that you don't have any ground.
That is not purview of the
So
GU.
that's also a Kerala judgment. If you are on retrospectivity, that is also Kerala High Court's judgment. Because you are trying to rely on retrospectivity. After the appeal is withdrawn, I can get transport. So the Kerala High Court Chief Justice, it's a judgment of the Kerala High Court then also.
There is no law which says that it should be simultaneous. Kindly, my lord, seize Order 23, Rule 1A once. Withdrawn, abandoned.
It's a first principle. Ms. Banerjee, first principle in the sense, I want to get transposed in an appeal. An appeal has to be live for my doing that or the court doing that. Yes, the court could have. On the date when they withdrew, the court very well could have transposed you.
I was not there that day.
Itself, Suomoto also court could have transposed.
Yes, now
no doubt on that.
Now,
but on that date, the position was that there was, although this was not adverted to, but the position of law was that one order is recorded in this appeal that you don't have any grievance. You.
But Miller, Very well. Your Lordship will say what you
So
have.
as of that date, there was nothing to even make the court or make the court think about transposing. Why should the court transpose you at all?
Well,
First of all, there is no prayer. Forget that. Even otherwise, your submission remains on record that no, I am not agreed with that part. So then, where is the question of why should the court transpose you?
may I say answer that? Because on that day, when it was withdrawn and there was no transposition, that order of justice sent was not shown. The withdrawal was
That position was on record. Ms.
Yeah,
Banerjee,
but-
what? Why should the court transpose it? Then, in that case, if that is taken, your argument is accepted. Every matter, in every matter where there is an appeal withdrawn without liberty to sue afresh, the court has to automatically transpose the respondent, some respondent or the other, although that respondent has never come up and challenged.
which is two answers to that. Two answers. First of all, Milord, it is not in every case that a person will have a right to be transport. It is very specific. Only in situation, Milord, where there are questions to be decided between the two, between some other respondents. So the court generally in a partition suit and etc., Milord, and this is a quasi partnership. It is an admitted position. In the 10F appeal, in the CLP proceeding, they say this is a quasi partnership. Milord,
Between whom?
Between the shareholders, the structure of the company. So it is a quasi partner. May I answer? So in that situation, forgetting 10F, forgetting CLP 397, if the company, Milord, is being run in a quasi partnership, Milord, there are situations where there may be other questions to be decided between some other respondents, like in a partition suit. I will show those paragraphs. This is there. So in that case, the court generally, Milord, no aspersion on the court, usually will ask.
Not a question of aspersion. You can make aspersions against the court. No, prevailed in that. No compulsion on the court in law. That is the difficulty you are facing.
So,
you can cast whatever aspersion on the court.
no, I
is immune to aspersions because we are in the bar. We know what we say outside the court.
don't say anything.
No, you are an exception. So we know what we say, but maybe the language differs according to vocabulary. But aspersions is not an issue here. Compulsion of the court, whether the court was mandated to transpose you.
No, mandated to transpose.
That is not so.
Yes.
If it was an option, discretion, then that discretion not being exercised by the court, can it be subject of review?
Kindly
is that an error apparent on the face of record?
No, we are not on error apparent of that order. We are error apparent on.
You are applying two legal fictions. First order, then second order. This is a second degree legal fiction.
No, Milord, subject to correction. On that day, Milord, I had a right to be transposed. I was not before your lordship. And the court, Milord, did not find out or forget about the court, Milord.
No. On the recall application date, you did not have a right. Appeal was not there. That's why I am saying double legal fiction.
On the first day.
You are now seeking a review of the order where recall was refused.
Yes.
Right.
Only that.
On that date, we have to see the position.
But your lordship, just now we were talking about the previous withdrawal date.
If on the previous withdrawal date, there was no mandate on the court, then on the recall day, it was all the more true. Because there was no appeal in addition to the same logic as applied in the first day. That there was no compulsion on the court even on the day of withdrawal of the appeal to transpose.
There was.
Very well. Then restoration application stage, in any event, there was no appeal in that.
Milord, may I just say, let's Milord talk about the first one. This is 2024. A withdrawal application is made before your lordship saying, I want to withdraw. And your lordship on the basis of order 23, rule 1, Milord, allows withdrawal. Now at that stage, the question is whether I should have been transposed or not. In my absence, I am not there. There is no application before your lordship. Milord, my answer is twofold. One, this is a quasi partnership form. So there are questions to be decided, and inquiry could have been made or to have perhaps been made that whether there are other questions to be decided or not. Then the onus is on them to disclose to your lordship that yes, I am withdrawing, but there is respondent number 9 and 10 who are still the owners now, and their rights have to be decided vis-a-vis the respondent number 2. This, Milord, in my humble submission, even if the court does not, today, Milord, as an advocate, is it not my duty, Milord, to point out to the court, if I may ask myself, kindly see, Milord, the order there. They simply come, not even putting that affidavit of service on record. today, my lord, we know that that affidavit of service is not there. Today they are trying to show this, that, but kindly visualize on that day. The advocates come to your lordship without any affidavit of service, and your lordship, my lord, out of that trust, my lord allows the withdrawal. Your lordship does not inquire. But my lord, with deepest of respect, my lord, as advocates, we have a duty to point out, because determinations are changing on a regular basis today. 10F appeal today, your lordship was taking, then tomorrow, my lord, something else. It should have been, as an advocate, my lord, pointed out to the court, I am withdrawing, I have nothing against, but yes, there are other respondents who have purchased from me. But the intention of this withdrawal is to, my lord, strategically.
They've got an affidavit of service, contemporaneous affidavit of service.
Now we are on that day, my lord. On that day,
Yes,
they did not.
because one of your premises is that you did not have notice of their withdrawal.
Yes.
But they say that they have a contemporaneous affidavit of service to show that you were put on notice.
They say that, and I will deal with that, my lord, if in review jurisdiction.
If necessary, I can take that affidavit of service on record also and ask you to deal with it.
I will.
Not subsequent, that is contemporaneous. That is what
what they are saying,
that is the date we are focusing on. You are arguing on that date. And one of your arguments is that you had no notice. They say they have a contemporaneous affidavit of service. It cannot be subsequent because it must have been affirmed on that date when the appeal was withdrawn. So let us take it on record. Why?
If your lordship will take it on record, your lordship
you can put it on record.
Even apart from that, I had shown that service letter annexed to their own recall application which shows service.
That was
apart from that as well. But even so, I can put it on record. The appellant is sorry. Yes.
Let them show, I will deal with that.
Give them a copy also. Get a copy during the course of her hearing, Ms. Banerjee's hearing. You just get a copy of that and give a copy and then hand over to me.
The original, I believe, was taken last occasion we had already.
It's on record.
It's affidavit of service. One affidavit of service is on record.
That should be sometime in 2024.
Copy was probably given to Ms. Banerjee. Just check it once.
Copy
Was given. If I take something on record, definitely I'll request.
It was not, your lordship had taken it. There was no order to that effect. But I will deal with Miller. May I just argue in the manner that
You like, yes.
prepared myself, otherwise.
Hello,
Yes, Ms. Banerjee, definitely. Sorry. Please,
Hello,
got it.
I pray for leave to submit my wakalatnama.
Do you do it in the court in the origin side? You put it in.
The department will be the end, but after that.
Department, the difficulty is things get lost when you.
I will not do it only as an officer of the court, Milord. I am not objecting. But legally, this is not permissible. I'll make my submission.
What? The filing of affidavit? Vakalatnama?
No, not Vakalatnama. Oh, sorry, that.
Filing the Vakalatnama.
Vakalatnama, yes. I don't have.
Give a copy of the Vakalatnama too.
And they are now the appellants who had withdrawn. Suddenly, Milord, they are filing a Vakalatnama.
Yes.
And espouse.
They withdrew and you want to recall that order. You want me to recall that order?
Recall so that they come on board. They can very well go. I want to continue. Yes.
What would be the effect of the recall order? What is the effect? The appeal survives, rather revives.
Restoring of an appeal. The order, your lordship, will today for transposition.
If your application is allowed, then their appeal gets restored. Their appeal.
Their appeal gets restored only for the purpose of my transposition. That is my case and that is permissible. They don't have to come and argue. Suddenly, I don't see why, Milord.
They don't have to justify. All the allegations are made against them, their advocate. Only their aunts and uncles are left out.
No, I am not.
Parents probably you have covered already by the partnership. So everybody, their advocate did not do his duty or her duty. You have argued against them all along. So they have a right to at least protest.
No, the stand perhaps should be that I have withdrawn, I have nothing against, I have maybe washed hands.
Ideal stand should have been, they should have considered to your application and the court should have allowed it.
But today,
the world does not run on ideals. So please.
Yes. All I want to show, I will cite, Milord, this. I am not, whatever I am submitting is not, Milord, out of something, Milord, I am submitting. This is backed up by, Milord,
Judgments.
Law, judgments, yes. to show that this was a strategic move,
Yes, yes, understood.
and which is proved by the fact that they have now suddenly reappeared. And in that case, the court should step in and under 151 also should transpose me, even by keeping them allowed. This is a short question. Now, my lord, on that date, when they withdrew, transposition, of course, my lord was not there. I was not there. I say I did not know. And the affidavit of service also was not there. It was portrayed to the court that I don't want to continue. I am old, and your lordship is allowed, in all fairness. Now, if a situation that happens, I am assuming the court will not have a duty. But my right to transpose perhaps was still there, your lordship is saying. Maybe the application was there. Now, if a right was there, then my lord, that right will not evaporate unless, my lord, it is evaporated by way of a rejection of a condonation of delay. But the right will remain. Now, the question, my lord, is that what happens in a situation where they in such a situation? Does it always have to be simultaneous? That when they withdraw, immediately the court will have a duty? There may be a situation where the court, will not inquire into such a situation, or a situation where the respondents will not, all fairness, will not bring it to your lordship's court. In that case, can a substantive right of transposition be wished away just because the appeal has gone? Will the appeal, my lord, not be restored in order to do substantial justice under 151? The answer, my lord, is yes, it should be. And this has happened, my lord. Decisions, my lord, your lordship knows. In execution proceedings also, my lord.
Any other state?
No, Supreme Court.
You have cited the judgment.
Everything is there, but what your lordship is saying, my lord, that I want to argue that, my lord, Order 23, Rule 1A, it is only triggered when it is withdrawn or abandoned. It is not in the process of abandoning or in the process of withdrawing. Kindly just see that, and
that may accrue after the appeal also. That's yes.
So abandonment, once it is abandoned, I come to
then you can come to know.
Only then I can come to your lordship.
Yes.
It cannot be that technical. Law cannot be technical. Logically, my lord, it does not make sense. Kindly, my lord, just see once Order 23, Rule 1A. This subsection 1A, my lord, had come in 77. Now, this under Order 1, Rule 10, your lordship recalls, my lord, I have cited judgments. Your lordship also agreed that right is there. Wide powers. You can transpose. Kindly let us go once to, my lord, Order 1, Rule 10.
Order 23, Rule 1 or 110?
Order 1, Rule 10, because this is incorporated.
Connected, yes.
Yes. The Order 1, Rule 10 was all along there.
Yes.
Here, my lord, kindly see, where a suit has been instituted in the name of the wrong person as plaintiff, or where it is doubtful whether it has been instituted in the name of the right plaintiff, the court may, at any stage of the suit, if satisfied that the suit has been instituted through a bona fide mistake and that it is necessary for the determination of the real matter in dispute, so to do, order any other person to be substituted or added as plaintiff upon such terms as the court thinks fit.
They harped upon at any stage of the suit.
So this is Order 1, Rule 10, which was already there, which requires it must be live. Order 1, Rule 10 says it's right. Today.
So you say that Order 1, Rule 10 requires the suit to be live?
Yes, at any stage of the suit.
So therefore, unless the suit is there, after the suit, it cannot be done.
No, I do not say that, because there is no law which says that after the suit it cannot be done. What we can
at any stage of the suit means that?
Any stage of the proceeding of the suit.
No. At any stage of the suit, not proceeding of the suit of the proceeding.
At any stage of the suit is at least when the suit is not abandoned or withdrawn. That provision was not there.
Till the suit is alive.
Let us read it like that.
No, we are asking you step by step.
Yes.
Because if you don't agree to that, then I'll ask you why.
Yes.
So that Order 1, Rule 10 has to apply only during pendency of the suit.
Yes. Now there was a lacuna because of this, which is why this was addressed by Order 23, Rule 1A.
Let us see that, Order 23.
when transposition of defendants as plaintiffs may be permitted. This is, my lord, came in subsequently. Where a suit is withdrawn or abandoned by a plaintiff under Rule 1 and a defendant applies to be transposed as the plaintiff under Order 1, Rule 10, the court shall, in considering such application, have due regard to the questions whether the applicant has a substantial question to
So
be
you say it's on a better footing here. You are on a better footing here because the language uses when the suit, where a suit is withdrawn.
is withdrawn.
So even after the withdrawal.
After withdrawal. And this is the lacuna which is being addressed perhaps by, my lord, the legislatures by putting in this clause. Because Order 1, Rule 10, even though it was wide, it could only be applied, my lord, at the stage of trial.
This is an excellent argument. Good. Yes.
I have...
You generally make excellent argument. I have
a
very good argument. This is a very good interpretation of Order 23 Rule 1. It's an appreciation. Nothing else. Yes. Please continue. Put your feet on the ground still. Yes.
So, my lord,
Yes, very well understood.
this is now
So this lacuna was there that in the language has been changed in 23.1.
which is described in this Delhi High Court
Sorry.
2025 decision.
Yes.
My lord, kindly takes
You had cited it.
compilation. Well, I'll have to read those judgments because Mr. Mukherjee in reply goes through each and every line and then Milord points out only the parts which
Suits him.
yes.
Yes.
So
you cite the other parts.
I'll try to show everything,
Yes.
Milord.
No, not a please.
Okay, not everything. Very well.
Yes.
Kindly, Milord, takes my compilation.
Which one?
Number 5, Roman 5.
Yes.
Here, Milord, I have in a nutshell, Milord, put in the relevant paragraph.
Nutshell. Nutshell is not. Yes. Yes.
I very well have extracted the relevant paras.
Yes. Which one?
The compilation, page 40, if your lordship takes.
40 I've got it. Yes. Which paragraph?
40 kindly takes. Just a minute, one. Yes.
The dissection. Dissection of Order 1 Rule 10.
Page 43, analysis and finding.
Yes.
The same question was there
Yes.
before the court. Whether Order 23 is in derogation of Order 1 Rule 10, whether the learned judge erred in holding order, etc. Now 26, my lord.
No, here the question was whether 23(1)(a) is in derogation of Order 1 Rule 10. Not after or before. That was not the question.
In derogation, and so if we say that Order 1 Rule 10, my lord, is applicable or incorporated in Order 23 Rule 1.
Anyway, let us see what is in our favor in this judgment.
Extracted, then, my lord.
This section starts.
25. Order 1 Rule 10.2 encapsulates the court's wide and discretionary power to add or strike out parties at any stage of the proceeding in order to enable an effective and complete adjudication of all questions involved in the suit. Provision is designed to ensure that the real and substantive controversy between the parties is adjudicated, thereby obviating multiplicity of proceedings. Scope and amplitude of Order 1 Rule 10.2 became evident upon a dissection of its constituent expressions at any stage of the proceeding. The phrase confers a continuing and pervasive authority upon the court, enabling the addition or deletion of parties not only during trial, but even after framing of issues or at the appellate stage, wherever the ends of justice so demands. Now, my lord, kindly takes 27. The foregoing analysis makes it clear that Order 1 Rule 10.2 serves as a principal source of the court's authority to add or strike out parties, the exercise of which is conditioned solely by the requirement of a complete and effective adjudication of the list. The provision vests the court with sufficient procedural discretion to ensure that all necessary and proper parties are before it, so that the real controversy is resolved in one proceeding and not left to be re-agitated through fragmented or successive suits. So this was, my lord, Order 1 Rule 10.2. Now, my lord, kindly takes paragraph 35.
33 also. This place 33.
Yes, 33. Consequently, Order 23 Rule 1A cannot be construed as a provision of general or unfettered application. Rather, it is attracted only upon the occurrence of specific contingencies, namely where the plaintiff files an application or otherwise prays for permission to withdraw the suit.
So this says, as you were saying, that it accrues only on their praying for permission,
yes,
which was done orally in court.
Not orally, by way of an application.
Or an application was filed.
Yes. which I say perhaps was not served. And
You say perhaps after the affidavit service.
no, I say upon instruction, my lord, I say.
That's why the perhaps came in, because you saw the affidavit service.
No, it wasn't served. I'll show.
Very good. Yes. So 35.
35. The text of Order 23 Rule 1A contains an express internal reference to Order 1 Rule 10.2, thereby binding the two provisions inextricably. It stipulates that upon withdrawal or abandonment of a suit, a defendant may apply to be transposed as a plaintiff under Rule 10 of Order 1. This formulation makes it clear that Order 23 Rule 1A does not create an independent or self-contained source of power for transposition. Rather, it delineates a specific contingency and mandates the exercise of the court's pre-existing power under Order 1 Rule 10.2 with due regard to the circumstances arising from such withdrawal or abandonment. So, I only come in, my lord, after they have withdrawn, whenever I get to know of it. Read in this context, a conjoint reading of the two provisions reveals Order 23 Rule 1A operates as a guiding provision for the invocation of the broader enabling power contained in Order 1 Rule 10.2. In a specific eventuality where a plaintiff seeks to withdraw a suit under Order 23 Rule 1, the court must first consider whether any defendant seeks transposition and whether a substantial question survives for adjudication. This is that part we were discussing.
From whether a substantial question onwards, it's in your favor.
In undertaking this exercise, the requirement of a substantial question under Order 23 Rule 1A necessarily falls to be assessed against the touchstone of effective and complete adjudication embodied under Order 1 Rule 10.2, thereby reinforcing that the two provisions operate in harmony and not in derogation of each other. So I want to say, my lord, here that derogation part, that if we say that Order 23 Rule 1A should also be at the stage of suit when it is live, then it will be in derogation, my lord. Otherwise, it will be rendered, my lord, meaningless. This harmonious construction also reveals a deeper second-order insight into the procedural architecture, namely its function as a safeguard against abuse of the process of court. A plaintiff, being dominus litis, possesses the initial authority to institute a suit and thereby place the subject matter in lis pendens, with the attendant consequence of restricting subsequent dealings. If such a plaintiff is thereafter permitted to withdraw the suit strategically, whether pursuant to a private settlement or in collusion with the claimants, the result could be effectively to effectively exclude or prejudice other legitimate claimants who are arrayed as defendants. This is, my lord, what my case is. It is in this backdrop that the integrated and harmonious application of Order 23 Rule 1A and Order 1 Rule 10.2 assumes significance, as it empowers the court to pierce such procedural stratagems by permitting the transposition of a defendant in whom a substantial question survives for adjudication. This ensures that the list is not defeated by tactical withdrawal, but proceeds to be just and effective determination on merits. Seen thus, even where the conditions contemplated under Order 23 Rule 1A are not strictly satisfied, for instance, where the plaintiff is not formally seeking withdrawal of the suit, but is merely failing to lead evidence, displaying procedural laxity, or acting in collusion with a defendant, the court's authority to order transposition remains unaffected. In such situations, the court continues to draw its power directly from Order 1 Rule 10.2, which constitutes the true and enduring wellspring of jurisdiction, to mold the array of parties in aid of complete and effective adjudication. Order 23 Rule 1A does not eclipse or exhaust this power. It merely functions as a specialized procedural tributary designed to guide the exercise of the court's discretion in a narrowly defined factual contingency. Properly construed, therefore, Order 23 Rule 1A supplements but does not supplant the broad enabling framework of Order 1 Rule 10.2. And then, my lord, 40 is this judgment, Dhan Sundari, my lord, which I had relied on, which says to avoid multiplicity, my lord, reliance will be placed upon the judgment rendered upon Honorable Supreme Court, wherein it has been authoritatively held that Order 1 Rule 10 expressly provides for the addition, deletion, and substitution of parties, and that the power to transpose a party from one status
Ms.
to another.
Banerjee, please come to para 46. That's squarely in your favor. Please read para 46. I've read up to that actually. That's why I've seen the previous one.
Any party whose legal rights or substantive interests may be affected by the proposed change in status has a legitimate stake in the outcome.
Next sentence is very important. Please read.
If the core test of transposition is the existence of a substantial question between the applicant, defendant, and other defendants, The latter cannot be relegated to passive observers. They must be heard in opposition where appropriate. Limiting opposition solely to the plaintiff would undermine the protective purpose of the provision and deprive other defendants of an opportunity to safeguard their right in relation to the substantial question raised. I am grateful, Vinod. And this entire judgment, I am not reading, but your Lordship will read it, my Lord. This resolves the issue that my right to be transferred only came, my Lord, after they withdrew. And there is a substantial question to be decided vis-a-vis me and the respondent number 2. And there is no conflict between me and whatever the appellants, my Lord, were seeking.
Yes.
And this is, my Lord, division bench. So, and this is also applicable in appeal. In a 10F appeal, my Lord, Order 23 Rule 1 cannot be limited to a suit in appeal. For that, my Lord, I have cited Supreme Court I've shown on the other day. Number numerical 6 in my chart. Kiran Tandon, para 4 in appeal. And here also it says, my Lord, in appeal. At paragraph 26. The scope
No
of
doubt on that.
yes,
In
yes. So
appeal,
that
it could also has equal powers.
yes. So if
Transposition power, appellate could definitely has.
yes. Now in another like so if I'm this should make me, my Lord, through, but I
Make me.
sail through the
Achha.
now, my Lord.
Yes.
See, if that is the case, that if I had a right, because I don't want to multiply. I have given an academic research that I have conducted, my Lord.
Who is interested?
I don't want to, my Lord, multiply. But today,
No, not interested any longer in academic interest, academic research. Leads nowhere.
yes. So, and Dhansundari, my Lord, I have separately, my Lord, also annexed.
Yes.
This is there. Now, there is one decision specifically on the point, page 52, if your Lordship takes.
Which are the most important decisions out of these?
Again, Kerala.
Because if I leave out, then I leave out the others.
No, I will cite.
Now, I'll pretend that I've read all, but which are the most important?
Yes, I will take your Lordship. There are very few, not too many.
So, pinpoint those.
Yes. 52.
No, which Roman numbers? Just
Now,
give me the
Roman number, my Lord, 5, numerical 2. Right cannot be defeated on the ground that the suit is not alive. Must be restored and then tried.
5 numerical 2 is 1. What
Take
else?
52 to 59, para 6 to 10.
No, just give first the which ones are the
Okay. So, my Lord, the numerical 1, 2, 3 and 3 are, my Lord, on the grounds of the scope of review. Today, my Lord, that
okay, very well, yes.
it's number 3 is very pertinent. Our Calcutta High Court overlooking a proposition of law which is well settled, my Lord.
3, very well, yes.
Yes. So today this is the case, overlooking Order 23 Rule 1 and etc. And
Multiplicity of proceedings 4, Dhansundari.
Yes. Then this is, my Lord, the Delhi High Court which I have cited. Right to transpose arises only after the suit is withdrawn.
Yes.
Then number 2 under that subclause is, my Lord, no shard. Right cannot be defeated.
Yes, this is very important. Let us see.
It takes 52. Starts at, and these decisions, my Lord, Paras will all get disposed of at the single bench stage. So it does not travel 54 minutes, para 6. The court in Ramakrishnan has held that the plaintiff has a right to abandon his suit at any stage, but if there are substantial questions to be decided in the suit, the court definitely has the power to allow transposition so that the suit can be pursued, and further, that abandonment can be either through positive submission or through silence leading to lapse. If one allows his suit to go for default, that will be abandonment by silence. It is also open to him to abandon the suit by making direct request to the court after due appearance. By stating not pressed in the instant case, what the plaintiffs have achieved is actually abandonment of the suit. In such a situation, Order 23 Rule 1A would certainly apply. It also further held that even if Order 23 Rule 1A does not apply, the suit would be restored if it is essential for enabling the petitioner to realize or effectuate his rights under Order 23 Rule 1A of CPC, and his right cannot be defeated by stating that the suit is no more alive. Whether the suit is alive or not, if the suit has to be allowed to be proceeded with as contemplated in Order 23 Rule 1A, and if the process of restoration is essential, therefore the court has the power to order such restoration even under 151. It would be profitable to refer to paragraphs 4 and 6 of the judgment in Ramakrishnan. So only that part, and then it follows. And then para 7. Technically speaking, an application under Order 9 Rule 9 of the CPC can be filed only by a plaintiff, but here is a case where the suit is one for partition, and in that sense, even the sixth defendant is in the position of a plaintiff. That apart, even if Order 9 Rule 9 of CPC does not apply, the suit can definitely be restored if it becomes essential for enabling the petitioners to realize or effectuate their rights under Order 23 Rule 1A of the CPC. His right cannot be defeated by stating that the suit is no more alive. Whether the suit is alive or not, if the suit has to be allowed to be proceeded with as contemplated under Order 20 Rule 1A, and if the process of restoration is essential, therefore, the court has power to order such restoration even under Section 151 of CPC. His right under the provision cannot be defeated to technical contentions. And then quickly the next paragraph, 8. Further, this court has held in the decision of KK.
6 and 10 are the best paragraphs in your favor. 7 is more on 9, Order 9 Rule 9,
Yes.
but it also says that restoration even under 151.
151. Perhaps 8 also. 8 relies on that judgment on which I cited on the first day. KK Abram, Kerala, that the application filed by the respondent for transposing himself in an appellant as an appellant cannot be rejected on the mere ground that the application was filed in an appeal and not in a suit, since the provision of Order 23 Rule 1A read with Order 1 will apply to a proceeding.
Yes, that's on a different proposition.
Respondent in appeal. Yes.
Very good. Yes.
Now, so this covers the live issue in addition to what Delhi is trying to say. Then, Milord, 6 are decisions that, Milord, it is available in appeal. Numerical 6. Which your Lordship, Milord, at least to that extent is with me that it is permissible. Now, this Shoilowala Dasi, Milord, is an old Supreme Court where, Milord, the appellants were brought on record as additional appellants since original appellant dropped the fight with the respondent, and when court, Milord, suo moto under Order 1 Rule 10 and read with 151, Milord, allowed. So this was also an instant where your Lordship has held in the impugned order that only when an order is passed, rights have accrued. So despite no order being passed, giving me a right, receiver appointment, etc., matrimonial, there are other instances where, Milord, this...
No, before it is withdrawn, it can be done. When it is alive, it can definitely be done. But there has to be some trigger for that. For the There was no trigger before the court to transpose you. You never asked for transposition. There was no...
Yes.
Nothing. Your right only accrued after, as per your argument also, when they withdrew. Till then, you were safe under the belief that they would be espousing whatever similar grounds.
Similar grounds, and Order 41 Rule 4 that anyone, your Lordship, can, Milord, ask to argue.
Yes.
Then, Milord, next is this I would like to cite, Milord, shortly.
Which one?
Bhuvaneshwar versus Siddheshwar, page 84. This is a part of it, page 960 and 961. And this ultimately traveled to Supreme Court. This was not disturbed. On merits, Milord, they lost. Order 41, Rule 4. Where a minor's rights were being represented by the father. Father could not withdraw.
No, that's different. That's different. If the minor is represented by a next friend, if the next friend seeks to withdraw, definitely court should, appoint a next friend, another next friend, or look into it at least.
Yes.
That's on a different footing. You are not a minor.
Not a minor, but my rights flow from the minor. Page 87, Milord, just quickly, Order 41, Rule 4. 87, Milord?
Yes.
Somewhere in the middle, just before page 961. Order 41 rule, because I specifically relied on this rule. Order 41 rule for CPC fully empowers an appellate court to reverse or vary the decree in favor of all the plaintiffs or defendants as the case may be, irrespective of the fact that the appeal is preferred only by one of the plaintiffs or one of the defendants. If the decree appeal from proceeds or any ground common to all the plaintiffs or all the defendants. So this is my case, my lord. Only one person can appeal, and if it is common to all, my lord, I have a right to argue. Then Order 41 Rule 33 CPC authorizes the appellate court to pass any decree and to make any order which ought to have been passed or made, and this power may be exercised by the court, notwithstanding that the appeal is as to the part only of the decree and may be exercised in favor of all or any of the respondents or parties. Although such respondents and parties.
Ms. Banerjee, in principle, since you are also aggrieved with the order, your right to get transposed in principle is cannot be disputed. Definitely you had a right. But the primary question is at what stage? Whether after the appeal and after at the restoration stage, whether it can be done. So for that, Kerala is a good judgment. Delhi judgment insinuates something in your favor also. And general tenor of these judgments is that yes, court has to look into it. So which is very important. And Delhi High Court para 10 says court has to in a mandatory tone.
Especially if it is strategic.
Substantive right. The substantive right part.
Yes. And
strategically also, yes. That word is used also.
Now, my lord, that first Kerala I showed, number 7. KK Abram 122 to 125. This is the first judgment I showed. This is exactly on a 10F.
Yes.
122. This, my lord, I would say the entire decision 3 to 13 is relevant. We have, my lord, gone through this. This was specific case, my lord, where 10F appeal was withdrawn.
Let's see the judgment once.
This was the first judgment. Para 3. May I, my lord, place here. Subsequent to the dismissal of the appeal as withdrawn as aforesaid, the petitioner herein filed an application under Order 23, Rule 1A of CPC seeking to transpose himself. So this is a subsequent situation. As the appellant in the said appeal and seeking permission to continue the proceedings. On 25th January 2000, the said application was dismissed on the ground that the application for restoration filed by him has already been dismissed. In other words, after dismissing the application for restoration, the court has passed an order on the application for transposition also. No revision is filed against the order dismissing the application for restoration. So here the restoration was dismissed. It was not live. Heard both sides. According to the learned counsel for the petitioner under Order 23 Rule 1A read with Order 1 Rule 10 of CPC, a defendant or a respondent as the case may be is entitled to file an application for transposition for transposing himself as the plaintiff or the appellant as the case may be, even after dismissal of the proceedings, whether it be an appeal or suit. Then Order 23 Rule 1A is quoted. Revision petitioner contends that the right to file an application for transposition arises either when the plaintiff abandons the suit or when the suit is withdrawn. According to him, even after withdrawing the suit, the section contemplates and permits transposition of the defendant as a plaintiff. He also relies on the decision reported in Ramakrishnan in support of his contention. Same judgment Milord Naushad had relied on. On the other hand, the learned counsel appearing for the respondent submits that the provision contained in Order 23 Rule 1 read with Order 1 Rule 10 CPC applies only to a suit and it only gives right to the defendant to be transferred.
And 9 onwards is the specific answer to the question.
Yes, I was just reading. Nine to 13, my lord, everything.
Yes.
And kindly once, my lord, notes para 7. Another judgment Govinda is pointed out here, where 107 was invoked. May I just quickly read 7? even though Order 23 Rule 1A, Order 1, Rule 10 refers to the expression suit and the plaintiff.
No, 107 is applicable. Yes.
Yes.
Correct.
This Govinda IR.
No dispute on that.
107. I'm not.
107 applies the same powers to the appeal court.
So that is also then my
that is
argument.
that is not in question.
Yes.
Para 10 specifically says that it can be done after.
Yes. Then, so Govinda, my lord, I am not separately citing, even though I have it here. Then, my lord, then I have given just, I will completely ignore 9 because this becomes irrelevant now. But 8, I have given few instances of cases where, my lord, transposition was allowed. This were first one, Basudev Lahiri, propounder of a will was disallowed to withdraw as the same would defeat the interest of the legatees who should be transposed, having recourse to Order 23 Rule 1A, read with Order 1 Rule 10. Then Gujarat High, that is our, this is Jharkhand. In a partnership where the defendant has interest identical to the plaintiff has a right to be transposed. In our case, the company structure is akin to a partnership, and so the applicant has a right.
You're not a part of the same company.
I am.
Not their company. Shareholder, yes.
I'm the.
Your purchase share. Very. This is also important.
Yes. So, Milord, may I show these or I'll just. Then next one, Milord, is in a proceeding in the nature of a representative capacity. It is not open to the plaintiff to end the litigation by withdrawing the suit. He may go out, but that does not put an end to litigation when others are interested in it and have a right to come in and continue the litigation. Even if Order 1 Rule 10 is not applicable, it was open to the court to transport when they ought to have been transposed, or else valuable rights will be lost. Then there is a Calcutta which says right of withdrawal is not absolute when defendant has cause of action against the plaintiff, in which case transposition should be allowed. Kindly, I'll just want to formally just place this 153.
When the defendant has cause of action against the plaintiff, did you have it? When the defendant has cause of action against the other defendants, that would be relevant.
Should be other. Maybe I have miswritten it. May I just check once more? Yes, it is. Yeah, that is incorrectly written. Page 159. But I am really not challenging whether that day they should have been allowed to be withdrawn or not. Maybe even if they were allowed, so I have a right to be transposed. In our view, where an application has been made under Order 23 Rule 1, the plaintiff.
Para 13 is the precise proposition which I was telling you. Para 13 says, in our view, when an application is made under 23(1), plaintiff is entitled to withdraw his suit and the defendants cannot be heard to oppose such prayer. But the said legal right of plaintiffs to withdraw the suit is not unconditional or absolute. The court can only exercise its jurisdiction in favor of the plaintiffs where the interests of the defendants are not adversely affected in any way if the plaintiffs are allowed to withdraw the suit. To illustrate, in a partition suit by a sole plaintiff against defendants, former cannot. Partition suit both are in the footing of a plaintiff. So that's why it's a different proposition.
No, not
and there are other judgments also which say in a matrimonial.
They're not so different now because it's a quasi-partnership structure.
All right.
Which is why this becomes relevant.
All right.
And this part where we are therefore satisfied where an application has been made under Order 20, court cannot compel them to come. So today, Milord, now that they have come filing Wakalatnama, kindly seize this, Milord. The last few portion.
Yes, we are.
We are therefore satisfied that where an application simpliciter has been made under Order 23 Rule 1, court cannot compel the plaintiff to proceed with the suit and the defendants cannot be allowed to.
This is very important, in fact.
Yes, but where there is an affinity or identity of interest between the plaintiffs and one or more of the defendants, The plaintiffs cannot be allowed to withdraw if an application on behalf of such defendants have an interest in the suit
Read that portion softly.
is made.
If an application is made.
Yes.
Read that softly so that I can't hear.
If an application.
No application was made by you.
Have an interest. So on that date, my lord.
If an application is made, definitely. If an application is made, how can the court say no?
Yes.
The defendant sails on the same footing as the plaintiff in respect of a certain cause of action? Yes. Then if you make an application and the court refuses, you have got a very good right to go up in appeal also. Or review or whatever you choose.
Yes.
Two factors go against you in this case, for which you have cited several judgments also. One is that there was no application by you at that point of time. Secondly, whether you can come subsequently and file such an make such a prayer. So you have addressed both issues by citing several Kerala and Delhi High Court also to say that if substantive rights are affected, court should. And there you have why I said that it's a very good argument 23-1 because that sets the tone of your argument by saying that Order 1 Rule 10 has had this lacuna. We may use softer expressions, may not have been a lacuna in Order 1 Rule 10 as such, but what was missed out was put into Order 23 Rule 1 in 1977 by specifically saying, but Delhi High Courts dilute that a bit by saying that the fundamental power comes from Order 1 Rule 10 and Order 23 is a subset as if. So that dilutes your proposition that no, 23 was brought in to rectify what was not there.
But has not rectified.
Yes, yes, it says that Order 1 Rule 10 is the mother, the parent provision from which power is derived, and 23 is a subsection. But even without going into that finding of the Delhi High Court, otherwise also, this is a very arguable case as to whether, yes, if a substantive right is there, that part appeals to me. That substantive right is there, then court should hear the other side.
Sure.
Here they have put in an affidavit of service also.
Now we are on review. I will answer that. Now we are on review of the impugned order.
Very well. Yes.
Kindly let us go to that order in view of the legal propositions that, my lord, we have just discussed.
Right.
Now, scope of review, my lord, is that I have to show error apparent without delving into too much analysis of. Can be a factual error, can be legal error. Now, just kindly, my lord, takes page 2. This is my argument. However, subsequently, without any notice or service of the copy of the withdrawal application on the present respondents, the said appeal was withdrawn beyond the back of the respondents, thereby seriously prejudicing the rights of the applicant. So my rights were prejudiced, my lord, was brought to your lordship notice. It is further argued that even in the capacity of respondents, the applicants had a right to address this court on the order impugned in the appeal, which has been taken away by the order permitting the appellant to withdraw the appeal. This, my lord, is Order 23 Rule 1A. Now, learned counsel appearing for respondent number 2 seeks to argue that by an order of 24th August 2016, a copy of which is annexed to the present petition. Now, I have only disclosed this order.
Without the commentary.
Achha, oh, sorry.
First, then you are.
Sorry.
Yes.
A copy of which is annexed to the present application. A coordinate bench had observed that learned counsel appearing on behalf of the respondent number 7, 9 and 10, although supports the findings of the company law board, but however has objected to a fresh valuation being made. As such, it is contended that the present applicants had supported the order.
This was their argument on Justice Chen's that.
Yes. However, learned counsel for the applicant vehemently deny the same and seek to place the factual background. Now, however, this court need not, while hearing the present recall application, enter into the factual aspects of the case. May I just pause and make one comment here?
Yes.
So, today we are on review on this order, where there is no decision on the purport of that order of Justice Sen. It clearly, on the contrary, says that I am not entering into what was the purport of that order, whether I wanted to withdraw or whether it meant that I have any right or not, my lord. It does not. So today,
it was in answer to your argument. it's recorded that learned counsel for the applicants vehemently deny the same and seek to place the factual background of the case, to which the court said no.
Yes, and does not decide anything.
Before that, whatever arguments were made is not touched by that.
So those are
Actual
arguments.
background we are not looking, but
No.
this is anyway. Let us continue.
While hearing the present recall and not entering into the factual aspects of the case, it is well settled that under the principle of Order 23, Rule 1, any appellant can at any point of time withdraw the appeal filed by them without liberty to sue afresh. However, the said proposition is diluted when a leave is sought to file a further appeal on the self-same cause of action, which is not the present case. Courts have made a distinction in cases where some order has been passed in the pending.
In line with that Calcutta High Court.
Yes.
Vested rights have been created, so in that case we don't permit withdrawal.
Which
Without
confers certain continuing and or vested. This is one instance that your lordship is quoting. Courts have also made a distinction in cases where some order has been passed in the pending appeal, which is sought to be withdrawn, which confers certain continuing or vested rights on the respondents or other parties on the appeal. In such cases, on occasions, courts have stopped short of permitting the withdrawal of the appeal without ensuring that the rights accrued in favor of the respondents are properly taken care of. However, the mere argument that the present applicants who were respondents in the appeal attempted to piggyback on the appellants cannot be accepted. Present applicants are not naive people coming from remote rural parts of the country, but are literate, educated people having commercial knowledge. As such, the contention of the applicants cannot be taken note of for recall of the order of withdrawal of appeal without leave to sue afresh. In any event, if the present applicants were aggrieved by the order impugned in the appeal, they could prefer independent appeals against the same. Having not done so, this court does not find any vested right of the present applicants having taken away by virtue of the order whereby the appeal was permitted.
Ms. Banerjee, this piggyback comment was made in the light of your submission as recorded in the second paragraph. Learned counsel appearing, very second paragraph of the order. Learned counsel appearing for the present applicant submit that although they were arrayed as respondents in the said appeal, which you also say today, an impression was given by the appellants therein that the appellants would espouse the cause of the respondents as well in the appeal, inasmuch as the respondents were also aggrieved with the order impugned in the appeal.
Yes.
So you are under that impression that they are espousing your cause, so
Yes.
you can sit secure in that belief.
Kindly takes my application, yes, which is a fact because the appeal was filed, my lord. We did not choose to file an independent appeal because this eventuality was not predicted they will withdraw. Now that they have withdrawn, my lord, my right gets triggered.
Right.
Just kindly takes once my application which was there before your lordship. My recall application, page 45. Dry out হয়ে যাচ্ছে appeal stay petition. This is my
GA.
DA.
Yes.
The strategic withdrawal was my case. Para 13. Para 11. An appeal was preferred from the aforesaid order by the appellants herein in whose favor the 20,000 shares were initially allotted under the rights issue. Such an appeal preferred by the appellants took care of the interest of the subsequent allottee, respond number 9, salty. So my case at para 11 is, leaving aside the other part.
No, read the next sentence.
I will. I'm just saying that first.
It's a continuous thing.
Such an appeal preferred took care of the interest. Under such assurances, neither respond number 9 nor respond
Under such assurances, you are under the impression that appellants took care of the interest of your interest, not stopping there. You say under such assurances, neither 9 nor 10 separately preferred an appeal. So you are assured by them that they were taking care of your interest, but there is nothing on record to show anything of that sort.
So I say, my lord, in purpose of respect, the filing of the appeal, the tenor of the appeal, where they are saying that this order of CLB should be set aside.
You don't say that. You don't say. You could have said here also that the grounds of challenge by them were their grounds were similar to your grounds of grievances, or your grievances were similar to theirs, or something of that sort. You have not said that the grievances were similar, or you are standing even on the same footing. Not something of that sort.
That is an error on the part.
Said appellants took care of the interest of the subsequentality. Under such assurances, you did not prefer an appeal. So that was your reason for not preferring, not questioning the order, separately preferring an appeal. So that is a
That played with your lordship. Now, if that is a mistake on the part of the council which caused this error,
their council committing mistakes, your council committing
that is also, my lord, revisable under review. I have cited those.
so many errors cannot be revised with it. Court is also entitled to make its errors then.
May I
Won't
just
review.
read this once?
2 errors cancel out. Court won't
Yeah, kindly see once. Such, but
everything cannot be brushed aside as an error.
I'm not saying that. I'm
Categorical admission on your in your application on oath. It's your client is affirming this. Again, see para 14. This was relied on by them. That's why
I am
marked.
para 11 first, third line, fourth
11
line.
I have read thrice.
Such an appeal preferred took care of the interest.
Then
And then that assurance, yes. Under such assurances, neither respondent.
again you repeat that in para 14. Appellants had assured that the respondent number 9 that there is excellent chance of success in the appeal.
In fact, since the applicant had purchased the 10,000 shares for an amount of 80 lakhs and subsequently purchased 3,300 shares for an amount.
That's again
from
para
the
15 also.
Respondent number 9 has been in control to the extent of the shares. No separate appeal was preferred by respondent number 9 and 10 as because the interest of the respondent number 9 and 10 were being taken care of and or advanced by the appellant by challenging the order dated 26 May 2016. So the filing of the appeal itself plus the assurance 15, my lord, kindly sees 15. I did not file an appeal because the fact that this appeal is filed and I have a right to argue, my lord, would have resolved my issue. I need not have, my lord, filed a separate appeal to avoid multiplicity. Then the respondent number 9 was being represented through an advocate who was then conducting the matter as evident from this order. Then 17, in a clandestine manner, the repellents without informing the applicant withdraw the appeal. Now, this is that Delhi, my lord, this strategic withdrawal. Appeal filed, the fact that this appeal is on record for 10 years.
Yes.
Fact that the appeal is there for 10 years, asking for, my lord, setting aside of the CLB order, my lord, itself would take care of my interest. And they made me a party. It is their appeal where I am party. That itself goes to show that there is an assurance. They did not file an appeal without making me a party.
Does not show there is an assurance at all.
Very well.
Obviously not. You are the point owners. You had to be made party. We are coming back. Yes.
But I was on that recall application.
Right.
Just few more paragraphs. So page 55, Milord.
55. Yes.
17, Milord, I say that they surreptitiously withdrawn. Now, how I'm prejudiced, Milord, I'm showing here. 18, by virtue of such withdrawal, the applicant has been rendered remedialess inasmuch as the applicant was informed by the appellant that they have settled the matter with the respondent number 2, who is willing to exit from the company by accepting the valuation of Salapuria without pursuing her challenge to the 20,000 rights issue. No copy of the fresh valuation allegedly done was shared with the applicant. Applicant had no idea that the appellants were hand in glove with the respondent number 2 and would withdraw the appeal to the detriment of the applicant and allow the impugned order to remain unchallenged. The applicant herein was shocked and surprised to receive a company petition for cancellation or deleting or setting aside the 20,000 shares in the name of the respondent number 9
In
and
para
10.
18, you say that the applicant was informed by the appellant that they have settled the matter. So, but why did you wait for that company petition then? Para 19.
No, so the appeal was in limbo for a long time. And they are saying their
So
proceedings.
when you came to know that they had settled the matter, why didn't you file the transposition then?
No, they told me that they had settled the matter, but that was a wrong representation, which I came to know because they filed a company petition before the NCLT.
So they had settled the matter with respondent number 2.
Yes. So they said that respondent number 2, there is nothing in the appeal. We are trying to settle with the respondent.
So at that point of time, in para 18, at that juncture, why didn't you come up with a transposition application?
That time it was not withdrawn.
That is precisely what we are saying, because it can be done before it is withdrawn.
So if they settle and she goes out, then there is nothing to be transposed.
When you came to know that they have settled the matter, and they have settled the matter with the, immediately you should have come up with a transposition
Settle the
application.
matter for what? Kindly see. Settle the matter so that respondent number 2 takes her shares and go out, which was a stand from the very beginning to 2013.
Achha.
That portion, that she's saying now she doesn't want to fight anymore. She's willing to walk out. This is the impression they were given.
Right.
Why the appeal is kept pending for so long. Then, Milord, I was shocked and surprised to receive a company petition under section 59 praying for cancellation and or deleting and or setting aside of the 20,000 shares lying in the name of 9 and 10. So when I got this company...
When did you receive this? It have not stated.
Yes, it is stated. This was...
Right. Not stated in this paragraph.
I have stated in para 27.
Very.
I have received in January 2025. I received this,
right,
where what they try to do is in that appeal, they say that now that it is withdrawn, there is no embargo. We are now asking for modification of the register of the company so that the shares are gone. Now, the purport of that is, Milord, I go out of the company after having invested in the company. And then immediately thereafter, I took steps. And Milord, I have explained the delay. And the reason I am showing this, Milord, is to show that there was a strategic withdrawal. And the reason for this withdrawal is to file the company petition. That company petition, your lordship, before the NCLT, which your lordship, Milord, will find page 90. September they withdraw and then they file this. Kindly takes page 114, the prayer portion. 114.
16.
106 first.
Achha. Yes.
This is their averment. The respondent number 1 at all material times was and until the time mentioned run on the principles of quasi-partnership and with the principles of partnership being applied. So this is Milord an admitted position. This is their petition. Now 114.
This was before you came in.
This
The
is
three brothers were director and respondent 1 being the eldest brother was the managing director.
no. So I step in.
You're neither the brother nor the sister.
I'm
This quasi-partnership is in the context of the paragraph. You have to see that.
always run in the principles of a quasi-partnership.
At all material times.
Yes. Which is under challenge, my lord. If
Until the time mentioned hereinafter. The respondent one was at all material times and until the time mentioned hereinafter run on the principles of quasi-partnership. Brothers were directors, etc., etc. Then this happened. 800, 2500. That was it. It was at that point of time.
they don't say on
General, the principle of this partnership concept by virtue of the judgments also comes in, that you have argued.
Yes, I have. 114, para 28. Since the appeal now stands withdrawn, there exists no embargo to have the order dated 26 May 2016 being given effect to by making the aforesaid rectifications to the registrar, books and accounts. After withdrawal of the appeal from the High Court, the applicant caused her advocate to issue a letter of 18 November to the respondent number 1. Respondent number 1 is Daga, the company, which is not the owner of the petrol pump, calling upon the respondent to make the aforesaid rectification. However, the respondent number 1 and 5 have caused their advocate to respond to the letter, making various answers.
Company petition was, let us once see the reliefs and then welcome.
Yes. I am showing this because they are willing, they have now given me a compilation saying they want to rely on certain letters. There is perhaps no reason, whatever is there in the Daga had replied. Reliefs are 116. Order.
That prayer.
Yes. Order squashing, cancelling of the 20,000. The only reason, this is what gives me an additional right to come with your lordship. So had it just been withdrawn, had the respondent number 2 walked out taking her money, I would not have come to court. But the fact that, my lord, now they are trying to throw me out.
It at the root of your title.
Yes, in this manner, which is what, my lord, I am seeking justice with your lordship today. You kindly transpose me because this is the reason why they have done this. Now, from the appeal also, your lordship will...
Why didn't you prefer an independent appeal instead of going to all this trouble?
For 10 years, my lord, they've this...
With the section 5, there will be a fantastic justification. This would be the justification. It was under challenge. Your cause of action would have arisen only when the appeal was withdrawn after that. Just take out an appeal with the application. What this is not multiplicity. You file an application for restoration with transposition, then a review application for that restoration. The review, if that is whatever way that goes, that will again give rise to a challenge. This is not multiplicity. Wouldn't it be much better if you preferred an independent appeal? You wouldn't be dependent on their mercy or for that matter the discretion of the court. Your own appeal, section 5, leave 1 minute affair. Section 5 would be a very good section 5. After doing all this, if you do that, you know what they'll say. The first sentence is Mugawati will stand up and with his sweet face say that, see, they've done this, lost everywhere, and then come up.
This sweet face is actually going against.
No. You are also very sweet. But your sweetness, either of your sweetness cannot transcend into the outcome of this matter.
If that course may be available, but does not mean that subject to correction that this course is not available.
No, not that. Right.
So now, so Milord, there I have shown one thing I want to say, Milord, this 10F appeal, if your lordship sees, your lordship has it.
Yes.
The company was going through a miserable time. When I stepped in, I infused money. The 2 petrol pumps were drying out. I helped them. Now that they are doing well, Milord, they are basically trying to, Milord, throw me out in this manner. This is again that strategic part. This, I don't want to, Milord, read the entire part of the appeal, but I started off with this, para 16. This appeal, when it kindly takes once, the 10F appeal, this was filed in 2016. Para 16. The company faced acute financial crisis on account of the following. Kindly see subclause E. One of the reason is the sudden withdrawal of the respondent number 2 of the loan capital of 32 lakhs. This is respondent number 2. Left the company in dire strain. In fact, it would have resulted in substantial loss to the company if immediately further funds were not made available. The same would also appear from the increase in price of petroleum as disclosed. Then 17. The appellant 1 and 3 had deposited 50 lakh and 30 lakh respectively towards the loan capital. For want of further infusion, the company was running the risk of dryouts in the petrol pump. Such dryouts would have resulted in immediate erosion of profitability and loss of regular clients. It was in these rather unfortunate circumstances and to maintain desirable debt equity ratio that the appellants 1 and 3, being directors of the company, decided a further infusion of funds by
I'm
issuing.
not going to that details in this.
Yes, I don't need to.
Going to-
The reason I'm showing this is that appeal was these things that were said here, and para 20 that I have,
Yes.
I am the buyer. Appellant said that such value, but the respondent 17 being the buyers. This is about me. So if the appeal was decided,
Yes.
then that would serve my purpose without me having to file an independent appeal.
Hmm.
The grounds taken therein.
Obviously, if that was set aside, then you would get.
Yes, and I had a right to, my lord, argue, which is now sought to be taken away, my lord, in this manner, which is why, my lord, I seek your lordship's
Very good.
intervention. And that Calcutta, my lord, para 13 is there, but 14, my lord, the transposition is allowed. Immediately the next paragraph.
Saw that.
Yes.
Well, I understand. I mean, reply to a reply because this was a reply submission.
Yes, but judgments have been set.
Of course, of course.
Yes,
Well, I'll deal with that. I'll just indicate my points in brief, Malo, the entire substratum of Ms. Banerjee's argument.
Sorry.
Yes.
And I have not addressed your lordship on that service because, my lord,
Address me.
because we are today in review. But just to say that the address that is mentioned here.
No, I've entertained this affidavit of service to be filed by them only because I had not directed affidavits to be filed in connection with the restoration application. At the outset, I had dismissed it without inviting affidavits. So therefore, since you are also in this review, also you are pressing that point that you are not given a notice. That's why I took that affidavit of service, and I have taken it only because it was contemporaneous. Subsequent document, definitely I won't be taking. So yes, what is your?
Yes. One more to the final one. Will not kindly see page 7. Post title address title. This address that is written here. Cost title to that. No.
7, 16
Kindly
and
see
20.
the cost title, my address. Salty, number 9, page 3. Salty having his registered officer AE 40, sector 1, Salt Lake, Kolkata 64. Now this is a shareholder. Your lordship knows, my lord, the separate juristic entity, my lord, notices have to be separately issued.
Salty is the shareholder.
Yes. Salty, Parimala, both shareholders. They are
You are representing which? Salty.
Salty. Now,
Salty, page 7, Salty was not served.
Salty
Is the second one.
but kindly see the address.
Vidhanagar CC block.
This address
CD block something. CC block.
CC block SO.
But cost
Right.
title
And the cost title address
AE
is
block.
AE 40.
All right.
Now, and there is no letter addressed to Salty. There are some annexures here, page
So
29.
probably these are references to something else, the post office or something. Because you see the other addresses also. No.
Yes, but this cannot be construed as service to me simpliciter from what we are now today at this
Address
stage.
is not matching. First of all, the
First address is not matching. Number 2, there is no letter. Kindly see the 2 letters given, page 29 and 30. This is to Atish Ghosh and Associates by Potit Pawan Bishwal. So Potit Pawan Bishwal, I believe, is the appellant's advocate on record, writing to the respondent number 2's advocate on record. The next letter is again them to
This was your advocate.
No, not mine. This
June
is
Alfin was not your advocate.
no. Must be Daga.
Was
And kindly see the
June
endorsement.
Alfin was
That's also
appearing for you
mentioned in-
before Justice Showman.
Oh, kindly see the endorsement. So kindly see the endorsement. I have no contact with the client anymore. Please send directly to the client.
And they send directly to you also.
So there is no
As
cover.
per their
As per what? As per that postal receipt, which does not match with my address, and there is no covering letter to show that a letter was issued in the similar nature that was sent, which is in page 2930. So to read from this postal receipt that I was served, along with that, there's a tracking report also, that it was actually in fact served to me at my address, would be perhaps in my humble submission too far-fetched. Yes, there's a tracking report, but address is not mine. 7919, which is page 16. bolchi. Now there is usually a letter, my lord, when we post, I have taken instructions, you put the address down. Proper address so that you know where the letter is going. And there must be some evidence that it was sent to AE block, sector AE 40, sector 1, Salt Lake. There is no document before your lordship today to show that it actually went to AE 40, sector 1, Kolkata. So therefore we cannot construe this was service. This is number one. Number two, my lord, this was, kindly see 16, assuming, but not admitting. This was in May 2024. Assuming. The order passed by your lordship is in September 2024. June, July, August, September. Now, it is established, my lord, your lordship is with me, that there is a right of transposition. Now, assuming, my lord, the advocates don't appear on that day, or I have no notice, and I have made that statement in my recall application also. It cannot, my lord, just go away just because I don't appear on one day, even if I had notice. Kindly see my
might not have had notice of the mention of the matter being mentioned or included.
that date. So many things can happen.
Although it's construed generally that publication in the list is notice enough. You ought to have been careful. But maybe yes, practically speaking, yes. After 4 months, you might not have been.
As that is also assuming I had notice.
Yes.
Kindly see that averment I have made. I have said that. Yes, para 27, page 58. 26. Since the appellants were conducting the appeal, which would ultimately serve the interest of the applicant herein, the applicant did not engage any advocate to conduct the appeal on the day-to-day basis. However, since the applicant was not aware of the withdrawal application or any intimation with respect to specific instruction for hearing thereof to be held on 26 September 2024, no one appeared on its behalf and the matter.
But in the postal receipt, if you see, Ms. Banerjee, all the addresses appear like this. The post office address is given. In all these postal receipts, all of these.
Now,
None of these, the entire full address is shown.
May I don't want to interfere. I'm
So
really
you,
sorry.
in your reply, you will say, yes.
কি বলছো দাঁড়াও
বলছি যে সিসি ব্লকে কেন পাঠাবে তো এই ব্লকে why is CC mentioned here দেখো
সেটা তো বলেছি একটা পয়েন্ট
ওইটাই তো দেখো
now my lord, kindly see the first one. Anisha Daga, annexure A, page 6.
Yes.
Kindly see her address.
All are SOs.
No, Altamount, Mumbai.
Pin code is given, then Kambala Hill, SO. Next one is also SO. SO is there, postal. Something office.
It's been received. It has not been delivered to me.
All of these.
So, Billard, perhaps it had gone to the post office. If there is no.
So the difficulty is it could have been said so, but item delivered only may be construed as to the post office. But within bracket address is also there. Page 16.
Page 16.
Page 16 within bracket item delivered. After that, within parentheses, it's written addressee. That makes it clear that the addressee received. If it is only item delivered, then we could constitute still that the local post office, it went up to the post office.
My instructions are still there, that salty infrastructure, but the address is nowhere there. Address.
None of these, the address is, the full address is there.
And there is no service shown on the others also, which makes it further clear.
Taga receipt is at page 23, that was pointed out.
তাকেই ব্র্যাকেটে অ্যাড্রেসই বলেই রিসিভ করবে, সেটা তো সল্টিকেই হতে হবে তার কোনো মানে।
Daga Milord was sent to Patit Pawan, Patit Pawan to Daga, sorry.
Patit Pawan appears in all names.
Yeah.
He's the most famous of these. What are you doing surreptitiously?
I'm trying to locate more of the affidavit of service filed in this review application. That might elucidate. I can show, I'm fairly certain, but I don't have a copy of it, so I want to have a look if Muller will kindly.
This is like a Milord fishing expedition now. I really cannot do much about this. This is my submission.
What about your service of this copy to them? Where is your affidavit of service?
Oh.
Never filed it.
Another affidavit of
So
service.
Mukherjee wants a clue from that.
Yes.
He's giving the reason also, so it's open.
File করোনি?
No.
Luckily there are no postal this. ও আছে, দেখি
কৌতূহল হয়ে গেছে। Yes.
আছে,
Don't with the rider that you cannot jump up. Manual doesn't help you. Yes, Ms. Banerjee, carry on. What else?
So there, that goes.
Therefore, the address is not shown anywhere.
Address not shown, I am not served. Para 58, I have said that, Milord, I was not conducting the matter on a day-to-day basis by page 58 once, para 26.
You did not engage an advocate for conducting day-to-day basis.
So that on that.
There's no such concept under the code.
No. Correct, yeah. Correct. After 4 months on that day.
This concept you have introduced. There is no such concept. Once you give wakalatnama power to somebody, has power until another.
These days, Milord.
Day-to-day,
money.
Day-to-day fees, watching fees.
These days,
alien concepts.
For arbitration, they'll tell you to appear one day, next day, no. And but anyway, I am not.
Just forget that. Yes.
Now, so Milord, no address. And even if
no address, primarily no address.
Yes.
Everything else follows because.
And even if I had, Milord, if I don't appear on a particular
May and September, that is also another.
That is on another September. I was not aware that thing. And therefore, Milord, my right to be transposed, Milord, cannot go away. And the review decisions I have not today cited, but last day, Milord, I pointed out 1, 2, 3 that if ignorance of law, if some order is passed, Milord, then that cannot be allowed to continue to avoid failure of justice. That's
first things first, Milord.
Note, short.
What about this affidavit of service? Give it back.
I want to rely upon it. I just open the page.
Then give it back. Don't forget to put it up.
Of course.
No, now keep it with you. If you want to rely, then
I'll
rely
indicate from there. I've taken inspection. I've seen.
I have a short note, if I may.
Notes of arguments?
Yes. Short.
Will you kindly grant me time also? I'll file a short note on the next date. Milord, we'll definitely file.
Definitely. This contains all that you have argued.
Yes.
Yes.
First things first, service, Milord. Service. I'll keep it very brief, Milord. The two judgments which seem to be hurting me, Milord, I'll deal with first, and I'll show how they are also supporting my case, especially Delhi, Milord. First things first, service, because that is at the conscience of the court. If Milord is minded to review the order and recall the order of dismissal on the ground that it was done behind their back, Milord has inherent jurisdiction to do that. I am the last person to say that Milord won't. But fact remains, they were served. I'll indicate two things. First, contention as to the affidavit of service. Page, if Milord kindly takes the postal receipts issued by the India Post only indicate the post office address. The booking, the address mentioned in the booking before the India Post is always in the correct form, my lord. And that is substantiated by the tracking report. Tracking report,
You have not annexed any covering letter for them.
that is there annexed in their own application. In their own application, Daga Auto, the covering letter I've shown, page 121. The covering letter is not there in the affidavit of service, my lord, but I'll indicate.
No,
Today,
in their application, what is there?
in their application, the review application, page 121, I've shown the covering letter. I had made arguments on that, my lord. I was
No,
not
that is
arguing
not
on the
salty.
affidavit of service. I'll indicate
That's
that.
Daga.
I'll
Daga,
indicate
yes.
that. I'll indicate that as well. That they
Yes.
are one and the same, I'll indicate that as well. But page 6 of the affidavit of service shows, my lord, the correct postal address, or rather the post office address. Post office address for AE block of Salt Lake is CC block post office, my lord. On instruction, I'm submitting this, and this is substantiated by page 16. As my lord has rightly pointed out, my lord will find item delivered to the addressee. The addressee is never the post office.
No,
And
no,
here,
addressee has to be.
addressee is them, number one. And secondly, my lord, will kindly see the office that is mentioned in that tabular statement, my lord, at page 16. My lord, will see the office. It is always, even today, if I seek to serve someone on Old Post Office Street, my lord, it will not show that item delivered to addressee. The office won't be mentioned as Old Post Office Street. It will be mentioned as GPO. That is evident from their own affidavit of service in their review application, where my lord will find from that page.
No, CC is.
My lord, CC block
That's
is the
probably a
post
postal
address. Yes, that is the
equivalent of.
office. No, that is the post office, my lord. The post office receives the consignment. Thereafter, the
It was
postman.
something service officer, something of that sort.
Yes, my lord.
It was.
No, my lord, that is the post office. On instruction, my lord, I'm submitting this. This is also substantiated by
What does the A stand for? There is some meaning to that. You can have a Google
always
search
on-
and find out.
Yes, my lord, that
But
will.
I just
will do
took
that.
out online. The primary post office serving AE block Salt Lake is Bidhannagar AE Market sub office. SO is sub office.
That is now 2024. I am not aware of what the situation was. My instruction.
You just put in Bidhannagar CC block SO and what comes?
WhatsApp. No.
Whatever. No. What WhatsApp?
Oh,
Nonsense.
বুঝতে পারিনি।
Sub post office is SO, my lord. Sub post office is the full
Just
form of
put in
SO.
Bidhannagar CC block SO
Yes.
and what comes up?
Bidhannagar CC block.
The entire thing.
কি বললো বিধাননগর দাও সিসি ব্লক কি আছে জানো?
Block SO. It's a post office address, my lord. Bidhannagar CC block is a post office situated at Salt Lake area, falling under the jurisdiction of North Chobbish Pargana, so and so on forth.
This is.
Yes. Now, my lord, here the address is, this is all going into a lot of conjecture and Google searches.
Yes.
Let us get back to, my lord, the tracking report. The track report clearly says addressee. The addressee means the name. Even if it was served, let us assume their case at the highest, it was served upon Salty at the post office, at the very least, taking this into consideration, and their affidavit of service, my lord, will find the offices mentioned are also akin to what I have annexed. My lord, we'll see every single track report. My lord has seen the postal receipts. Unfortunately, this is a private courier, my lord. This is not a.
Oh yes.
This is a private courier, not India Post.
Right. It will be different.
But still, even so, my lord, we'll kindly see the track reports. The track reports are exactly like what is there here.
It was sent by post. Yes.
It was sent by post, but the offices always mention, my lord, the SO. It never mentions as a matter of general practice. My lord can take judicial cognizance of this. Here, the post office, even today, my lord, as on date, if I try to serve someone on 6 old Post Office Street, it will show office was GPO, and in the side, my lord, remarks will say delivered to addressee. That is what will be there even today if my lord dispatches a postal consignment. Now, this is affidavit of service. This is my submission totality in respect of affidavit of service, because
Merchant of Venice gives a clue. Merchant of Venice that if you Antonio was saying to Bassanio that if you lose one arrow, then send another in that direction. And
yes, that
you find
in effect.
Yes.
But here it's an arrow to a
that
post
also.
office as well,
Anyway.
to the correct post office on instruction. I'm saying this one. There's nothing to controvert the
Very
endorsement of delivered to addressee. That's my submission as to the affidavit of service. Now, my lord, will kindly take as to service again the last point that I'm making, page 121 of my of the review application, my lord, which I had already shown on the last occasion. I won't repeat myself. Page 121, my lord, will find this is delivered to Daga Auto Services.
Yes.
This is not a certified copy. This is photocopy of a service letter.
To Daga. Ms. Banerjee is saying it's to Daga, not to them.
I'll come to that. I'll come to that.
I'm saying is Daga and
I'll come to that.
shareholder Salty Millard is a separate. entity.
I'll come to.
I am not citing judgment because that is, my lord, is there.
I'll come to that.
And all these
I'll come to that. Well, you kindly see page 121, and thereafter.
Judgment
This,
for what proposition?
that
Shareholding is different from a.
yes, shareholder cannot be construed to be the company. The rights of the company, property of the company, notices, everything is separate. Yes.
Yes.
121, the service letter is annexed. Along with, my lord, the application is there on the next few pages. Now kindly comes to 130, 130. The last page. Second last page, my lord. My lord, we'll see this is also part of the service letter. My lord, we'll see the caveat endorsement, no intimation so and so. This is an application to be moved before the Honorable Justice so and so on 7th May 2024 of the Honorable Court. My instructions are from 7th May 2024. The matter was running in the list as per the notice of motion, as per the caveat endorsement, which is part of the served application annexed by them in their recall application. This whole boogie of non-service is completely misplaced, my lord. This is an incorrect statement made from the bar. Now, my lord, we kindly take. Now, this is the service letter, which is a part of their recall application. Let us see how they've annexed it. That will give us a clue as to whether they distinguish between this juristic entity of the company or not. Page 56. My lord, will kindly have page 56, paragraph 21, part of their own recall application. Let us see how they annex it. They must have mentioned that we've received only a certified copy or taken out a certified copy of the application that was served upon Daga Auto. That should be the requirement ideally. My lord, will kindly see paragraph 21. It appears that a withdrawal application was filed by the appellant seeking leave to withdraw the appeal, all connected application on the ground of the appellants are aged persons and they do not wish to pursue the appeal. Kindly see the next page. A copy of the application is annexed as Annexure G. This is Annexure G, page 121. In their own recall application, they annex the service letter issued to Daga Auto and the application enclosed therewith, thereby showing that they have knowledge of the application from the get-go. Clearly, this is an argument that has been conjured up post everything, post receipt. Perhaps I don't dispute what Ms. Banerjee is saying. Daga
Banerjee, you incorporate your arguments on this affidavit of service also and file a composite one.
Yes.
You have not put in your arguments regarding the affidavit of service, which you made today.
I think I've made it short that we are in review and we are not in appeal, and this was not the scope of their order, impugned order. And nevertheless, I have addressed it, I think, very shortly. This part and also whatever my learned friend is today arguing.
page 56, Maladu, is clear.
You put in your arguments in your written.
Yes, we'll put it. 56, 57.
Give a supplementary.
I think that's better.
Clearly, my lord, they were having knowledge of the application that was there on 26 September when my lord passed the order. They were aware, they chose not to appear. This is my categoric submission from all the documents that they have themselves placed before this Honorable Court. And in addition, the affidavit of service, which shows item delivered to addressee Salty. Now, second, as to juristic entity, just I'm completing service, my lord, so that thereafter we don't need to go into that terrain again. My lord, on the first day when I was arguing, I had handed up an advocate's letter of Mr. Saurabh Roy that was issued by my learned senior friend's client. First day, my lord, I had given them a copy as well. It should be part of my lord's record. My lord was looking into it. There should be one letter of Mr. Saurabh Roy. Yes, kindly has. It's a letter dated 4th December 2024. My lord, will kindly see my client, Daga Auto Services and Salty Infrastructure. Ms. Banerjee is not argued on this, but I think this is of some importance. Number 2, kindly takes page 2 of that letter. The first sentence which starts, only under such circumstances, the said Prayak Das Daga, Nirmala Daga, Krishan Daga could have withdrawn the appeal on 26 September 2024. On 4th December 2024, belying the contention today that 23rd January 25 is first when they learned of withdrawal. This is a false, or I'm sorry, I shouldn't say false. It's an incorrect statement today made from the bar and also made on oath in the application for review, as well as the recalling application. They were aware. 4th December, their knowledge starts. Let us assume everything they are saying to be true. 4th December, their knowledge starts.
This was served on whom? You?
On my advocate, on my advocate, because I had written to them
You means your
subsequently.
advocate?
Yes, Mr. Atish Ghosh is my advocate. That is the respondent number 2. I'm not the appellant, will you kindly keep in mind. I had written to them on numerous occasions and we had prepared a compilation of letters, but I don't want to show subsequent documents in reply to a reply. So I'll rely upon only this document which is already there, clearly showing that firstly, Salty and Daga Auto are the same entity insofar as knowledge is concerned. For the purpose of rights and liabilities in a suit, perhaps they're separate entities, but insofar as knowledge of the order, they are the same. Secondly, from this letter, it is clearly evident 4th December, at least, they were completely aware of the order passed withdrawing the appeal, and they do not talk about their vested right. Malad, this letter is important because they also do not talk about any vested right in the appeal. They say that they've alleged that we have settled with Prayagdas, Daga and so, but they do not say that they are entitled to be transposed in the appeal. They do not say that. They simply say that they've paid money, consideration, so and so. A vague allegation of fraud is also there, but no allegation as to a vested right. This is an advocate's letter. This is not a letter issued by the client themselves. They were advised. So contemporaneously, no prayer for restoration and transposition. Even after withdrawal from December 2024, no prayer made in that regard. Service, Malad, I think that should suffice. I'll just sum up my submission on service. They were aware, they were duly served as endorsed by the postal authorities. From May 2024, the matter was running in the list. They chose not to appear on September 2024 when it was taken up. Malad, we recall company matters. I don't want to digress this much, but then in company matters, Malad would take up on a particular day, only on Fridays in court number 36. So it would not be called a lot of occasions. So it was called finally on 26. It was throughout there in the list. I was there personally, Malad. It was there throughout in the list from May. So they chose not to appear regardless. Now, Malad, on the next aspect, the substance of their application. The entire substratum of Ms. Banerjee's application and contention before Malad is that they have a substantive right in the appeal. They have a substantive right in the appeal, a vested right. That is the language used in the review application. I'll take their language. They have a vested right in the appeal filed by another shareholder in a company challenging a rights issue, or rather challenging a finding in respect of a rights issue. They have not shown, even now, after opportunity, after I had made my arguments, not a single document, not a single averment in the memorandum of appeal, nor the stay application to show that the appellants in the appeal were in any way espousing the cause or carrying the torch, so to speak, for the respondent numbers 9 and 10 in the appeal. Not a single scrap of paper. So my submission in that regard stands admitted, in effect, that there was nothing on record. So today, Malad, the judgments that have been shown are all judgments relating to partition suits in respect of partnership and in respect of the Guardians Act, all of which contemplate some right of a party to be decided in the matter.
10F appeal has also been shown. 10F appeal. Kerala is
Kerala. That is the Kerala. Kerala is the only judgment where it is absolutely on them. Absolutely. I cannot dispute that. But Kerala, again, I'll show 2008 Kerala, well, I'm sorry, 2003 Kerala is in their favor, but it doesn't consider the other judgments. And the Supreme Court, in my humble submission, I tried to establish that from the 2 Supreme Court decisions that they've shown, only 2 they've shown, that is 2020 and 2013. Both decisions are in my favor. They both say that when a plaintiff or an appellant, so and so forth, seeks to withdraw, at that point of time, that is the correct juncture at which an application under Order 23, Rule 1A, read with Order 1, Rule 10, has to be filed. They have to oppose that prayer for withdrawal. Here, they've chosen not to appear on that date, and in any event, on that date, the court did not have before it either an application for transposition, nor even an affidavit where they were or rather propounding the cause of the appellants either. Not a single scrap of document was there. Only the memorandum of appeal and the stay application, and the vital order of justice sent. Even if they had appeared on that date, Mullah,
that no opposition to the withdrawal application.
No, they didn't appear.
That copy was
could have been
subject to Ms. Banerjee's argument if it is accepted that it was served.
Yes, Mullah. My submission, it was served. No affidavit of any sort opposing the withdrawal. And in any event, in the appeal, in the substantive appeal, my lord, no document on record to show, no pleading on record to show.
At that point of time, there was
There
nothing.
was nothing.
Direction
There was nothing.
for filing affidavit.
That is beyond the. My lord, I'm saying there was nothing on record. Whether there was a direction or not is not important. There was nothing on record, and also coupled with the order of justice Sen. My lord, all of their judgments cannot be, or rather, none of the judgments can be looked into in view of the order of justice Sen. The order of justice Sen has not been explained away, my lord, with the deepest of humility. That order still stands in their face. Even if today their prayer for transposition, if the appeal was alive today and their prayer for transposition was taken up on merits, even so, I would have had a valid right to contest it and say that, look, your advocate, your admission, your statement before a court saying that you support. So where was the wrong done by the court for the court to recall such an order of withdrawal, allowing an appellant to simply not pursue its remedy? That's about it.
What about the substantive right aspect highlighted by the Delhi High Court and other high courts, which is it's something to ponder on, because
Delhi
if somebody's right is affected, because they were selling on the same footing as you as the appellant, insofar as the challenge to the matter was concerned, because that would affect their rights also.
In my humble submission, in view of Justice Sen's order, they were not. They were not. Number one. And number two, even assuming, let us assume Justice Sen's order was not there. Even so, what is Ms. Banerjee's client? A purchaser of goods, a purchaser of shares only. Assurance and all of those statements I'm ignoring because they are unsupported by any document, anything on record.
Assurance.
I'm not on that at all. I'm saying what is Ms. Banerjee's core legal character? She's a purchaser of goods only.
Through you.
Not through me.
Them.
Not through me.
Appellant.
Not through them. Once title in the goods pass, Malad will kindly appreciate. Malad, here,
right, yes.
I have to just clarify this.
Yes.
The appellants did not sell.
Not agent or something.
Not an agent. Not an agent, not a co-sharer in respect of a property sought to be partitioned, not a guardian ad litem. These are all the judgments that have been cited, not a guardian ad litem.
Claiming through need not necessarily mean that they, even if, because the right insofar as the tenant was concerned, I mean, their claim is through the appellant, in a sense that, because in Arbitration Act also, I mean, when we think about this impleading people as parties or through them also broadly speaks about somebody claiming through. I mean, the interest.
Who is an assignee. I would say, if at all through an assignee, perhaps they could have been said to be.
All right, very well. This
is not a case of assignment per se, because assignment.
At least their claim was dependent on the appellant's fate in the appeal. If these share issues go, then the premise of their purchase goes off.
If they wanted to challenge the CLB's order, they always had a right. Well, we're talking about a vested right in a proceeding. We are not talking about a vested right in a product or a good. I'm talking about a vested right that they're claiming in a proceeding. For that, the standard is a little higher.
The vested right, there was the vested right in their favor.
If that is the case,
unlike the other cases of partition and all those.
In a partition suit,
right,
my lord, in a partition suit, what happens? My lord, Order 20, Rule 18, my lord, is aware of. It's an obligation on court in a partition suit to determine the rights of the parties who are before the court. It's an obligation on court in a partition suit. Order 20, Rule 18 is there. Similarly, in a guardian ad litem action, my lord, there's a person who's represented.
No doubt.
Order 1, Rule 8 also representative. There's something, there's a leave granted by court. There's a document on record. And in this case, in respect of the Companies Act, I had shown and relied upon 399. Section 399, that argument has not, with the deepest of humility, been at all touched in the response by Ms. Banerjee. This is not a case where the premises, or rather the first application before the CLB, which is the genesis of the entire litigation, was not a 399 action. It was not an action in representative capacity. There was not even a single document before the trial court, that is the CLB, to show that they were together. They were represented by different advocates. We'll recall I had shown the CLB's order. They were represented by different advocates. Before the High Court, they come and say, I support the order of the CLB. We'll kindly see, this is not a case at all where they can say that they were sailing even on the same boat. They're represented by different advocates taking different stands. And their rights in respect of the shares are again a right that is a qua the property itself, which is already vested and already that's passed. The title has passed. It does not entitle them to piggyback, as has been rightly pointed out in the order under challenge today. They have no right to piggyback on the appellants. So, Malad, vested right in my humble submission, Malad, does not at all. There's nothing on record for Malad to come to that finding. They are only trying to, if at all, they can say that I had a right to come and oppose the withdrawal and transpose. To that, my answer is served, number one. Number two, you chose not to do so. Number three, even after the withdrawal, you waited for more than a year to come to court. Delay is the next point that I want to highlight. The order is of 26 September 2024. They filed the recalling application on 13 November 2025. More than a year without taking any step after having been served.
But the recall application was not rejected on the ground of delay. That is one point Mr. Banerjee made.
Malad, the recall application today, if Malad is reviewing Malad's order, Malad will then have to allow the recall
Then we
application.
have to enter into
Also,
all the aspects of it.
yes, but also Muller will not review an order and set it aside when the ultimate outcome of the application is the same.
Yes.
On account of delay and latches, and especially I want to argue acquiescence. They had acquiesced to the order of withdrawal. This is a case of pure acquiescence. Number one, Justice Sen's order, which I will harp on till I think the matter ends. That is my biggest trump.
This
Justice Sen
and
service, and thereafter they come to court on 13 November 2025. Muller has also seen paragraph 30. There was a jump of about 9 months. Paragraph 30 of the recall application,
Yes.
Muller, they say from January and thereafter September they directly come to. No explanation as to anything that they have done in between. That clearly shows acquiescence on the part of the litigant, negligence on the part of the litigant, which my lord will not entertain. Now, substantive. Now, my lord will kindly see the judgments very quickly. In a representative capacity, in any event, Muller, the pleading standard of pleadings is different, which is not before Muller. Order 7 Rule 4 has not been complied with. Muller will kindly take two
It's
judgments.
not a representative capacity. Right?
That's the argument I'm meeting it, Muller.
That I made it clear to his manager.
The suit is not a representative capacity. Is not a representative. Secondly, the appeal itself is not any person agreement. I'll very quickly, Muller, deal with the
Not
two
in a
judgments.
representative capacity, but today's plinth of argument of his manager was as a respondent also. Order 4, 33 and all these are
They had
there.
a right
And
to argue.
apart from that also, the substantive right on that aspect of the matter as highlighted in those judgments.
They had a right to argue in the appeal. But till the day Justice Sen passed the order. From that
Order
day,
23 also uses the language as opposed to Order 1 Rule 10, although it has been held by the Delhi High Court as a subset that exact
it
language
arises after abandonment.
after
That is the
or
argument
on
of this.
abandonment or something like that. I'll just read the exact language.
When
Where a suit is withdrawn or abandoned
yes, Mullah.
and a defendant applies to
Yes,
be transferred.
Yes, Mullah. Just to
Sure.
deal with that very quickly.
It's a bit vague on the timing, but where a suit is withdrawn apparently initiates the cause of action, commences the cause of action from withdrawal of the suit.
In my humble submission, no. I say that because the use, Mullah will kindly see, where a suit is withdrawn or abandoned by a plaintiff under Rule 1 and the defendant applies and this.
So you say Order 1 Rule 10 is invoked through the channel of this.
Yes.
This is the window.
Yes. Order 1 Rule 10 is a substantive provision. Order 23 Rule 1A. As
So
opposed-
why was Order 23 Rule 1 necessary then?
Order 23 Rule
Order 1
was-
Rule 10 itself
Order 1
would be
Rule 10, no.
110
It was
along
not.
with read
No.
with 107.
Subject to correction, my lord, no.
Why?
Order 1 Rule 10 contemplated transposition only if there was a mistake. My lord, kindly take Order 1 Rule 10.
Yes.
To substantiate, to cure that lacuna, this was introduced. It was not introduced to allow post facto Order 1 Rule 10.
All right.
An application has to be filed under Order 1 Rule 10. My lord, Order 23 Rule 1A does not contemplate an independent application. It says, and defendant applies under Order 1 Rule 10.
It enables Order 1 Rule 10 to appear.
Yes, it is another limb of consideration for a court to allow transposition. Order 1 Rule 10 allows transposition only if there is a bona fide mistake. That is the language of Order 1 Rule 10.
23 1 is that additional ground is peculiar to withdrawal scenario.
Yes,
That's why it was put in 1A,
yes,
not an amendment to Order 1 Rule
Yes.
10 itself.
yes, yes. Because Mullah, we are in India, Mullah, there are occasions where Mullah, there is a strategic withdrawal, as Ms. Banerjee has pointed out. Delhi High
The
Court
country
also
says
does-
the strategic withdrawal.
No, I don't know. I'm not
You're speaking about the
I'm
intense
sorry.
jugaad.
No, I shouldn't.
Which has been
shouldn't.
recognized
I
in
did-
certain
I
dictionaries
did.
also, jugaad.
No.
Yes.
I
It's
retract that.
parliamentary now.
I retract that, my lord. I retract that. I retract that. That's not a correct
True.
submission.
So strategic.
Strategy. Yes. So, my lord, Order 23 Rule 1A only provides us for the consideration of a court in respect of an application of Order 1 Rule 10, which has to be filed during the pendency of a suit. My lord, every single decision that's been cited, barring those two Kerala High Court decisions, all say that when the suit is attempted to be withdrawn, Order 1 Rule 10 comes in, transposition, transpose me.
Right.
But it doesn't contemplate post facto. I've made my submissions on that. I'm not repeating myself again. But I will kindly see now the two decisions which I really want to distinguish specifically. The rest, Malal, I'll deal with in my notes because we're running short of time. I want to finish this today, Malal, if Malal will kindly permit. Malal, page 40 of the compilation, if Malal takes the Delhi High Court decision, because that discusses the law a lot, so I have to deal with it. Paragraph 6, first distinguishing feature, this is a partition suit. Paragraph 6, the underlying suit was a partition suit. The underlying civil suit was instituted by plaintiff so-and-so seeking partition. Number 1. Thereafter, Malal will kindly turn the page. Malal will kindly take paragraph 13 to 15 very quickly. Here, Malal, the allegation was paragraph 13 to 15, Malal will have a look. Here, the contention before the court was that the plaintiff was delaying the matter and was being negligent. Therefore, during the pendency of the suit, an application was filed under Order 1 Rule 10 seeking transposition. Specifically, paragraph 14, 15, Malal will find that. It was not a case. Post facto withdrawal or the post facto transposition was not the case. Thereafter, Malal will see the law is discussed. Paragraph 33, Malal, I am relying upon. Consequently, may I just place paragraph 33 quickly, Malad? Consequently, Order 23, Rule 1A cannot be construed as a provision of general or unfettered application. Rather, it is attracted only upon occurrence of the specific contingencies, namely where the plaintiff files an application or otherwise prays for permission to withdraw the suit. When that prayer is before court, not after it is allowed. Specifically. Thereafter, Malad will kindly see paragraph 42. Yes, 36 also, Malad, that substantial question to be decided is there. Ms. Banerjee has placed paragraph 36. Substantial question, in my humble submission, in this case, there is no substantial question in view of Justice Sen's order number 1. And number 2, because there is no document on record to show any representative capacity or a vested right. These are my
No,
two.
this is on a wider footing. It says in a specific eventuality where a plaintiff seeks to withdraw suit under Order 23 Rule 1 CPC, the court must first consider whether any defendant seeks transposition.
All of these are...
and whether a substantial question survives for it. So, and.
Yes. And whether a substantial question survives. Now, here a substantial question does not survive in this appeal. Well, we will kindly see, if today, let us assume they are transposed, will the averments in the application make sense, or the application for stay or the memorandum of appeal make sense at all for the companies to espouse? Because the appeal was filed by my relatives alleging their or other justification in doing the rights issue or other continuing with the rights issue. If they were transposed today, even the averments of the stay application would be nonsensical because it talks about the nature of the business prior to the sale.
No, for transposition, we have to look at the grounds in the memorandum primarily.
Undoubtedly. Undoubtedly.
And there can always be a fresh application directed.
To amend the grounds and so on and so forth. But the nature of the appeal is also one filed by shareholders at that time, justifying the rights issue conducted by them, not subsequent. Today, Malad, we are not on the sale of the appellants in favor of Salty. It is at a stage prior. I had handed up that chart, Malad. The stage prior is...
That I also asked Ms. Banerjee.
Yes, the stage prior is the rights issue.
It's come later.
Yes. So, as on date, when the list arose in this appeal, it was only the rights issue at question. Salty did not have much to say at all. Salty comes later. Thereafter, Malad, paragraph 42, if Malad will kindly take a look at this judgment. The decision reinforces the principle. The decision thus reinforces the principle that procedural provisions must subserve the substantive rights, and that a defendant having an independent and enforceable interest in the subject matter of the suit cannot be non-suited merely on account of so-and-so. Here, Salty does not have an independent, enforceable right in the subject matter of this appeal. Even taking 10F to be permitting representative capacity action, which again, that's my first limb of submission. 10F appeal talks about a person. So here again, there's no substantive right of Ms. Banerjee's client to at all espouse before this honorable court, my lord. Now, my lord, will kindly take Kerala 2018, that's page 52, my lord, the next judgment itself. Very quickly, my lord, here, paragraph 7, my lord, will find this is also suit for partition. Paragraph 7, technically, I'll just place this. Technically speaking, an application under Order 9, Rule 9 of the CPC, this was placed by Ms. Banerjee, can be filed by a plaintiff. But here is a case where a suit is one for partition. Paragraph 7. So again, a partition suit, my lord, is a very substantially different concept as compared to a 10F appeal arising out of a 397, where a shareholder having sufficient capacity to institute independently has done so. Partition suits are where co-sharers have their rights required to be adjudicated by court. They stand on a completely different footing. Thereafter, my lord, the other judgments that are there, my lord, I'll deal with in my notes more specifically, but 1958, all of the judgments, I'll indicate the relevant for one or two, my lord. Page 78, that's 1955, 1958 SEC Online SC. This was, my lord, also a suit where paragraph 4, my lord, we kindly have, the application came during the pendency of the appeal. This Ms. Banerjee cited to show that Order 23 Rule 1A also applies in appeals. Here again, the appeal was alive, paragraph 4 and 5. Thereafter, my lord, will kindly take 1948 Patna. Here again, my lord, application filed during the pendency, and it related to a guardian ad litem action, my lord. The first page itself, first paragraph itself, my lord. It is stated, the sentence starting with, it is stated on their behalf that on account of default in guardians ad litem, completely different scenario as compared to this present case. As to the judgments relating to partnership principle, my lord, in partnership suits, my lord, partnership actions also, perhaps, my lord, rights of partners survive because there's a right for having accounts of a firm delivered for dissolution after dissolution. So some rights, there are some rights which have to be adjudicated by a court. Rendition of accounts and thereafter declaration of shares of the partners is again something that has to be adjudicated by a court. In this case, my lord, there is no such adjudication to be done by the court as to rights of Ms. Banerjee. It is only the rights issue which was under challenge. Ms. Banerjee has purchased the shares from the appellants, not only of that 20,000 impugned shares, but also the rest. So Ms. Banerjee's rights also subsist insofar as the rest is concerned. It isn't only the rights issue where Ms. Banerjee comes into the company. She's also derived the entirety of the shareholding. That's the appellants had 2/3 shareholding in effect. She also gets that 66% of the original shareholding by way of transfer direct. Malad, is in essence that's it, Malad. Yes, one more further point, Malad. Today, the reason why Ms. Banerjee is really harping upon this application and seeking to be transposed is that they're trying to circumvent the limitation that is provided for under Section 10F. They have, as per it has fallen from a law, their averments say that they have chosen not to file an appeal. So today, if they were to file an appeal, I would have a valid right to oppose that appeal on the ground of limitation alone. Their only ground, Malad has said this is a fantastic case for a Section 5. But I would, with the deepest of humility, I understand. I understand.
Yes.
Of course, I have a right to oppose that, a Section 5. Because today, this is a litigant who has been sleeping under the impression that their rights are being espoused by a completely different entity before a court, who has consciously chosen not to file an appeal. And thereafter, they have consciously chosen, even after the withdrawal, not to approach my lord, even within a year of that withdrawal. Now, my lord, last thing just which I wanted to point out, because my lord I have to point out in the judgment under review, my lord, the question of this vested right has been decided, taken note of and decided by my lord. That is not something that can be reviewed. If at all it is an incorrect finding, I'm not saying that. Rather, I'm supporting it. But if at all, this is not the proper forum. Because Malad, will kindly have a look at Malad's order, specifically page 3. Malad talks about in detail the fact that they didn't file an independent appeal also is a finding for a delay. If Malad will kindly appreciate. The word delay is not used in Malad's order. But the fact that they didn't file an independent appeal,
not to file an appeal.
They chose not to file an appeal. That's recorded in Malad's order. The fact that they're piggybacking, that is also a contention on delay which is decided. And vested right, it is decided in extenso. In that one page, my lord had decided the question of their vested right in extenso. Yes, and lastly, my lord, I'll just reiterate, Justice Sen's order is there. I'm not going to show any further. Justice Sen's order precludes all of it. Every single judgment is distinguished by Justice Sen's order, and they have not distinguished it. They have not been able to explain. Those are my submissions, my lord. And my lord, one further, my client has been suffering for 15 years. Today, the question is only as to a rights issue which was illegally done, held to be so. If today the review applicant is permitted again to revive the appeal, but my client's substantive rights in the company, just to have her legitimate shareholding, will be prejudiced. She's a widow. This would cause substantial prejudice to my client if the appeal were to be revived. Let them file their independent appeal or take whatever steps they want to do so. Let them fight it out. Section 5, my lord, is not taking up here. They have a right to argue it out. Well, those are my submissions.
File a written notes, both of you.
We'll file it within a week.
You want
my
to
lord.
file an addition? Do file an addition supplementary written notes or arguments
I'll file a supplement.
regarding this the arguments made.
Then, my lord, on that, I will also add one decision why. Oh, very well. Because
I
your
oppose this.
lordship, my lord,
For the decision.
I oppose this.
the only thing why, because my lord, your lordship is now, I was proceeding on the basis on the scope of review. Only one question whether I have an independent
Because
right.
you made several arguments, not only on the scope of review, on several aspects, which is reflected from your
Yes.
written notes of argument.
On delay and Justice Sen's order, my lord, I have not addressed because that was.
No, miss. You were several times I put you to notice during arguments that Justice Sen's order is there. Definitely it was before you.
Yes.
If you have chosen not to argue, it's your problem.
No, Sen's order, I have said that, my lord, in the impugned order, my lord.
Whatever. Justice Sen's argument came up during your argument several times. I pointed out.
Yes, and I have dealt with in the
No further judgments in your learn it because he has not cited new judgments. He has just distinguished your judgments and relied on some of it.
Yes, yes. Just the scope of review, your lordship also knows, my lord. I mean, have to say.
This affidavit of service, that affidavit of service you had filed earlier.
Yes, my lord, last occasion. my lord.
Acha. The affidavit of service with regard to the present review application filed today be kept on record. Whose of the written notes of submissions filed by the review applicant is also kept on record. Whose upon prayer of learned counsel for the review applicant, the applicant is permitted to file supplementary notes of arguments on the returnable date. The respondents within bracket respondent number 2 in the original appeal, shall also file the written notes of arguments on the returnable date. The matter shall next be listed on. I'm putting it on 8th of May. 8th of May is the next date available when I come back. May 8, 2026. The matter shall be listed under the heading to be mentioned on the said date.
My lord, kindly adds the leave for the wakalatnama.
For the legal aids of the appellant number.
প্রথমে একটা করে leave is granted to the learned advocate on record for the respondent number 2.
No, my lord, not
5.
this. Number 5.
For the learned advocate for the respondent number 5 to file.
Respondent number 2.
2 to file his wakalatnama. His or her.
No, I'll deal.
Her wakalatnama.
The last part, the widow part, my lord, I did not understand. What?
My client is a widow, my lord.
Yeah, but
What did you not understand?
yes, our client may be a widow, but she is being represented when her son is here, and
That is not.
it is not like she is an old infirm widow, my lord, who is coming to court. So this is the son is here.
Yes.
Court.
I believe the death of a husband makes a person a widow. Perhaps not. The existence of a son does not.
And the appeal shows that we tried
I don't
to
believe
please
anything
her.
about this. That's the presumption I have. That's a presumption. Everything is revertible. Ms. Banerjee, everything is revertible, isn't it?
We tried to pay her, my lord. She wants to.
Well. Yes.
I have a lordship's leave, my lord, to mention with respect to item number 26 of this bench.
Yes.
This is a review. My lord, I have been engaged. My lord, I personally feel, my lord, the grounds taken in review should be taken in SLP. My lord,
Should be taken in?
SLP, appellable. Those grounds are appellable
All right.
rather than a reviewable.
You want to not press?
My lord, exactly, my lord. Since we are going to go for SLP, my lord, I wish let this be a court's order saying that, my lord, the review, the points in the review are should be taken in
Not according, no order made to order.
My lord,
When you have to
that would
withdraw
create
it
a
with
my lord,
liberty
no.
to take these points in the that we can if you want. Take instruction from your
My lord,
client.
withdrawal would, my lord knows in SLP, my lord, other side would take up and we have withdrawn the review. And
Then
my
you
lord,
have to hear it on merits. There are other review applications. How can you take it up before the others?
I was praying since I was going to, my lord, urge this order may be court's order, but my consent may not be recorded.
No, if your consent is not recorded, we have to, Mr. Chatterjee, enter into the merits. So that cannot be done jumping the queue. Other matters are equally maybe.
Well, I would
Maybe all the other matters are similar. We don't, we never know.
that's why
So many review applications. No.
I will not hard press much, my lord. You can to be mentioned and, my lord, let one.
Your softness does not give a right. Yes, you are mentioning the same thing. No.
No.
This bench.
Yes, this bench. For inclusion, my lord.
Yes, yes.
Deeply.
Call. ও এইটাতে না একটা ভুল করেছে মানে ভুলটা আমারই এটা হচ্ছে 17/2025, we had erroneously directed that a formal decree be drawn up. However, since by the judgment passed in the appeal, we had remanded the matter, no formal decree is required to be drawn up. Accordingly, the said direction in the order dated July 17, 2025 be deemed to stand deleted.
For the petitioner.
Yes.
The last occasion, Lordship had directed the office of this honorable court to serve the warrant of arrest on the Commissioner of Police, Kerala, to produce the alleged contender before your Lordship today. No one.
রিপোর্ট করে দিয়েছো বার করে এগুলো প্রথমে The Commissioner of Police has filed a report. Let us go through that. এই ক্ষেত্রে একটা কপি নেই দুটো করে কপি করে দেবেন যদি কোনো অফিসিয়াল কপি আছে They have undertaken a full-fledged investigation.
Find him?
Yes, a full-fledged report. I mean, like a criminal investigation. Could not find him. Went to his place, last 6 months not residing, tracked his phone number, switched off, went to some other place, secret inquiry.
But he is continuing to issue emails to my learned advocate as well as the petitioner. Well,
You can then
some cyber
furnish those email the particulars of the emails.
Yes.
But you have to then approach the Commissioner of Police, Kannur City. Will give you that liberty. You can
we shall communicate the email.
communicate also. You can communicate also.
That the URLs may be traced. There are methods.
There are methods. So if you can forward those emails, then it will help the police. So they are requesting more time. So definitely they have done their level best.
Lordship may grant me liberty to communicate the emails.
will.
We have received emails even yesterday.
Very well. We will direct you to, will give you liberty to get in touch with the Commissioner of Police, Kannur City, and you may go through this report also, so that you get their whereabouts. Or you may contact our office also.
Get a copy of the
But,
report, a certified copy of the
should we apply for a certified copy of the report, or will it?
Need not. We will permit you to have an inspection. In our order itself will say.
Very well.
From the office report, comma, you find that a reply has been received by the from the Commissioner of Police, comma, Kannur City, comma, Kerala, pertaining to the arrest warrant issued against the contemner. Push up next para. From the said report, comma, we find that satisfactory steps have been taken by the Commissioner of Police, comma, Kannur City, to trace out the contemner. Push up, however, comma, despite their best efforts, comma, the police could not yet trace out the said contemner. Push up, accordingly, further time has been sought to execute the warrant. Full stop. We express our prima facie satisfaction with the efforts taken by the Commissioner of Police, comma, Kannur City, and extend the warrant issued and make it clear that the warrant issued against the contemner shall remain in force until further orders. Push up. A further report be sought from the Commissioner of Police, Kannur City, regarding further developments in respect of tracing out the contemner, absconding contemner, within a month from date. Pushed up next para. In the meantime, comma, the learned advocate appearing for the petitioner is granted leave to inspect the report furnished by the Commissioner of Police, comma, Kannur City, which is a part of the records, comma, and to communicate with the said Commissioner of Police, since we are apprised by learned counsel for the petitioner that very recently certain emails have been sent purportedly by the contemner, comma, the particulars of the said emails may be furnished by the petitioner to the Commissioner of Police, comma, Kannur City, in order to facilitate early apprehension of the contemner for the purpose of production before this court. So let the matter be listed next on May 15, 2026 for passing further orders.
Grateful.
Unless it is nabbed, nothing can be done.
Yes. But will your Lordship be kind enough to observe in the order that they may take other recourses for tracing the emails and the location from where the...
No, they're doing
they will do
whatever
it.
they have asked for time only. They are saying that they're exploring all options.
Very well. But one more concern, Varad, the alleged contemner has been sending the advocate threatening emails and then for complaining to the Bar Council, publishing.
File a one-page application, supplementary affidavit to that, and we'll record our prima facie satisfaction of aggravated contempt, and also maybe passing some protective orders. Protective orders are not working because he's already in contempt.
Yes, already in contempt. But some observation may have.
But make a one or two-page application.
I'll do that. But we'll file a supplementary affidavit.
We'll run to that. At this juncture, comma, learned counsel for the petitioner submits that the contemner has been sending threatening letters to the learned advocate for the petitioner. For next para, the petitioner is granted leave to file a supplementary affidavit bringing on record such purported threatening emails and or other communications for the court to take note of the same and to pass appropriate orders in that regard on the returnable date.
Grateful.
Thank you.
Item number 3, I am for the petition. The appellant, applicant.
Please give us half a minute. We'll see. Please carry.
my lord, the pursuant to the direction passed by your lordship, my lord, 12 September.
Yes.
My lord, the copy of the contempt application, my lord, has been served, my lord, on the contempt. This is, my lord, affidavit of service, my lord, it will be taken in record.
They have been served.
Yes. And my lord, this is, my lord, the appeal, my lord, against the, my lord, the under section, my lord, 25 of the Guardians and Wards Act.
Right.
And my lord, dear lordship are pleased to pass an order, my lord, on 18th, my lord, the June 2025. My lord, you can see that.
But delivery, well, within bracket address is not written. It has been delivered to the local.
It has been delivered to the, my lord, the kindly see.
Yes.
Item delivered on 16/9/2025.
If you please come to the last last entry in the track report, item delivered at Uttarbar PO.
Branch office.
Well,
this is the post of Uttarbar branch office.
Yes, branch office. So
the branch office has delivered to the one.
That is not reflected here because in the ones which have been in the service which is affected to the person himself, it's within bracket. It's written item delivered addressee.
Well, this is one of the.
When did you send? 13th.
Well, it was sent, my lord.
No, they are not.
13th of September.
13th of September.
Oh, then by now it should have been served.
13th of September.
This is a contempt application.
Contempt application.
You should issue a rule now. If they are not appearing, they choose not to appear. You have to issue a rule.
No, my lord, the kindly, my lord, this is the, my lord, the right of visitation of the child, my lord, who is, my lord, in the custody of the mother. And my lord, the order has been communicated to the, my lord, the mother.
We will issue a rule asking him to be present.
Yes.
Contempt, we cannot do more. Let us just see that order once, that order in portion.
Yes. On 18th, my lord, the June.
Yes. She has never produced.
Never produced. Never.
Affidavit of service filed to be kept on record, from which it transpires that service has been effected on the alleged contemner, in any event, since the copy of the contempt application was sent as long back as on September 13, 2025, we deem proper service to have been effected in the meantime, as the service was effected at the address of the contemner as given in the cause title of the main appeal. Next para. By our order dated June 18, 2025, we had, inter alia, directed the alleged contemner to produce the minor son of the parties at the children's park as designated in the said order for the purpose of visitation by the present petitioner and past incidental directions in that regard. So, however, since none appears to oppose the contempt application, we proceed on the premise that the order dated June 18, 2025 has not been complied with by the alleged contemner. Accordingly, a rule to issue calling upon the alleged contemner to show cause as to why the alleged contemner shall not be penalized in terms of the prayers made in the contempt application for willful disobedience of the order of this court dated June 18, 2025, passed in Can 1 of 2025, within bracket FMAT 166 of 2025, bracket closed, directing the alleged contemner to produce the minor son of the parties at the children's park at Gholai, Baliachok, police station Debra, district Paschim Medinipur, by not producing the child for such visitation at any point of time. The rule is made returnable on 8th May. May 8 এর আছে তো আমাদের পরে বেঞ্চ May 8, 2026. May 2026. Thank you. Good. এটা ওই ম্যাটারটার পরেই দিয়ে দেবেন, সেকেন্ড ম্যাটার দিয়ে দেবেন। ওটা 2 PM করা আছে, এটা সেকেন্ড ম্যাটার ছিল। কিংবা এটা ঠিক উপরে রেখে দেবেন, এটা আগে রাখবেন, কেন ওটা চলবে। এটা ছোট।
তোমার নামটা দিয়ে দাও।
Yes.
So I'm appealing for the petition.
Yes.
Pursuant to your
Yes, stop. Yes. You are appearing.
My lord.
What is the nature of the contempt?
Lordship, they have violated your lordship's order dated 25th of February 2025, appearing at page number 83. Lordship, the operative portion starts at page number 90. Your lordship, in paragraph 34, your lordship has directed rupees 30,000 to be paid per month. Thereafter, in page number 91, your lordship has directed how the arrear amount has to be paid.
What have they paid?
Lordship, there is a deficit amount of rupees 2,50,000.
What do you say?
My lord, and regular alimony is also not paid.
Not paid, not being paid.
No.
Now
There
it
is a
not paid.
deficit of 1,20,000 till today as per the monthly alimony, your lordship. And the arrear alimony, there is a 2,50,000.
My lord, prior to the filing of this contempt application, my lord, application for modification was filed, my lord. After service, perhaps this has been filed, my lord. That is on record. Your lordship, a directed application. So this is
application,
the affidavit of service, my lord. This was the application.
That is appearing today also.
Yes, my lord. Just check once.
No, this has been filed on November, and my contempt application on September, your lordship.
September, they could not have been written. My lord,
Lordship, my contempt application is filed in
can
September.
6 and can 7, both. Because, my lord, I'd like to harp on the order because
In September they have filed the contempt application.
no, my lord, then thereafter, my lord.
কোথায়
Then
ওই
applications have been filed there.
গুলো দিচ্ছেন না কেন?
My lord, the fellowship.
Can 6 and 7?
Yes, my lord.
Why 2?
My lord, 2, my lord, one is for bringing on record subsequent documents which have come into the hands of the, my lord, the present contemner with regard to, my lord,
Because interim alimony granted by us.
pending delete.
Pending delete.
My lord, what had happened, well, if fellowship takes my application, can seek.
Lordship, before your lordship takes up their application, there is a subsisting order of your lordship which has been violated.
Let us see if we modify that order, then the premise of the contempt may go.
My lord, what had happened is, my lord, if fellowship takes page.
You take your seat, please. Yes.
Page 22, your lordship's order starts from page 17, page 22, what I'll be referring to.
Can 6.
Paragraph 25.
Yes.
The submission was made that learned counsel for the appellant's wife submits on the strength of the affidavit of assets and liabilities of the wife that the wife does not have any income, whereas she has to bear educational expenses for her son, as well as expenses for her own medical treatment. Now, my lord, if your lordship takes the document, page 51, the appellant is employed, she has a job, not a contractual job, but she earns something. This was suppressed. And number 2, my lord, at that point of time, the son of the petitioner had already dropped out of college. The son had dropped out in the year 2023, and the son works in a catering business in the locality. Now, I have attached.
This is
her
not
card.
even temporary.
But she was working. That
This is nothing. This is meager amount.
Lordship, this fact has already been stated in my application. I can show you, lordship.
Very well, we will hear you on this.
And this is a premise, my lord, where the petition, the contempt of your lordship is a cancer patient. That is part of the order that was already on record.
Maybe. We have considered that and passed an order.
Yes, my lord.
There is no scope of review in a modification in a dispose of application. Otherwise,
modification because
review unless review tests are satisfied. You have to
these documents are not
material suppression. Yes, we have a power. Yes,
but it was not at the knowledge of the contemptor or applicant at that point of time. He could not. These documents are procured.
Not even a temporary job. It's not worth being called a
earning something. Well, kindly appreciate the position of the petitioner because number one,
we cannot reopen our order. Sorry, no.
Well, not reopen. Well, the quantification because this is not an willful.
Yes, quantification was decided on merits. We cannot reopen in a modification application. Sorry, no.
This is subsequent document which I have come across that was not presented before lordship at the point of deciding of
the college dropout. Where do we find it?
Well, page 48, the mark sheet. He had failed and thereafter he has been working somewhere. I have attached the photographs, but those are not conclusive. Page 48 is the mark sheet, my lord. 24th April 2023, my lord.
You go on fighting and your child will suffer.
My lord, that is not the case. He has been paying alimony from the inception. The proceedings have been dragging on. This is not a case where he has not paid. What has happened, my lord, because he is a cancer patient, the expenses are, my lord, he cannot presume what would be the expenses in the next month because he is undergoing treatment.
We have
And
considered everything in our order.
My lord, no, subsequently also he has relapsed, prostate cancer has spread. He's not even in a working position now. That is one aspect of the matter with regard to the contempt, my lord. And this perhaps this is not a
considered everything. We considered your affidavit of asset, your pleadings and everything.
Well, but at that point of time, these facts were not brought to the notice.
These two facts that she's working and he's a dropout.
Dropout, because specifically educational expenses 5,000 was decided by your lordship on that day. Educational expenses, he is working in a catering. He has dropped out of college at that point of time. This was decided in February 2020.
What does she earn? Have you stated here? She.
But I have attached the document.
This does not say about any income.
He did.
Where do you find the income? Her income?
Page 52. 52 is 53, my lord. The middle portion, a provision for engagement of total number of such and such workers has been created, and they are being engaged for 30 days in a month for rupees 175 per day. The middle portion. Workforce deployment for 3159 other rural GPs.
This is not a permanent employment. This is for 30 days.
30 days, my lord, this is the quantum which they are being paid.
Rupees 175 per day.
Meager amount, but something, because considers
this is not income sufficient to maintain herself.
I am not claiming that she won't be paid. My lord, considers the fact that
income cannot be calculated. Meager amount.
And my lord, kindly
it's not a regular income at all.
Kindly see, my lord, what is happening, my lord. The petitioner is paying. The difficulty, contempt arises out of irregular payment, not non-payment, because he has
not doing a charity, sir.
Well, this is not. I am being paying since the litigation started. It has dragged on.
Whatever you have paid, we are not reopening. We are not going behind our order in a modification application. This meager amount of 175 as some dengue procedural bahini, which is an absolutely temporary thing, and they are a vector control team. She earned for 30 days 175 per day. That's not an income sufficient to maintain herself. So therefore, this is not an indication. This is not a material suppression. That is what we will hold.
Well, the submission,
and we will also hear him to see whether he has shown it in there.
My lord, because
this dropout thing, 5,000 rupees has been given for the educational expense.
We'll hear him on that. Anything else, because he is undergoing treatment. And
undergoing treatment was before us when he moved there. We cannot reopen on that ground. Sorry.
No, I am not challenging, because this helps, because whatever is lessened, my lord.
That we can appreciate.
And this is not a case of willful obedience. That is my submission, because he has been paying, but the mode of payment was irregular because he had to take loan from his GPF also.
What else than willful?
Well, he has been making payment.
He knows about the order. His counsel was present. My lord, so that's willful. Disobedience means he's not obeying the order. Well, we are direct you to pay 2 lakh rupees, you pay 1 lakh. That is not obedience.
No, with regard to the area amount, 1,67,000.
Yes. We direct you to pay 2 lakh, you pay 1 rupee and say, no, it is not disobedience. No, sorry, no.
Well,
you have to pay, unless the entire amount is paid, it is definitely willful disobedience.
Well, on the later month, he has paid more than the amount, just to sum up with that. And with regard to the cost, that was paid that was paid within time, but contempt says it has not been paid. Well, this is the document to show that cost of 20,000 was paid within the stipulated.
Why didn't you annex it here?
Well, I have got hold of this one. The application
later on.
The application.
Let us say yes. What about this job and son dropout?
First of all, you lost this 30-day, which is appearing at page number 53. Well, 30-day we don't get, you lost it. Means the petitioner does not get 30-day job. Sometimes they are being called and perform their duties, and your lordship, I have categorically stated in my application, in my affidavit of asset and liability, I can show.
Show us that.
Lordship, today I did not carry that.
What have you said? That you were?
Yes, I am employed as an. Not employed, it's not a permanent job, your lordship, but I am working as a dengue procedural bahini. That is what I have pleaded.
This is you have stated. Yes,
your lordship, I have stated.
And what about this dropout? You have asked for education expenses.
Lordship, I don't understand. I have to take instruction whether he has been dropped out or not. But my instruction was
take instruction.
Very well.
We'll permit you to use an affidavit in opposition to this, so that you can point out this. Make it a short affidavit in opposition. You will get 2 weeks in any event till 8th of May in any event, because this bench is sitting on that.
Very well. May I bring on record this document with regard to this, with regard to payment of cost, because this is an allegation in the contempt, and I have paid within.
Don't you have the original?
Lord, as of now, I can.
Receipt you should have the no have
The
what
original.
your client should have the original.
Online 20,000.
You give a copy to him. We'll record this in your order.
20,000 cost.
That was paid
Online.
in time, but that is a pleading.
That
in
has
contempt
stated,
clause.
that has stated,
Online payment.
that has stated at paragraph number 12, your lordship. He has
that
paid rupees 10,000, 20,000. Though it was not clear to me whether he has paid
No,
that
the
for
contempt
recalling
is-
of your lordship's injunction order.
20,000 payment you have stated in your contempt application.
Yes, your lordship. Page 30, page 13, Roman 1. 20,000 in terms of your lordship recalling of the injunction order. That I have stated they have paid, but it was not clarified to me. So
you have stated about
yes,
20,000.
yes.
In the chart, they have stated, but in the pleadings, they said the cost has not been paid. That is why I have.
Cost
That
was how
was
much?
clarified to me. That was not clarified to me, your lordship. How can I say whether he has paid in that amount?
Learned counsel appearing for the alleged contempt submits seeks to press the application for modification of the order under contempt and the connected application প্রথমটা হচ্ছে order under contempt comma bearing can 6 of 2025 as well as the connected application for production of additional evidence bearing can 7 of 2025. Full sub next para. Learned counsel submits that that contrary to the pleadings in the alimony application, comma, on the basis of which the order was passed, comma, the appellant stroke petitioner wife is earning from her employment in the within double inverted dengue protirodh bahini. Furthermore, comma, the son of the parties, comma, on whose for whose educational expenses rupees 5,000 per month was granted by the court, comma, has been a school dropout, college dropout since before the date of
the age of this person, son,
passing of the order. What is the age?
graduation.
My lord, my lord, I'll just.
আমরা বোধহয় বউয়ের ওই টাকাটা দিতে হয় বলে বউয়ের এক্সপেন্সের মধ্যে ঢুকিয়েছিল। So next para, learned counsel appearing for the petitioner in the contempt application submits that the alleged job of the petitioner wife is merely of a temporary nature and the meager amount of rupees 175 per day is paid, comma, if at all the petitioner is called upon to do such work, comma, which is extremely irregular and does not amount to an appointment. Full stop next para. Furthermore, comma, it is submitted that such fact was not suppressed but disclosed in the alimony application and the connected affidavit of assets. Full stop next para. With regard to the allegation that the son of the parties is a college dropout, comma, learned counsel seeks to take instructions. Full stop accordingly, we direct the petitioner in the contempt application and the opposite party in can 6 and can 6 of 2025 and can 7 of 2025 to file his affidavits in her affidavit in opposition to the said applications within a fortnight from date. For sub reply, if any, shall be filed within a week thereafter. The applications, all the applications, including the contempt application, shall be listed next on May 8, 2026.
So far the contempt application is concerned, they are admitting that there is a arrear amount which they have not paid.
There is already a direction. We'll send him to jail. What else can we do?
Great.
Great. In contempt, our hands are limited. Yes. We may ask you to disclose your assets also, other assets.
But he will, because he has already pleaded that in the application also.
In that
application also, because well, he earns 80, 30 has been given, and he has been paying long because, and he has to he had withdrawn 6 lakhs from GPF just to pay her, and he has paid. This is a bona fide conduct. That is what I was trying to submit. Grateful.
Item number 5.
And, no copy of the affidavit has been served upon me.
Number 5, my lord, I beg to apology, my lord. Just yesterday it has been affirmed. No, they could not be served.
Why? Because the bench is sitting today. That's why it was affirmed yesterday.
No, I don't think. Just affirmed yesterday, my lord.
If you would sit next week, you would be affirming next week.
No, I'm just serving here, you know.
I think they are
cost. This
is a contempt application.
It is a contempt application.
Delay in filing affidavit is itself a contempt, sir.
No, my lord, they have alleged some things, my lord, the payment has not been done. I annexed the documents.
Well, Mr. Bhattacharya, file a reply to this, will extend the time.
Lord, earlier, my lord, on 3 occasions they failed to file their affidavit, assets on liabilities. For that reason, my lord had imposed cost upon them. Thereafter, lordship had accepted the affidavit of service, affidavit of assets and liabilities, and then it was again the same conduct.
No, this is not the contempt.
Again, the same in the main application, lordship had imposed on 10,000 rupees cost. কত the 27th March for that? No, 27th March না বের করো।
কি বলছো?
হ্যাঁ।
That is not my knowledge. Take copy টা নাও। Receive করো। তাহলে আপনি receive করেছেন।
No, we had condoned the delay in filing affidavit.
Definitely, but subject to payment of cost.
No, no.
আরে পেমেন্টটা দেওয়া হচ্ছে না, কন্টেম্প্ট হয়েছে, পেমেন্টটা দেওয়া হচ্ছে কিনা? পেমেন্ট দিয়েছে, ডকুমেন্টস ম্যানেজ করে
26 March order.
My lord, kindly see, my lord, 10th March 2025.
Acha.
25.
Yes.
10th March 2025. Yes.
That is not my knowledge.
Paragraph number 9.
Yes, cost. That was cost for what? Affidavit of
asset. Third failure to file, my lord, the affidavit of asset. Again, the same conduct. Mr. Banerjee, Dutiman Banerjee appeared.
Yes, yes. And thereafter also we condoned.
Yes.
After that also there was delay there which we condoned. Yes, pay 10,000 again. This is matrimonial.
Matrimonial.
So
they have
you get your alimony in this manner.
And my lord, another thing, my lord, 19 appeal, my lord, not taken any steps, my lord, for my lord, preparation of paper books, LCR, nothing.
Was there a direction or direct right?
না সেটা বোধহয় ছিল।
ভায়োলেশন করেছো, ভায়োলেশনটা তুমি ডিসপোজড হয়ে যাও।
No, no. You first pay 10,000 cost for this also. You have a history of this sort of delay.
No, that is not my knowledge.
No, your client's knowledge must be there. So we are imposing 10,000 again. This is your first default in this.
No, this is not the first default, my lord. Last occasion, my lord, I appeared. My lord says direction.
In another order, my lord, 1 lakh rupees also there. Cost. Next order. Since they were not accepting notice, 1 lakh rupees cost. That is also.
Sure, we will adjust it with the alimony then. Your entire grievance is solved. Which order?
11th February. 11th February 2025.
Earlier.
7. Para 7.
Probably that is why Mr. Banerjee has been removed. So we'll ensure that you are also removed. Some third.
I do not know. I have no knowledge.
Yes, yes. No, ad hoc amount.
Ad hoc amount, yes.
They were not paying, that's why ad hoc amount of rupees.
So far, my lord, the relating to the order, my lord, compliance of the order, my lord, the allegation, the payment has been done. I've annexed the documents, let the verify.
We will accept the application by the allegations in the application by non-traverse. We will not accept this affidavit in opposition. It's delayed. When did we direct you? Let us see.
27th of March, 1 week.
27th of March, 1 week. You have affirmed it yesterday.
My lord, it has been affirmed yesterday.
So 1 month late. Not 1 month, not less than that.
1 week is.
So we are accepting this time. Learned counsel for the alleged contemner seeks to file affidavit in opposition and also prays for condonation of delay in filing the same. Full stop. Learned counsel for the petitioner points out that on a previous occasion as well, since the affidavit of asset of the husband/alleged contemner was filed after getting 3 opportunities, costs of rupees 10,000 had been imposed for such conduct on the alleged contemner. Full stop. Again, at the present instance, a similar mode of conduct has been adopted by the alleged contemner, and as such, the affidavit in opposition ought not to be accepted. Full stop. However, considering that this is the first default with regard to the present application, We condone the delay in filing the affidavit in opposition and accept the same. Full stop. The time for filing reply thereto is extended for a fortnight from date. Full stop. The matter shall next be listed for hearing on May 8, 2026. 2026.
Milord, only one thing, Milord, if your Lordship would kind enough to see, Milord, volume 1, R1, page 15. Milord, this is for prima facie hauling them off for contempt. Milord, if your Lordship would kind enough to see the affidavit in opposition, which
So
has
that's
been
why you directed affidavit.
Yes.
Their affidavit?
Yeah, their affidavit.
Which page?
Page 15.
Why 2 affidavits in opposition?
Volume 2 volumes, Milord, up to 116.
Documents is a payment documents, the bank's transaction.
The payment.
Right. Which page?
15, R1, annexure R1.
First page.
Yes.
Milord, kindly see, Milord, amount which has been credited, Milord, is 40,000. Milord, my Lord's direction was composite 60,000. Milord, this is sufficient for Milord holding them in contempt.
Let the affidavit deal with the affidavit. Not only that.
They're relying on your affidavit. 40,000?
That's true. These other documents is there. Let them verify all the documents.
You have to pay amount, a composite amount of 60,000 per month.
60,000. All
Where
the
is the
documents.
we find only 40,000.
40,000.
You show us.
Only school fees. Like the paid to the BDM International School directly. Admission.
That was not the direction because Lordship had concerned educational expenses.
Total had directed you to pay. We had directed you to pay rupees 60,000 per month. You have paid 40,000.
Other documents.
Where are the other documents?
Kindly see.
Why wasn't it paid compositely?
Verify the document.
No. On the basis of this, we'll haul you up.
I submit before Lordships.
What do you submit?
That is the paragraph 2 have stated.
No. Show us the documents.
Yes, documents annexed to paragraph 2 have stated all the things.
Forget your paragraph 2. Show us the documents you have paid. So loud in a contempt application. Let us see how far you have committed contempt. Don't be so loud, Mr. Maiti. You are in contempt. And you have paid only 40,000.
I am not shouting Lordships before Lordships.
Yes. Show us that payment. We are shouting. 40,000 paid. We directed 60,000. We'll direct personal appearance of your client. You're already in contempt and you're at the top of your voice, defending your client.
1 minute. 1 minute.
1 minute. This is expressive contempt.
Lord, the annexure R5, page 97.
Why separate payments? This is 4,000, 3,000. What are these?
This is the, my lord, the one is the school payment has been 40,000.
We did not segregate anything. We directed you to pay 60,000 per month. Are you supposed to calculate this 2,000, 3,000 at odd amounts? And these are not paid in time, paid in different times.
Well, I come back, my lord. I come back.
Insofar as Milord,
anyway, come back on the next occasion.
Yes, Milord, I am indicating to my learned friend, Milord, direction was from the date of filing of the application. No indication regarding arrears also in the affidavit, and the litigation cost also. Those were also directions.
Very good. Come back, point it out in
I will file a reply to this.
Mr. Maiti, ask your client to be careful. We are telling you. And we know how to stop arguments in a contempt application if you're in contempt. We know how to control our court and ensure that our orders are complied with. Get it very clear from us. Next.
Time to file reply, Milord.
We have given fortnight's time. The matter will next be listed on 8th of May. May 8, 2026. Next. Yes, Suiza.
Item number 6, I'm appearing for the petitioner.
Yes.
This is a contempt application. We have filed non-payment of the alimony. On last occasion, also
soft copy on the other.
Yes, the pleadings have been completed. Even they have prayed for a recalling of the order. So that is can 3.
Let us hear the recall first.
Yes.
Well, in item 6,
yes,
Malad, I am always submissive and very polite, Malad, to your lordship.
Thank you for that. We are grateful for that to you. What is your matter?
But in contempt, I be more polite. Now, my lord, I have 2 points. The order which was based, my lord, kindly first come to the ordering part. What your lordship has passed.
Yes.
Now, my lord,
This is the
kindly check.
5th of March order.
Mine.
Right.
Now, kindly see, my lord, paragraph 3.
Paragraph 3, yes.
It is submitted that the daughter of the parties is now studying class 12 CBSE board and is studying science. Kindly underline that. Is studying science. The premise of my lord's order that the daughter was pursuing and studying science, so a huge expenses are required. And now on the basis of this, my lord, now my lord kindly takes up my lord's order. See paragraph 7, next page.
Yes.
The opposition.
We have carefully perused the application and opposition as well as the reply and affidavit of assets by both the parties. Now, my lord, pause here for a moment. Kindly say, takes up the asset filed by the wife. My lord, kindly takes up page 67, affidavit of asset filed by the wife. And on the day, my lord, when the wife had filed affidavit of asset, my lord, the daughter became major, but still, anyway, though she was not a minor, but mother was taking my lord cards of her. Kindly takes up page 67. Lordship has found, my lord?
Yes.
Kindly see BDM International, Lordship has found?
Yes.
Just right side, class 12 HUM. In all probability, it stands for humanity.
Humanities, yes.
So, my lord, the premise was absolutely wrong. Now, my lord, again go back to the paragraph 7. Upon granting the husband the benefit of statutory deduction on account of PF and income tax, the husband monthly income such and such, such and such. We have then, my lord, para H. Then, my lord, lordship has counted this. So far, the wife's income is concerned and the maintenance, my lord has recorded satisfaction that the husband has regularly discharged before the district court. There was no infraction, no negligence. Now, my lord, kindly see only for para 9. In so far as the daughter is concerned, she is studying in 12th standard in a CBSE board school, having opted for science stream and has several expenses commensurate with the needs of a growing girl of her age. Now turn to the next page, para 10. Although we don't subscribe to the claim of the wife to the tune of such and such per month for a daughter, as disclosed in the wife's assets and annexed to the application for alimony application, we are of the opinion that an amount of rupees 18,000 per month would suffice to meet the liability of the husband for expense of the daughter. This is something, my lord, which with the deepest of respect was, my lord, taken, my lord, and we are put at a scapegoat. And I can tell you, lordship, I have personally talked to the client in presence of my advocates and juniors and have inquired. Father has, my lord, much love for her, for his daughter. He literally cried before me. He said that since, my lord, she was 6 months baby, her mother took her away, and she even, my lord, doesn't even want to talk to me. I even text her several messages. She, my lord, has called me by my name. As you want to talk to me, and I have, and she has given me, my lord, 100 and 1,000 pages of transcripted WhatsApp and WhatsApp talk. She said, my husband, the father said, then why don't I bear? I have been bearing her for 18 years and odd. But something should have been told to me also that what she is studying.
What about the science?
Now,
First answer to my.
Now, my lord, I have not yet completed.
Will kindly comes to page 59.
Yes, something else. Yes, complete.
Now, my lord, kindly takes up the contempt application. Also,
no, we are now hearing your the modification application.
Yes, modification application. Well, modification they have.
Yes.
They have taken out an opposition to it.
They have taken out an opposition. Yes.
Mild. See page 9.
Appropriate orders is can 3 is your application for
mild. For the change circumstances. Well, right. I have the other fold of submission also. I'll be coming to that.
Achha. Yes.
Now, page 9. See,
page 9 of
their opposition to my application for appropriate.
Opposition you have filed, Mr.
Yes, yes. File kore to.
Just check up for the opposition ta kothay?
Mr. Dotto, Mr. Shorodit Dotto, if you have a copy with you, kindly.
No,
give it
we'll
to the
find out the origin.
my.
থাকবে এখানে দেখে নিন না মিস করে যাচ্ছে।
And so far the contempt is concerned, we have used our opposition, but they have not dealt with any of our allegations.
Acid na এখানটায় না can see আর contempt. We don't have any opposition.
Well, it was recorded in the order.
We have also issued a reply.
Reply has been filed previously.
No. Well, affidavit in opposition filed in can 3 is kept on.
এই তো affidavit in opposition নেই গেলে কোনটা? This is an opposition to can 2. What is can 2 is something else.
No, can 2 is something. Can 3.
No, can 2 was the application for enhancement. This order was passed on the enhancement application.
Yes.
Opposition. Can 3 চাইছি 3 এখানে দেখছি এখানে এই যে তলা ঢুকে আছে অ্যাপ্লিকেশনটা তার সঙ্গে থাকবে তো yes we have found it out file or reply yes
but I'm sorry
you are referring to some page of the opposition yes please we have found out the opposition
my lord I'm sorry my lord there were some disconnections
no yes which page
well my lord page I'm sorry my lord just
yes
a moment my lord page 9 to their opposition
yes
to my can 3
yes
the first annexure discloses my lord C Sri Shikshatan College then name then my lord BA and JMC I have inquired and I understood journalism and mass communication. So my first point is my lord we have to be very fair and honest. I understand my lord there would be some liability either of the way other mother has also some liability. Now my lord my second fold of submission is my lord on the day when your lordship has found my lord or specifically on the basis of my income and expenses my lord I have been paying and discharging till the time my lord I was in
Mr. Basu the session fee from page 9 session fee appears to be 34,860
yes
so loving father
now my lord if 38,000 my lord if she has joined in such a costly my lord college which my lord doesn't even my lord bear my status and situation where I was not even put to know that what she is studying where she is studying whether my lord I can say my lord there are many other colleges where journalism and mass communications are also being taught.
It is very evident that you are not happy that your daughter is studying in a good college.
No, I'm not.
It's one of the better colleges of Calcutta.
My lord, I do not say that. My lord, the Jadavpur University also.
For half a year.
Yes.
So it comes to how much per month?
34,000. It comes around 6 4 12 34 by 6 by 6.
Now, my point is,
6,000 something. Of what we granted? We granted 12.
Well, now only this is the fees. After that, Lordship will kindly clarify. My learned senior friend has represented something. I'll just clarify that point first. Lordship will kindly take page 59 with your Lordship's order at paragraph 3. How this is interpreted, Lordship will kindly see. First point what my learned senior friend has taken.
Of what?
Lordship will kindly takes page 4, the paragraph 3 of your Lordship's order.
Yes.
Lordship has recorded. It is submitted that the daughter of the parties is now studying in class 12 of a CBSE board school and is studying science, which is also reflected from the laboratory expenses borne by the appellant for the study of her daughter as evident from the annexures to the wife's pleading. Now, Lordship will kindly take page 59 of my lord, that can application, which page 67 was referred to your Lordship. The first, can 2. Can 2 now? Can 2 now. Affidavit of assets. I'm extremely sorry. Affidavit of assets. Affidavit of assets. Lordship will kindly take.
Affidavit of yes. This is their affidavit.
Our affidavit of assets. This.
Yes.
Now Lordship will.
You are
they have referred. Now, Lordship will kindly take page 59. Why Lordship recorded such thing? It was not misrepresented by us. Like page 59, this is a payment.
Lab.
Yes. So, my learned senior friend has.
No. He stated that it was science stream, but it is humanities.
No. Well, what I'm showing before your Lordship, this is the fees that was raised by the school that we have stated over here, and Lordship has recorded that only.
Science was not stated by you.
No, Lordship will carry lab fees. Lab fees was there, 3,500.
Lab fees is different, but have you stated in your
yes,
application?
No, but not in
that she's studying in science.
Your Lordship recorded on the basis of annexure, paragraph 3.
No, have you stated anywhere where
No,
she's studying? Let us see what you have stated regarding her studies.
Yes. Application welcome. Moreover, father is not paying since June 2025.
That will take care of.
We have, as per my instruction, I think I have not stated anywhere. That enhancement.
In your application for enhancement, let us see that. Can two is
yes,
that application?
Yes, madam.
Yes.
Well, I'll try to, madam.
So we proceeded on the basis of that lab.
Annexure. Yes, madam.
So even if we proceeded erroneously, Mr. Then Mr. Chattopadhyay, then it's our error. Then
not erroneously, madam. Lordship has recorded that this is the bill raised by the school. So lab fees for your Lordship has recorded that, madam. It's not that something has come from the bar. Not is written.
Then if we were wrong, then we should correct it.
Your Lordship is not wrong. Your Lordship has recorded on the.
She's not studying in science stream.
Even if that today your Lordship has specifically stated that 18,000 is the minimum expenses that is required. And now
we calculated probably 12,000 for the education.
No, your Lordship calculated 12,000 for the wife.
Oh, achha.
And 18,000 for the daughter. Now 6,000 to 7,000 is only required for the education. So remaining in hand is 11,000. Well, in 11,000 she has to take the entire day's expenses, meal, other tuitions, everything she has to take. So, my lord, that is what my learned senior friend has stated before.
Let Mr. Basu complete on the other aspects. Yes, Mr. Basu, what about the other?
My lord, the other parties is, my lord, if your lordship kindly takes
Science is one, and what about the else?
My lord, the other part is a change of circumstances. My lord, on that day, my lord had duly considered, my lord, I was in job and earning a money. My lord, and I had complied my lord's order till the time I was in service and I had earned the money. And under I stand correct, I earned the salary. Now, my lord, I am, my lord, no more in a job. My lord, that is, my lord, my lord, a second point of submissions that there has been a certain change of circumstances, which I most humbly beseech, my lord, I have also disclosed the document.
One point.
My lord, kindly.
Cannot have a rally between you. Take your let him complete. Yes. Which page?
My lord, may kindly comes to.
You have given a resignation.
Yes.
The resignation I was asked for is a private concern. Lordship knows, my lord, if they terminate, then I could not have even, my lord, opted for any, my lord, another job, which I say even.
It is a common practice, Mr. Basu, to give a resignation to a present company and join some other company without the of which the wife does not have knowledge. This is a common practice nowadays. In every other matter, we are seeing this.
My lord, with the deepest of respect, in private concern.
You have resigned of yourself. You cannot absolve yourself of the liability for that.
My lord,
what are you doing at present? Where have you stated? Let us see.
My lord.
Resignation very fine. Now, what are you doing now?
Now, my lord, presently, my lord, I have stated, my lord, that I have been trying to search a job. Now, I am also, my lord, at the age of 55, 56 years, or rather, my lord, if I stand corrected, I have in my affidavit, my lord.
What is your qualification? What is your qualification?
My lord, I am a graduate. My lord, that I have to take instructions, my lord, more precisely, since it has come from your lordship.
What was your designation in the previous job, Mr. Basu?
My lord, regional sales manager. That page 8 would appear.
You must have some. You are 55 years of age, regional sales manager. You must have some experience.
My lord, that is what.
Huge experience. So you must be somewhere else. Let us see your statement regarding that. Let us see.
My lord, it is not that, my lord, that
come to the paragraph, Mr. Basu. Come to the paragraph. Not oral submissions.
Exactly. Well, it comes to, my lord, page 5.
Yes.
Or rather page 3, man. Kindly comes to page 3. that at the time of the said order, he was employed in such and such regional sales manager. However, shortly thereafter, the company underwent a significant operational restructuring. Has your lordship got minute? My lord, due to diminishing profitability in the eastern region, the management decided to gradually shift its base and such and such operation of southern zone. The corporate decisions led to the gradual downsizing of the workforce in the region, and in the petitioner's role as regional sales manager was declared redundant. He was left with no option but to tender his resignation, effectively ending his career with the company. This sudden and involuntary termination of his employment was a crushing blow, rendering his years of experience and dedication, Millard, void overnight. Now, Millard, this is why I say so, Millard. I have in para 1, Millard, I have said with all humbleness that this is due to a drastic and unforeseen change in the financial circumstances of the husband.
Then Mr. Basu will carry on the next day.
My lord, I shall mention.
No, one thing, Mala, after the receipt of this order, Mala, he has resigned from that because 28th March he has given the resignation. Mala.
Point that out on the next one.
Mala,
only one thing I'm praying for Mala, since June 2025, not a single penny has been paid, Mala. Mala, Lordship will kindly consider this, Mala, to at least to say something, Mala. At least, Mala, he should pay something to us.
Mr. Basu, you are not paying anything?
Nothing.
You don't have any case regarding the wife.
No,
so why not pay something for the daughter also?
Millard, I have talked to my client, Millard. I have requested, Millard, I rather tried to arrange
some money. We are talking to a client now through our order. We'll direct you to pay an ad hoc amount. What is the arrears as per?
3.5 lakhs as of today.
Millard,
pay 1 lakh. Pay 1 lakh, Mr. Basu.
Millard, may I say this? Lordships, Millard, do not need to put it in a judicial order. I can say, Millard.
We will.
Millard, I have already told my client, Millard, to arrange some money.
Paucity of time, the hearing of the application filed by the alleged contender for modification of our previous order cannot be completed. Who's up next para? However, it is pointed out by the counsel for the wife that the alleged contender stroke husband has not paid a single paisa in terms of the order of which recall has been sought. Who's up next para?
No,
since June 2025.
We have paid.
Since June 2025.
Yes.
Who's up next para? Learned counsel for the alleged contender submits that some amounts have been paid. Who's be that as it may, the alleged contender shall pay an ad hoc amount of rupees 1 lakh to the appellant wife by online transfer. He has your account.
I have annexed the details of my account. Only can
by online transfer to the bank account of the wife,
yes,
as disclosed in the contempt application.
Contempt, he is also paying when we used to pay, Mala. So he has the details, Mala.
Millard, would I suggest, Millard, let them, Millard,
within a fortnight from date. Who's up next para? The matter shall next be taken up for hearing, further hearing on May 8, 2026.
Yes,
Millard, may I make one
Make the payment, Mr. Basu. Make the payment.
No, I will be making payment. My lordship says.
Reply, my lord, to the can 3.
Oh, thank you. The affidavit in reply filed today in respect of can 3 of 2025 be kept on record.
My lordship says, 1 lakh within a fortnight. May it be a little lesser amount, or in an installment.
1 rupee less. 1 rupee less. 1 rupee concession. Choito shell.
Next thing.
Item number 1.
Lordship, I favor the petition.
But I beg to appeal, Lordship, for the contempt, Lordship.
Yes, yes.
Last day we submitted that we have prepared one SLP before the Honorable Supreme Court against the order dated 4th of February.
Right.
And my lord was pleased to made certain observation and to bring appropriate order.
Before the division bench.
Lordship. Division bench, yes.
Against the order of the division bench, they had pleaded that they would file an SLP. They have filed the SLP order.
No, division bench affirmed
the order and
against that
SLP.
SLP.
My lord's order was affirmed. At the same time, some more directions have been given, which were not included in my lord's observation.
What happened to the SLP?
SLP, my lord, that has been filed only. This is, my lord, the copies.
Just recently we have filed a
yes,
caveat.
yes.
Recently only it has been filed.
It is recorded on, my lord, it is filed on 7th of April. 7th of April. 4th February is order. 7th of April, it is filed. That is the communication. Though we have requested them immediately place it and take appropriate step. That is
how much time should you give to the Supreme Court to dispose it of?
That is not in our hand. We are.
You have to take steps, Mr. Nayak. We have to put some pressure on you. Otherwise, you won't have any handle to mention. We must put in something in our order so that you can mention before the Supreme Court that the court is not giving time.
Lordship knows better than me. So Lordship make appropriate observation so that we can also, if that is required. But this is the only, we are handicapped here.
What will be a reasonable period? You are the dominus litis in the...
1 month at least. Lord, kindly allow us 1 month time. As your Lordship knows.
Lordship, I have no issue, but what they're doing is they are not even giving the recent bills. They are not, recent months bills also, they are not releasing. They have not adjusted. They have still now imposing interest on the their whatever bills they had raised. They are imposing interest also, and they are imposing interest. They are saying they are going to increase the interest.
That is contrary to the judgment of the division bench also.
Yes, your lordship.
Mr. Naik, you take care of that. You cannot go on flouting the order. It's still there.
One thing, Milord, on instruction, Milord, line has not been disturbed. With regard to raising of the bill and making payment of the bills, that is, Milord, the disputed and some more amount is to be adjusted. These are the directions.
We will have to pass an order in the contempt, although it's beyond the scope of...
Only, Milord, our
submission. You cannot disconnect the electricity.
We entirely leave it to your lordship. We say, since, Milord, the entire order has been challenged and, Milord, this is the situation, my lord, give us...
We will record your assurance that you are not disconnecting immediately till the contempt is decided.
Till the SLP is decided.
Sorry, till the SLP is decided. But taking advantage of that, you will not pay.
I will pay for the recent bills, your lordship. I will pay for whatever recent bills.
Getting the outstanding only.
Outstanding only. What they are doing is they raised LPSC charges, your lordship, of 30 lakhs while the matter was pending before the division bench. They kept on charging interest. Now the recent bills, they are not even handing over any bills.
No,
the recent
months. The outstanding bills in the meantime.
No, lordship.
Then you are in continuous contempt.
We cannot do. Now, my lord, what subsequent period?
Subsequent current bills you raise.
Current bills, they're also not raising. They're not raising any current bills also.
That
you raise the current bills, Mr. Nayak, you raise on them the current bills, and you indicate something in your current bills that this will be subject to the result of the SLP or something like that.
Lordship.
Learned counsel for the alleged contemptor submits that the special leave petition filed against the order of the division bench, partially affirming the order of this court, is still pending, and hands over an information slip to that effect. Next para, learned counsel for the petitioner submits that taking advantage of the pendency of the matter before the Honorable Supreme Court, the alleged contemptor is continuing to raise bills for outstanding amounts.
Your lordship, they are not raising the bills now. They were doing so before. Now, so they are not raising any bills.
Are taking undue advantage of the pendency of the matter before the Honorable Supreme Court, the alleged contemptor is not raising even current bills, thereby jeopardizing the continuance of electricity supply to the petitioners. Learned counsel for the alleged contemptor submits as per instruction, that the electricity connection to the premises of the petitioners has not yet been disconnected. Be that as it may, the alleged contemptors are directed to raise current bills for the consumption of electricity by the petitioners, which shall be duly paid by the petitioners, without prejudice to the rights and contentions of the parties in the pending specially petition with regard to the outstanding bills. To sub next para, the alleged contender will shall be permitted, comma, while raising the current bills, comma, to indicate in the concerned bills as to such bills being subject to the outcome of the SLP insofar as the outstanding dues from the petitioners is concerned.
Your Lordship, will
They will
they
raise
also,
current bills. They'll indicate in the bills that
will
this
they
is
be
subject-
charging also increase? What they have been doing previously is they have been charging interest, LPSC charges on the outstanding and have been increasing that. Will they were doing so of 30 lakhs, they have
They
charged.
clarified that only this
Only the outstanding will be there, no interest.
city bills for only for current consumption.
And no, our interest may be charged on the outstanding, Your Lordship, in the meantime.
Only for current consumption. Yes.
The matter will appear.
The matter will appear next on
6 weeks, Lordship, at least.
6 weeks.
Because they are not.
Keeping in view the pendency of the SLP before the Honorable Supreme Court, comma, let the matter be listed next on 12 June.
Your Lordship,
June 12, 2026.
My apprehension is what they had done before. They will show the outstanding 40 lakhs and they will add on charges and increase the 40 lakhs to 1 CR like that during the pendency. They will show the outstanding.
SLP goes against you, then you'll have to pay that amount.
But the interest.
Put that amount in a bank.
After all, they are not suffering. My Lord's order will protect them. We are also obliged to do it. But Lordship, during that period, perhaps Supreme Court will be closed. You know, that June.
We don't know.
July normally up to
move it immediately on the ground of
we shall certainly try.
Yes.
Get full lunch.
Thank you. Yes. Two. Yes. Yes, Mr. Channel.
Sir, Achint.
What have gone?
No.
Still there? Yes.
No, ওটাই ভয় পেয়ে গেলাম.
He was very facial expression. Yes.
No, this is an application for under the title of the application, the application for clarification and modification of your lordship's order dated 14th August 2023.
Yes.
I just take your lordship's order of your lordship's order is not at all a longest order.
You are the respondent in the petition.
If my lord so please, you can come back after filing affidavits. There is no scope for any interim order. No point.
What sort of clarification you are wanting, Mr. Channel? Just give a.
I give your lordships.
Is it necessary? Opposition?
Yes, because my lord, person to my lord, kindly takes 469.
Annexures are there.
Yes, 469.
That's your lordship's order.
Order.
Yes.
My lord had asked him to give the exact millard unit charge. Now millard also give millard kindly takes millard page 474 start the penultimate paragraph accordingly.
Yes.
Accordingly, WPN such and such is allowed on contest, thereby setting aside the bills raised by CSC Limited against the petitions for the month of May and June. Those are two impugned months. Such and such against the petition which are impugned in the present writ petition. The CSC shall raise fresh bills indicating the exact breakup of the charging of the amounts in the said bills for the said months, incorporating the previous dues. Millard, these two millard, they are saying that they are facing difficulties in getting the exact units. Now, the exact what they are saying, it should be converted, millard, clarified by lump sum. Now, millard, with the millard disposing of that, kind of takes 475.
Some is permitted by their regulations or those regulations also.
Yes, kindly takes 475.
It cannot be calculated.
Yes, kindly takes 475.
Yes.
Again, the penultimate paragraph, millard, it is made clear that in the event after CSC Limited issues such fresh bills in compliance with this order of this court, the petitions have a further given regard to the backup quantum or any other factual issues. Millard, we are relegated to approach the grievance redressal cell. Millard, we have already approached. Now, Millard, we need to bring this to your lordship's notice. Millard, filing an affidavit because Millard
that if the order is modified,
then Millard, my pity, Millard, this my this
will
goes.
become, it will go.
It will go.
It will go.
Now, Millard, now, Millard, they have come up after Millard more than
because your grievance that grievance will go. We cannot. Refuse their prayer on that ground.
No,
that was
Millard, only Millard some factual issues which Millard I also need to Millard bring.
Even after modification, still they have a grievance. They can still go.
You can argue on this. Whatever is happening.
Give me 2 weeks time, Millard, so that I can disclose the at least I should.
bring this.
That will also be equally thick.
মালাট না শুনতে পাইনি কি বলছে
এত মোটা থাকবে
হ্যাঁ শিওর
মোটামুটি চেষ্টা করবো কম কম ডকুমেন্ট
মানে I'll make it shorter.
Yes.
I'll reduce Millard. Without annexation, Millard.
That will be the maximum number of pages. We'll specify that in our order.
মিস্টার উপাধ্যায়'s briefটা দেখ ওই রকমই হবে
Learned counsel appearing for the respondent in Can 1 of 2024 seeks an opportunity to file an affidavit in opposition to the said application. Accordingly, the respondents in the respondent or respondents.
Respondent.
No, writ petitioners there were two.
Acha, respondents.
Accordingly, the respondents are directed to file their affidavit in opposition to Can 1 of 2024 within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The matter shall next be listed on May 8th, 2026.
For this season, we have converted into repeat text.
Into liquid, yes, absolutely. Rightly so. We are trying to, but there are certain hindrances, administrative hindrances we are not being able to. We've been trying for a long time. Us.
This is the brief, Millard.
It will be easier to exchange documents also if necessary. Yes. Yes, please.
I have filed one application for modification, my lord.
Right.
ওইদিকে petitioner. না এখন petitioner তুমি তো read petitioner.
You are for the railways.
I am for the railways.
Yes.
So I am first placing my lord's order.
Yes.
At page 11 of my application. The petitioner has made out a strong prima facie case as to the respondent authorities having deviated from the multi-purpose stalls policy which stipulates that minimum license fee fixed shall not be less than 12% of the estimated sale turnover for the corresponding period. By not giving effect to the joint sales assessment with regard to the stalls run by the petitioner, but asking for exorbitant license fees. It transfers prima facie from the impugned communication dated November 9, 2023, annexure page 44, annexure P6, that the claim of the railway authority is disproportionate with the joint sales assessment for the particular division in question, that is the Howrah division of the said railway. Accordingly, respondents shall file their affidavits of opposition within 3 weeks from the date received thereof, if any, shall be filed within.
There is a question of modification. You file your opposition and let us hear out the writ petition.
No, they are occupying, my lord, in spite of expiring the tenure.
So where is the question of modifying this order? You have to file an opposition and point out.
My lord, because my lord, by virtue of this order,
yes,
they are now possessing this portion when the tenure of the license has been expired, my lord.
So there is no scope of modification. I don't find absolutely any scope of modification of my
lord. What I am
before the regular it could and file your opposition and get it canvassed.
My lord, I am submitting one thing, my lord.
Yes.
Due to this interim order, although there is no specific order not to take the position, since the matter was moved when there was the tenure was on, and during the pendency tenure was over. So this order shall not prevent the responsibility. I am just making one clarification. This order
from doing what?
This order shall not prevent the railway to take appropriate steps for taking possession due to the expiry of the tenure.
Yes, what do you say to that, Mr.?
First of all, the issue before my lord during the petition was that the amount which I am depositing as provisional license fee was.
No, that issue still remains.
Remains.
There is no question. This is stay of operation of the impugned claim only.
Oh, my lord.
Now, why the case made out by the
no, if there is a subsequent cause of action by the expiry of your tenure, then why should they be prevented by this order from taking steps?
So the order, kindly have a look at the
I'll clarify that this does not prevent them from taking action subsequent.
With that, any which ways they were always nothing prevented them from carrying out, because the order was as simple as it. 2 annexures
will dismiss the modification application with the finding that we are dismissing because there is no scope of modification And this order does not prevent them from taking action on any subsequent work.
Subsequent.
If they have a right in
Have any.
Yes.
If they have. And also that the contention made by them is that we have not been making payment, which is not incorrect. In my
I'll not go into that. I'll say that whatever contentions regarding the merits of the writ petition, since affidavits have been directed, you disclose in your affidavit.
And this will not prevent the railway authority to take appropriate steps for recovery of position.
This does not prevent.
That
I'll
does.
say. This does not.
it was not
The inception it was not
No,
prevented.
no, because in my lord's order, two letters were mentioned. In one letter, it has been stated that stay of the two letters. One of the order that this was the notice if you don't pay within 15 days.
Pay that claim. It was
Yes,
that
closed.
claim.
Your stalls will be closed. That comes within the purview of this order.
Very.
So clarify this position.
Learned counsel appearing for the applicant in the modification application, that is the respondent in the writ petition, submits that by the order dated January 5, 2024, passed in WPA 177 of 2024, this court had directed stay of operation of the impugned claim dated November 9, 2023, within bracket annexure P6 at page 44 of the writ petition, bracket closed, as well as the communication dated December 13, 2023, bracket annexure P-9 at page 53 of the writ petition, bracket closed, till a particular period. Full stop, next para. Learned counsel submits that by dint of the said order, despite the subsequent expiry of the tenure of the license granted to the writ petitioner, the respondent authorities within bracket present applicants, bracket close, are precluded from taking any action for action in accordance therewith. Full stop, next para. Learned counsel appearing for the writ petitioner submits, writ petitioner stroke respondent herein, submits that certain allegations, certain incorrect averments have been made in the application for modification. Full stop, next para. Be that as it may, insofar as the allegations made in the modification application pertaining to the merits of the writ petition is concerned, there is no scope for entering into the same at this juncture, since affidavits have already been directed to be filed in the writ petition. Full stop, next para. Inasmuch as the apprehension of the present applicants to the effect that the stay order granted by this court would preclude the applicants from taking steps on further cause of action is concerned, such apprehension is misplaced, since by the impugned order, only the claim dated November 9, 2023, made by the present applicants was stayed, as well as the consequential communication dated December 13, 2023, which was a fallout of the self-same claim. Full stop, next para. In the first place, the order dated January 5, 2024 did not preclude the present applicants from taking recourse to law in the event any subsequent cause of action arises. Full stop. Hence, there is no scope of modification of the impugned order on such misplaced apprehension. Full stop. Accordingly, can 1 of 2025 is disposed of in the light of the above.
My submission is, my lord, we are unable to take the position. Just what use
position we won't permit you to take position.
Because no,
it is accordingly clarified that nothing in the order dated January 5, 2024 precludes the present applicants from taking steps in accordance with law in respect of any subsequent cause of action if arisen against the writ petitioners vis-a-vis the stalls in question. It's blanket. Any subsequent cause of action, you can take steps in accordance.
This is confined to only enhancement of
That
the
you have said
license
already.
fee.
That was what the application
That is the
was.
order itself.
That's the order very categorically.
Because that's why we consciously
Mention.
we
We cannot close the stall in the second letter.
Second letter.
the closure of the stall is connected to the claim because of non-payment of that claim.
Yes,
absolutely.
That claim. That is what you have clarified in today's order. That subsequent one is a fallout of the self-same claim. And in the last sentence, I have made it very clear. In the subsequent cause of action, you can always take it. I deliberately did not restrain you from disturbing their possession or evicting. That order was not passed.
No, at that time, the lease period was continuing.
So they could
But
not
there was a threat on the basis of the claims. If they don't pay, you will.
Yes, so
That's why
so we have come the modification application
That's why I did,
after the part of
that's why
the
I did not
inspection.
grant an injunction order in the first place. That would be a blanket order. I did not grant it.
Or I'm for the petitioner. This is an application for restoration.
Within time?
No. There is a delay of 110 days.
Reason?
Well, the registered the clerk was ill. That's why he could not.
What illness? For 110 days?
No. We don't have the knowledge. Actually, kindly see paragraph number 10 once.
Oh, ill. So miss the item and then you did not have knowledge. Which for the other side?
But on the last occasion, your lordship was pleased to give me direction to serve the contempt. Service effected.
Effective.
I got the track report.
Affidavit of service filed today be kept on record. Yes.
Yes. Delivered. Kindly see the track report.
It transpires therefrom that the restoration application has been duly served on the respondents. However, none appears for the respondents at the time of call. Hence, can 1 of 2026 is taken up for hearing expertise. Upon a perusal of the application, I find sufficient and plausible explanation having been given for the delay in making the application as well as for the absence of the petitioners on the relevant date. Hence, can 1 of 2026 is allowed, thereby recalling the order dated October 31, 2025 and restoring CPAN 742 of 2025 to its original file and number. In the contempt, did I pass any order?
Yes, for
service affidavit.
Yes.
The contempt application be listed next on May 8, 2026.
Yes, obliged. Good. Thank you.
Item number 5.
Yes. Yes, Shana.
Factually, I have placed the matter on the last but one occasion.
How are you, Mr. Bhattacharya?
It's very complex. Very complex. Now I am asked to submit myself before knife and scalpel, and that can be done only in Mumbai.
Oh. Mr. Bhattacharya, you can argue by sitting also.
No, that's not.
No difficulty otherwise.
No difficulty.
Good. Till you are called upon, at least take your seat. When you argue, you can argue in whatever manner. You can argue sitting also. We have no problems. Yes, Mr. Shannon.
No, my lord, I just, my lord, so for the maintainability point, my lord, that's over. My lord, forgot senior friend also accepted that maintainable.
Did I deal with that?
Yes, I think on the last order, your lordship probably recorded that.
No, that's it.
Last but one. Last order, NH copy.
Yes, that is it.
Very. So now, my lord, I placed, thereafter, my lord, I placed the facts of the case that, my lord, the disciplinary proceedings, my lord, we can come up before, my lord, this review jurisdiction, my lord, only 3 counts: violation of natural justice, violation of the provisions of rule, and perversity. So, my lord, we have come up, your lordships, for the violation of the principle of natural justice and perversity. My lord, I take your lordships to the rules first in that. My lord, then I will just point of violation and I will give you lordships the reference of the judgment. My lord, rule 14, sub rule 14, this should be called or para, under rule 106. আচ্ছা জোসেফ আর কোনো কপি আছে তোদের বার কর রুলসটা এটা জোসেফ কোঅপারেটিভ সোসাইটি আছে এটা এক রুলসটা বার কর কুইক জাস্ট আ মিনিট মানে গিভ টেক ইওর লসেস 1 মিনিট কোঅপারেটিভ সোসাইটি একটু হয়ে যায় ঘোরাতে ঘোরাতে হাত ব্যথা হয়ে যায় আমি এখানে গেলে চলে যাই যে
এটা sexual harassment was it regarding a sexual harassment matter?
Yes.
The cooperative rules.
Cooperative rules.
How is that relevant?
Because I have been proceeded under the cooperative rules. I took a point 1 that I will go subsequently, that without proceeding under the Sexual Harassment Act, you cannot at all proceed. I'm trying to satisfy you losses on the point that even under the cooperative rules, these are valid. Yes. Your losses kindly consider section rule 106, sub-rule under the heading or your losses para 14. Para 14, your losses will find
এই বইটা আনি রাখতে হবে বাবু
misconduct and disciplinary action.
এটা একটা স্ন্যাপশট তুলে রাখুন আর হয়ে গেলে yes misconduct
and disciplinary action. The following acts amongst others shall constitute misconduct of an employee, namely your losses will find first willful subordination, disobedience, whether in alliance with co-employee or not, of any lawful or reasonable order of superior. 2, willful avoidance of work of abatement or instigation thereof. Theft, fraud, misappropriation, or dishonesty in connection with.
But this is on a different footing than sexual harassment.
That's only one your losses kindly take note of. Roman V, misconduct. Commission of any act subversive of discipline or good behavior in any public place such as drunkenness, riotous, disorderly or indecent behavior, gambling, taking or giving bribes, or any illegal gratification of any kind whatsoever. As I find, it doesn't cover sexual harassment as such, except if your losses stretch the word good behavior.
Yes, discipline, good behavior, right?
Good. Now your losses will find thereafter, under the rules, punishment have been provided. Your losses will find first disciplinary action, explanation, disclosing all that. Then your losses B, Roman small b. I just got that one after Roman.
Yes, got it.
Any of the following penalties may be imposed on an employee for such misconduct by the disciplinary authority: censure, recovery from whole of the part of pecuniary loss, withholding of increments, withholding promotion, reduction to lower stage, removal from service. These have been imposed. Now your losses will find thereafter, my lord, straightway paragraph 15, disciplinary and appellate authority. 1, for the purpose of imposing any penalty under paragraph 14, the board, which is the appointing authority, shall be the disciplinary authority, and the general body members in the general meeting shall be the appellate authority. Then your losses 2, an employee aggrieved by an order of the disciplinary authority shall have a right to appeal against such order. An appeal shall lie against any order passed by the chief executive officer to the chairman of the board, against the order passed by the chairman or the vice chairman of the board to the board, against the order of the board to the general body of the society. Every appeal shall comply with the following conditions: it shall contain all material statements, arguments relied on shall be complete in itself. It shall specify the relief desired. It shall be submitted through proper channel. The appellate authority shall decide the appeal within 3 months from the date of submission of the application, except but the general body is the authority. 16, my lord, suspension. My lord, then removal from service on criminal conviction. 18, resignation. 19, retirement and retirement benefits, appointment of compassionate ground, and formulation of any other. Now the point, my lord, comes up. There is no procedure laid down under the rules how the disciplinary proceedings to be conducted. Normally it is found, my lord, in the service this is service conditions. Entire chapter is appointment, recruitment, and service conditions. My lord, it has been followed. Now, my lord, according to me, therefore, principle of natural justice has to be read into the rules. Now, this I tell you, Lordships, there is one set of judgment. Suppose there is no provision for disciplinary proceedings at all under the rules. That does it mean that the employer cannot proceed? It's the employer's prerogative. He can proceed. But those line of judgment also says he has to comply with the provisions of natural justice. That means charge sheet has to be given. You can, a disciplinary authority himself can make an inquiry or give it to somebody else for inquiry for fact finding, then report, and then Malad order. Now, how the inquiry to be proceeded with? I have to give a reply. Then your Lordships points Malad documents to be produced. Now, the recent judgment of the Supreme Court says if any document is disputed by the employee, then the author of the documents has to be produced.
In any discipline?
Any discipline, latest judgment. Though it is not right now applicable, but that has to be. Suppose any particular.
Not applicable is not yet passed.
No, passed. Not applicable in my facts of the case because there is no such case. Now, therefore, it's almost like though Evidence Act not applicable, but the principles of law will be applicable like should. Because you were taking away, some of the judgment says it's a quasi-criminal jurisdiction. You are taking somebody's bread and butter. Removal means, I will not be having dismissal means I can consider. Removal means nowhere I will get the employment. So therefore, it's a capital punishment of
stigma also.
Now, the first point I have raised to your Lordships, whether the disciplinary authority can go beyond the charges. There is no provision how this is to be conducted. But normally this is not there. Now, Supreme Court says if it is proceeds beyond the charge sheet, this is violation of natural justice. This is my first point, your Lordships. My Lord, I have to go your Lordships to cite your Lordships one judgment that statute when silent as to observance of natural justice implies requirements of compliance of natural justice. That's your 2004 2 SCC. Page 447, paragraph 10. I will not take your losses to the entire facts. Paragraph 10. If necessary, your losses I will take. Paragraph 10, your losses kindly consider. Kindly allow me, I will be placing 10 but 9 so that your losses can get the matter done. 9, paragraph 9. That brings us to the most crucial question, that is whether the court was required to hear the accused before fixing the quantum of compensation. It is urged by the learned counsel for the state that unlike a sentence of fine before imposition, of which a court is required to hear the accused while considering the question of quantum of sentence, it is but natural that the trial court, after hearing on the question of sentence, does not impose a fine, but in terms of subsection 3 of section 357, proceed to award compensation at that juncture or even during the course of hearing, so as to the quantum of sentence by sufficient indication made by the court concerned. The accused gets opportunity to present his version as to the relevant criteria or norms to be applied in the context of the case before the court on the quantum of compensation. The position cannot be said to be in any way different, while the appellate or revisional court also does not in terms of subsection 4, as long as it requires to be done in the light of the criteria indicated as above, unless it is by any agreement or consent of the party, such compensation has been fixed. Now, paragraph 2. Even if a statute is silent and there are no positive words in the act or the rules made thereafter, there could be nothing wrong in spelling out the need to hear the parties whose rights or interests are likely to be affected by the orders that may be passed, and making it a requirement to follow a fair procedure before taking a decision, unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute, unless there is a clear mandate to the country. No form or procedure should ever be permitted to exclude the presentations of a litigant's defense or stand. Even in the absence of a provision in the procedural laws, this is procedural laws, certainly, paragraph rule 14 and 50. These are procedural laws, my lord. procedural laws, power enhanced in every tribunal or court or of a judicial or quasi-judicial character to adopt modalities necessary to achieve requirements of natural justice and fair play to ensure better and proper discharge of their duties. Procedure is mainly grounded on the principle of natural justice, irrespective of the extent of its application by express provision in that regard in a given situation. It has always been a cherished principle. But the statute is silent about the observance of the principle of natural justice. Statutory silence is taken to imply compliance with the principle of natural justice, where substantial rights of the parties are considerably affected. The application of natural justice becomes presumptive unless found excluded by the express force of statutes or necessary intendment. Its aim to secure justice or to prevent miscarriage of justice. Principles of natural justice do not supplant the law but supplement it. These rules operate only in areas not covered by any law validly made. They are a means to an end and not an end in themselves. The principles of natural justice have many facets. Two of them are notice of the case to be made and opportunity to explain. But I think there are other judgments. If you losses, I give you lawsuits to that extent on the same principle of law. Because other one of the two of the cases your lordships,
if there is
what
any
happened
other aspect of it, then you can decide.
I don't think according to me this is the judgment applicable, because other I just give your lordships what happened. Inquiry officer, my lord, gave finding in favor of the employee. All the charges disproved. Now the disciplinary authority on the basis of same evidence, my lord, discarded the inquiry officer and imposed punishment. Now the question arose, if you disagree, do you not give an opportunity of hearing?
Here also same thing happened.
Not. Well, that's line of this. Here the Supreme Court says the natural justice has to be read into the rules. Therefore, my lord, all that I'm saying, if there is a silence,
fundamental.
These are the things. Now your lordships, yes. The one question I take the lordships. My first question was that the charge-treated officer, inquiry officer, traveled beyond the charges. The charge you use your lordships just for this, for this point to make out. You just take up the charge sheet once. Charge sheet at page. Charge sheet I give you lordships. I give this. The charge sheet at your lordships page. Charge page 75.
75, yes, got it. You pointed out on the last time. Yes.
Now your lordships kindly consider what are the charges. Page 76. According to the complaint of Srimati Pooja Hajra, a member of such and such society limited, Shri Shodoy Chand Mondol, the then manager of such and such, misbehaved and committed indecent behavior with Srimati Pooja Hajra. Now your lordship, this act tantamounts to misconduct in terms of clause 4AV. I place before your lordship 4AV, indecent misbehavior, your lordships. This and your lordships. The second charge your lordships kindly consider, page 77. On such and such date, about 4:30 p.m., Srimati Pooja Hajra, an employee of Vidyasagar Central Cooperative Bank Limited, for performing some works relating to membership of the society limited, when Sri Shodoy Chand Mondol and the then manager of Limited and Sri Ram Prasad Jana, an employee, were present, Sri Shodoy Chand Mondol handed over an application form to Pooja Hajra and insisted upon Sri Ram Prasad Jana to leave the place. Sri Jana left the place when Srimati Pooja Hajra and Sri Shodoy Chand Mondol were in the office. All on a sudden, Sri Shodoy Chand Mondol committed indecent behavior with Srimati Pooja Hajra, and bewildered with the attitude of Srimati Mondol Hajra, became frightened and quickly left the place and reported the matter to PD section bank. Subsequently, the matter was brought to the notice of such and such. But again, charge amala under the clause 4AV. No, and this mala. Then your losses will find these are the two articles of charges. Now, the inquiry report at page 100. Now, your lordships, I have placed my lord entirety. Now, your lordships kindly take up the last paragraph. Just my lord. Now, two questions arises. As the page 100, middle after the middle portion.
Yes, now two questions.
Two questions.
Yes.
Now, whether Sri Sadoy Mondal Charge had any bad motive to call Srimati Puja in the office.
But in the charge sheet, it stated she went.
She went. Now, your lordships, two, whether the charge sheeted employee misbehaved with Puja Hajra, rather molested her.
I did.
So, Malad, the very question goes beyond the charge. Then issue, Malad, kindly see, last paragraph, last two lines. Thus, answer to the question number 1 is, the Sadoy Chando Mondol had bad motive to call Srimati Puja Hajra on such an in the office to get her alone.
Yes.
And next page, your lordships, regarding question number 2, find that all the evidences, depositions, and all the witnesses goes against the charge sheeted employee. Thus, answer to the question that Sri Sadoy Chando Mondol misbehaved, committed indecent behavior with Srimati and rather molested her. Now, this report was accepted by by the disciplinary authority. Your lordships will find page 129. 129. I have taken your lordships to the entire proceedings, so it's not needed now, your lordship.
No.
He accepted the inquiry report blindly. Appeal filed, appeal equally, my lord, dismissed without any reason. Going beyond the charge.
The appeal dismissal is annexed also here.
Malab, the
appeal dismissal is annexed.
Yes. Malab, that's a page I just give you also.
Just for the records.
132. Malab, probably I don't know whether your lawsuit's copy is legible. 132.
Hey, can be deciphered.
Your lawsuits, or should I give a type copy?
Need not. This will do.
Well, kindly see, Malab. You know the general body not to change the order of the disciplinary authority.
Mr. Shanal, before you proceed further, one question to you. Have you made out any case in your this application that they had any other reason to have malice against you or any other agenda against you or any reason to frame you? There is no such independent case run.
I don't think so. I check up if any paragraph.
You need not cock up something.
No. If not there, Malad, on
not there, not there. In any event, if this goes on the procedure also, then you have a good case.
That's
you have to test that after hearing this one.
Malad, the first judgment on this point, Malad, the 1994 SCC online. Oh, Malad, SCC online. Punjab and Haryana High Court, page 1191. দেখাতে হতো আচ্ছা এটা কত প্যারাগ্রাফ বলছিলাম 10 মানে kindly consider your lawsuits 10 and 11
there's a note
noted that's your lawsuit that's why the Supreme Court judgment I brought down.
Yes.
I am at fault because nowadays everybody with this I do not find it there. That's your lawsuits, kindly take note of. I will give a photocopy to that judgment.
No, you have given.
No, the other Supreme Court judgment, noted cases all. Just take
refer to here.
Yeah, here, your lawsuits.
Which one? Achha, this Delhi cloth.
I just no, State of Punjab and others versus Bakhtiyar Singh and others.
Where is it referred here?
That's I just give you lawsuits. This is referred. Supreme Court judge.
Yes, para 6.
Para 6.
So para 6 I'm just marking and I'll just.
The paragraph 6,
I'll check it.
Reported, edition reported.
1972
4 SCC 7.
Yes.
Slow cholo, send note. No, just the quoted paragraph in paragraph 6. It may be noted that Sri Bakhtiyar Singh was not charged with having not discharged his duties impartially. None of the charges leveled against him accused him of not discharging his duties impartially. Hence, the minister was not justified in taking into consideration a charge in respect of which the member was not given an opportunity to explain his position. Look, the charge sheet, my lord, what are the charges I am supposed to deal with? Those only.
Mr. Sandal, I'll ask you something because which is against you. I mean, yes, we can understand that a completely new charge which is not there is brought in the inquiry. That you have a point there. But if it's a question of degree or qualitative difference, in the sense that indecent behavior has been stated. Indecent behavior, although it's very broad, you are not supposed to answer that. You have a point there. But still, it may be argued by the other side that molestation is a part of indecent behavior. And the circumstances were such. A lady went there, charge sheet says a lady went there, not called. Called is a different aspect. You have a better point there. She went there, you asked the person, another person was standing there to go out of the room, and you indecently behaved with her. She got frightened and escaped. So, doesn't molestation come within the broad purview of this charge? It can it be said to be so alien to the charge that it's a new charge altogether? That may be argued against you by Mr. Bhattacharya.
That's certainly. Well, probably that they will argue.
Should argue, I mean.
Well, I tell you, losses. Misbehavior. Well, if I use a very harsh language to someone, that's also misbehavior.
It has several shades actually. So
and
it's a broad
molestation,
sweep, yes.
Molestation means, my lord, some physical assault. Molestation.
We'll have to see the dictionary meaning. Later on, I'll check up.
I will also
use it loosely, but
molestation. Molestation, that's why your lordships, if you say molestation, that will argue
if teasing molestation. Isn't if teasing molestation? If teasing is molestation. In a layman's language, we are speaking because these are laymen. We are not speaking about any technical term used in a statute.
Molestation and sexual harassment are two different things. Then I have to take
molestation is obviously sexual harassment. Sexual harassment is much wider under
much
the act.
wider. That's your lawsuit.
You wink at a lady and you're gone.
That's your lawsuit.
And don't do that.
No.
But molestation definitely comes within sexual harassment.
Sexual harassment.
That's a different argument. We'll come to that.
Now, that argument...
Indecent behavior, isn't molestation indecent? Then what is indecent?
Molestation, if you look at it,
indecent may mean generally rude behavior. Abusive.
Who doesn't not using appropriate words towards a lady.
Yes,
these are the indecent behavior.
Of a lighter shade. I mean, then molestation is more serious.
Serious.
Very.
Something very serious. But there should be a charge sheet must narrative. The second question, the charge sheet is vague. Indecent behavior means what indecent behavior?
Yes.
Charge sheet doesn't say so. That's why your lawsuits, this sort of allegation must first be inquired into by the inquiry committee of the internal inquiry committee of the Sexual Harassment Act. That's the Supreme Court judgment. Otherwise, on this basis of this charge, you cannot proceed. I will show that judgment. That's the second limb of argument.
Complaint or molestation?
If the complaint doesn't say so molestation. Now your lawsuits, kindly see paragraph 10 and 12. It is clear from the above notice case, an employee cannot be punished for a charge which is not leveled against him. Kindly see your lawsuits. Rule 4A Roman V, indecent behavior, misbehavior, indecent misbehavior.
Which is not good behavior.
The good behavior.
Everything can come under
Everything can come under like this.
That's too broad.
One has to be narrate in the charge sheet that these are the behaviors I have committed.
Yes.
Employer's action of punishing an employee in respect of the charge which is not leveled against him results in a breach of principle of natural justice, and it has the effect of rendering the order passed by the employer.
No doubt about this principle.
This
elementary.
I didn't have. Now suppose
it has been held to be elementary.
Yes. That's elementary. Yes. Now your lawsuits, I have taken your lawsuits to the proceedings, minutes of the proceedings. If I'm not wrong, if I recollect, that somebody, I wanted to hold her hand.
Yes, there is a discrepancy in the...
Now, this is not the charge. Somebody comes and gives that on oral evidence. Then does it form a charge?
And this it goes one step further by saying that you called her with the intention to molest her.
Exactly.
And
to get him alone. Kindly see the
alone,
language.
yes.
Get him alone means, my lord, just like indecent. If I want to an office colleague to get him alone in a room, that's very, very indecent.
Not only
The very way they placed it.
Not only indecent, much more serious than that.
That's
and
it.
with the intention to commit molestation, that is much more serious.
So these are not the charges,
Maybe.
your lordships.
Maybe you have a
Charge
point.
cannot be improved by giving evidence on that.
All right.
Charge can be established by evidence.
Yes.
Well, this is the first thing, your lordships. Now, my lord, Cambridge Dictionary says, my lord, molestation means to touch or attack someone in a sexual way against their wishes. That should be.
What is the meaning of attack in Cambridge?
Touch or attack someone.
What is the meaning of attack in Cambridge?
Attack. Quick. To try to hurt or defeat using violence.
That is broader.
To try even.
To try
to hurt.
Try to hurt.
Or defeat using violence. He was attacked and seriously injured by a gang of youths. Armed forces have been attacking the town since dawn. Well, that's different examples. So these, I have to deal with the charges.
Yes.
So these are not the charges, even, your lordships. Then second thing, your lordships.
Molestation, Mr. Channel, may not involve physical touch. Why I'm saying, suppose a lady is going to block her way in an indecent manner, or you just, show her something, some indecent picture or something.
That's your lordship. That's your lordship.
Molestation.
Sexual advances.
That comes within sexual harassment, but we are speaking about molestation without the sexual harassment. That trapping of the act, even otherwise. Or you whistle at a lady.
But
or you make a comment, cute comment.
All these must
come under the act, sexual harassment act. Yes.
No, my lord, all the molestation. I tell you, lordships, molestation must be an element of sexual harassment. A sexual.
Yes. Sexual connotation. Sexual undertone must be there. Must be there.
I take another example of the record. In another college, a very accomplished lady with highly qualified.
Yes.
Another co-colleague in the economics department use the language. তোমাকে সবাই জানে তুমি কেমন জিনিস. This exactly this. Does it is comes within the indecent, but this is not molestation. Now sexual act under the sexual harassment act. Exactly this
under that act, yes.
So it varies in the facts. What the complaint
depends on the context also. Context. If it is used in such an atmosphere where people are used to these languages,
that's
it's fine. But if it happens in a suppose an intellectual gathering, then that may take a different connotation.
That's
so it depends on the context, the background also.
Absolutely. Context with whom I am using the words, who are
under the liberty to use it on anybody. But depends on the context of the use also.
For these, your lordships, I request your lordship, since I'm getting a chance to recapitulation for 71. What's the complaint was of the lady?
Don't recapitulate too much because Mr. Chanel, every time you'll be
that's your lordship.
You will be recapitulating and we'll never finish it. But this has been going on for literally for months. Because we are not sitting regularly, we cannot reach it, something happens.
Now the second was your lordships.
Yes. And I'll take brief written notes of arguments from both of you. Otherwise, continuity is lost already. I recollect, I have my notes, I can recollect, I will. But even then,
second, your lordships, with the charge sheet, today I do not give you lordships. I will, in the notes, I will give that judgment. Your lordships can take.
No, but cite it so that Mr. Bhattacharya can.
I'll give to the Mr. Bhattacharya before the next day. Citation.
But the reference you can give today also.
I missed it today.
What? Very.
So one line of judgment is there. By the charge sheet, reply is called for, written statement of defense or whatever. Written statement is called for from the charge sheet. Now the question arose, before getting reply, can you appoint with the charge sheet an inquiry officer and presiding officer? And whether if you do so, whether it amounts to predetermination of the charges. You're also getting the point.
All right. So if you appoint an inquiry officer, you are presuming that the charge is prima facie at least.
Because I tell you, Lordship, very old judgment says that upon getting my reply, the disciplinary officer may take a decision not to proceed against that.
Understood.
So this, my lord, they have done. My lord, the second point. So this shows, my lord, they are biased. With the charge sheet, inquiry officer and presenting officer were appointed. Then in next পরের judgment জন্য কি দেখাবো বললো? 2017 2 SCC just ওটা আমি তো আনিনি আজকে মিস করে গেছি না মানে this is on the point when the court can interfere with the disciplinary proceedings because has become very narrow after all the judgments of the Supreme Court. This service judicial
to the latest, yes, because you know much better than me the latest question.
2 SCC,
yes,
2017 2 SCC,
Din amendment,
2 SCC, page 308, paragraph 7.
Could you release the other matters? Half an hour left.
No, then I don't think so.
Maybe shorter. Yes.
We have given our anxious consideration to the submissions at the bar.
This is 27, paragraph 7, right?
That the Reed Court is very slow in interfering with the findings of facts recorded by departmental authority on the basis of evidence available on record. But it is equally true that in a case where the disciplinary authority, I am on this, records a finding that is unsupported by any evidence whatsoever, or finding which no reasonable person could have arrived at, the Reed Court would be justified, if not duty bound, to examine the matter and grant relief in appropriate case. The Reed Court will certainly interfere with the disciplinary inquiry and the resultant orders passed by the competent authority on the basis if the inquiry itself was vitiated on account of violation of natural justice, as alleged to be the position in the present case, non-application of mind by the inquiry officer or the disciplinary authority, non-recording of reasons in support of the conclusion arrived at by them, are all grounds on which the Reed Court are justified in interfering with the orders of punishment. Therefore, the case is hand, that's different aspect, your lordships. What are the case, my lord, I have narrated before your lordships. Cross-examination was not properly recorded. That's one of them. Or incomplete recording. I just tell this point I argued when I placed the facts. Minutes, all that I'm trying to point out, your lordships. Suppose, my lord, a deposition is taken of the witness, chief is taken today. Normally we find in the suit, I must be corrected by your lordships.
No.
Suppose 1 or 2 questions is put, then cross-examination is deferred for the next day. That's normally I have found, your lordships, maybe. Now, then he gets the deposition in chief of the either from the court by certified copy or in the law court they had to use in longhand taken note of that so that they can. Now, here the disciplinary proceedings normally is today's minutes is supplied by the next day to the charge sheeted employee so that he can prepare himself what was the question put to her and so that he can prepare and come. The minutes were never given to us. That's what I subsequently got. And deposition recorded, not supplied. Now, these are the 3 things which is judgment of record depositions now. Just tell us. The paragraph 13, 19,
39 to 41.
13. My lord, this is your lordship, sir, arekta judgment. Just your lordship. 2010, 2 SCC, 772, paragraph 39 to 41.
Please repeat the paragraph. 39.
39 to 41. The proposition of law that a government employee facing a departmental inquiry is entitled to all the relevant statements, documents, and other materials to enable him to have a reasonable opportunity to defend himself in departmental inquiry.
Both the judges from Calcutta High Court.
Yes, Your Lordship, that's correct.
Chief Justices, yes.
Now, Your Lordship, as
Yes.
we may re-emphasize the law as stated by this court. The state contended that the respondent was not entitled to get copies of statements. The reasoning of the state was that, may I point out one thing to Your Lordship, since kindly do not miss.
No, why should
Your Lordship, just now before that, since Your Lordship Calcutta High Court judgment, we are all proud of that. In restoration application delay, Justice Chittoto's judgment, the restoration, no condonation of delay appointment application required.
No, there was no condonation application.
Not required. Now,
the-
even Your Lordship nowadays asking us to review in 226 condonation.
In the application which I decided in the morning,
Just 2-3 matters before.
2-3 matters before restoration application was allowed, there was no separate condonation application.
That's well,
It was inbuilt in the restoration application. We take it to be implicit in the restoration.
Now, all that
I see, even in substitution, Mr. Bhattacharya knows, even in substitution, if I ask for substitution, inbuilt in that is that I seek also the sitting asset amendment. We are not technical on that.
No, but Your Lordship, now Your Lordship have introduced review 30 days. That's also
We have many things have been introduced by judgments of the Supreme Court.
No, this is our rules.
Oh, Raj.
These are rules. Now, in Your Lordship,
Section 5 views now are changing.
All that I have to satisfy with Your Lordship that I do not suffer from laches and negligence. Not the number of days. Condonation of delay not required, my lord. I'm getting Your Lordship. All that I'm not negligent in coming before the.
No, but restoration application, there is a statutory time limit also.
No, my lord, I did not find that.
There is 30 days. There is 30 days.
No, that's Your Lordship, not read jurisdiction I'm talking about.
Read by default, nothing is applicable.
But Your Lordship now introduced review 30 days. Initially not there.
Separate application is required.
Yes. Otherwise, the department will not accepting now.
For the last 25 or 30 years, this is going on.
This is not. That's judgment of our High Court also. This is inherent jurisdiction.
Yes.
Now, Your Lordships, that the reasoning of the state was that the respondent was given the opportunity to cross-examine the witness, and during the cross-examination, the respondent would have the opportunity of confronting the witness with the statements. It is contended that synopsis was adequate to acquaint with the respondent with the gist of evidence. The meaning of a reasonable opportunity of showing cause against the action proposed to be taken is that the government servant is afforded a reasonable opportunity to defend himself against charges on which inquiry is held. The government servant should be given an opportunity to deny his guilt and establish his innocence. He can do so when he is told that the charges against him are. He can do so by cross-examining the witnesses produced against him. The object of supplying statements is that the government servant will be able to refer to the previous statements of the witness proposed to be examined against the government servant. Unless the statements are given to the government servant, he will not be able to have an effective and useful cross-examination. It is unjust and unfair to deny the government servant copies of the statement of the witness examined during investigation and produced at the inquiry in support of the charges leveled against the government servant. A synopsis does not satisfy the requirements of giving the government servant a reasonable opportunity of showing the cause against the action proposed to be taken. We may also notice that the counsel for the appellant sought to argue that the respondent had even failed to give a reply to the so-called notice under Rule 9. The removal order according to him was therefore justified. We are unable to accept this aforesaid submission. The first inquiry report dated 3rd August 2021 is clearly vitiated for the reasons stated earlier. The second report cannot legally be termed as an inquiry report, as it is reiteration of the earlier. Paragraph 41. In our opinion, the appellants have deliberately misconstrued the direction issued by the High Courts, and in terms of the aforesaid order, the respondents are required to submit a reply to the charge sheet upon all that. But my endeavor, your lawsuit, is that every part of the documents are produced before the inquiry officer and created during the inquiry. Now, created means, my lord, suppose the deposition have been recorded by the inquiry officer. Minutes have been drawn up. Those have to be given to me so that I can deal with that. This was not followed. Now, my lord, your lawsuits, here in this judgment, one word, my lord, you will find, my lord, in paragraph, quoted paragraph 7, the meaning of a reasonable opportunity of showing cause. Just, my lord, paragraph 39, quoted paragraph 7.
Oh, yes.
Now, your losses, that's why I place the rule. Your losses, nothing is there. So this has to be read into the rules. Reasonable opportunity to defend myself. This has to be read into the rules. Because rules provides misconduct, rules provides punishment, rule provides appeal, rules provides even how appeal to be framed, how appeal to be drawn up. But the rule is silent in regard to how to be conducted. Normally, your lawsuits, all these statutory bodies, this is there. But these statutory rules are...
This is a serious lacuna, actually.
This is serious lacuna. And because of this, my lord, I today am for the employee, tomorrow I am the cooperative society. All the disciplinary proceedings matter against the cooperative societies are entertained by your lawsuits. Because of violation of rules.
Yes.
Now, this is one thing, your lawsuits. 2020. Honestly, just a minute. My lord, this is 2016 6 SCC, sir. 2016 6 SCC 22. Sorry, page 82.
On the next day, the judgment you will give is on this inquiry officer being appointed before reply. On that.
And if I give you losses, with advance copy to my learned friends,
Give him the
synopsis.
reference.
I will give you.
Yes, so that he can, Mr. Bhattacharya can come prepared.
Paragraph 45. Well, here your losses can be seen. If required, then I will take your losses to the earlier paragraph. The privilege committee should have necessarily offered this opportunity in order to make the process adopted by it compliant with the requirements of Article 14. The petitioner in his reply letter to the notice issued by the privilege committee seeks permission to give further explanation when video recording is provided to him. Petitioner number 3 in his reply letter states that he believes his version of his conduct will be proven by the video recording. The other petitioners do not mention the video recording in their reply letters. However, it is not the petitioner's burden to request for a copy of the video recording. It is the legal obligation of the privilege committee to ensure that the requirements of the principles of natural justice, the failure to supply a copy of the video recording or affording an opportunity to the petitioners to view the video recording replied by the committee, in our view, clearly resulted in the violation of the principle of natural justice. A denial of a reasonable opportunity to meet the case. We therefore have no option but to set aside the impugned resolution set aside. But here, my lord, what the membership was cancelled, legislative membership, on the basis of a video recording. But that video recording was never shown to the concerned person, charge-sheeted person. Only, my lord, shown by the committee members.
So even if you did not ask for it, it was there in.
Has to be. Look, that's the basic requirement. Now we, my lord, like I said, I'm saying every time now the Supreme Court comes up, theory of prejudice. That's, my lord, a person getting, my lord, going to lose her job. What more prejudice he will suffer if you do not? What is the harm in it if you give a copy to him? So this way, my lord, the service jurisprudence being little, your lordships, my lord, shown in the light of you. Now, my lord, these judgment, I'm likely showing.
Industry is up for being considered by the 9th judge bench. Industry.
Industry now.
We don't know what is coming.
Neither. But then another, your lordship, Sabrimala.
Different.
No, Sabrimala
It's being reopened.
This is going on.
Sabrimala is that
Again being reviewed because one of the honorable lady judge earlier in favor of the Sabrima.
Yes, I had the occasion to meet Justice Malhotra, Indu Malhotra. In a NUJS there was a conference. I didn't know she was coming. Her point of view was very. I mean, it is a valid point of view.
That's logic. I think, well, with all
sometimes
some matters are there where the court should not go.
Yes, not on the religious aspect of it, Mr. Chanel. I am the last person to be on the religious. That I can ensure. But it's a question. I mean, if I believe none of the petitioners, first of all, had ever went to Sabanimala. Justice Malhotra was telling us, the petitioners, they did not have locus stand even. So public interest litigation. Anyway, there are several aspects to it, and it's a question of belief. Anyway, it's a. Let us see what happens. But this trend is also dangerous now. Last year, 3 judgments of the Supreme Court were recalled by diktat of the Chief Justice. That is also another alarming trend. Although the judgments initially might have been bad, but this trend is also equally bad. Nothing will be final now.
Just now expressed his mind.
Justice
Datta, Dipankar Datta.
Yes.
That this is nowadays we have find that the older views or earlier views
at the drop of a hat, thrown out. That is very dangerous. Good, before it is thrown out, you cite your judgment. Yes. You never know what will happen before you pass out my judgment.
No, that's always we have.
Maybe something else may come.
2020 volume 12 SCC. You are cleaning? Oh, sorry. Sir, 2020.
Yes.
Volume 12 SCC. Page 4 to 6. Paragraph 3, 6, 11 and 12. I tell you losses here. Paragraph 3, your losses will find this is in relation to a college, University Grants Commission have a separate regulation in respect of sexual harassment under the Act. Now, there is a certain allegations. 3, 6, your losses will find the what happened actually,
yes,
stigmatic, and then 12, 11 and 12 I will be placing. In the present case,
11.
Page 433. Judgment hand up করেছি তো?
Yes. In the present case.
In the present case, all the 3 elements are attractive, as a result of which it must follow that the stated order is ex facie stigmatic and punitive. Such an order could be issued only after subjecting the incumbent to a regular inquiry as per the service rules. As a matter of fact, the Internal Complaints Committee had recommended to proceed against the appellant appropriately, but the Executive Council proceeded under the mistaken belief that in terms of clause 7 of the contract, it was open to the Executive Council to terminate the service of the appellant without a formal regular inquiry as per the service of rules. Indisputably, in the present case, the Internal Complaint Committee was constituted in reference to the complaints received from the girl students about the alleged misconduct committed by the appellant, which allegations were duly inquired into in a formal inquiry after giving opportunity to the appellant and culminated with the report recording finding against the appellant with the recommendation to proceed against him. Yolos is getting the background. Internal committee was there in this matter.
Resonates something which recently happened in our state.
Exactly. This was relied upon.
Think about the final order.
I know. Now your losses, what happened? There was the internal committee. A report was there.
We can do the same thing also. We can say that the charges have not been proved, but wherever you apply for service, you have to disclose that this proceeding was initiated against you. You can do the same thing following the Supreme Court judgment.
Now your losses, Supreme Court has said no. Upon receipt of complaints from the aggrieved woman about the sexual harassment at workplace, it was obligatory on the administration to refer such complaints to the internal committee or the local committee within the stipulated time period as predicated in section 9.
This is on your other argument.
Other argument
That
there is no committee at all.
if there was a sexual complaint, the harassment complaint, it had to go to the court.
Now,
Yes, it's admitted that there is
no committee admitted. Now, your lordships, second part. Upon receipt of such complaint, an inquiry is required to be undertaken by the internal committee or the local committee in conformity with the stipulations in section 11 of the 2013 Act. I have placed that act, your lordship. The procedure for conducting such an inquiry has been amplified in 2015 regulations. That's UGC regulations. Thus understood, it necessarily follows that inquiry is a formal inquiry required to be undertaken in terms of 2015 regulations. The allegations to be inquired into by such committee being of sexual harassment defined in section 2N read with section 3 of the Act, and being a serious matter bordering on criminality, it would certainly not be advisable to confer the benefit on such employee by merely passing a simple order of termination. Such complaints ought to be taken to its logical end by not only initiating departmental or regular inquiry as per the service rules, but also followed by other actions as per law. In such cases, a regular inquiry, departmental inquiry as per service rule is also indispensable so as to enable the employee concerned to vindicate his position, establish innocence, we say no more. A priori, we have no hesitation including the impugned termination is illegal, being expressly stigmatic, as it has been issued without subjecting the applicant to a regular inquiry as per the service rules. Now, here you'll also, if I read according to me, after the inquiry by the internal inquiry committee under the Sexual Harassment Act, if there is a complaint of sex, that has to go first. Then that inquiry report has to be submitted before the disciplinary authority or the employer. Now the employer, upon receiving that report, has to frame a charge and proceed against it.
Under the POSH Act?
And no, under the service regulations. That's your lordships, paragraph 12. First, my lord, I just make it clear to your lordships. For there must be, if there is a complaint of sexual, it must go to the internal inquiry committee, complaint committee. The internal complaint committee make it inquiry, file a report to the employer. Now, if the report, my lord, totally, my lord, says that the allegations are not correct, my lord, is totally free. Now, if says the allegations are correct, therefore this report will go to the employer. Now the employer has to take steps according to service rules. Now he has to give me the charge, and that inquiry report will be the part of one of the annexed evidence. So these are the things. Well, they totally has been given go by to it. Next date, I just one or two judgments I will give to your losses and conclude that.
Hard in part. List the matter for further hearing on May 8, 2026. 8th May. Mr. Bhattacharya, no difficulty on 8th May?
We had to accommodate.
Yes, if there is any difficulty, Mr. Sannal will complete and we'll hear you on the then next day.
If I am here, I will definitely come.
I've kept it on 8th of May.
All right.
Thanks. আমাদের টানে নিতে হবে স্ন্যাপশট করে রেখে দেবে নাকি নোট করে
একটা জাজমেন্টের পয়েন্ট ওয়াইজ দিয়ে উপরে ফ্রন্ট পেজ করে দিয়ে দেবো সুবিধা হবে
Item number 6 to 15.
Malad, we'll be concluding our arguments, Malad. Today, only 5 minutes are left. If Malad so pleases, Malad, on the next Friday, we'll give our written notes, Malad. We'll conclude.
I'll keep it on 15th of May.
Lordship.
Because 8th May, several matters have been fixed. There will be an uncertainty whether I can take up.
We have submitted our written notes
On the last occasion, you did.
on the last occasion.
So you will be submitting your written notes and concluding your arguments.
No, I will, I'm indicating it to your lordship. May I start today a little? Because,
yes, why not? If you are ready.
Kindly looks into your lordship's order in contempt. A contempt application has been filed. The matter triggers from the contempt application. Today, your lordship is hearing a contempt application. Kindly looks into the order in contempt. Kindly comes to the order passed by your lordship.
You read out, feeling lazy.
Well, I'm just.
Yes.
This is the CPAN.
The relevant portion which you.
No, I'm just.
So you say we cannot go beyond the contempt in a.
No, that is one aspect of my submission.
That was the first aspect.
Yes. Now, please come to the order in contempt. Now, please see. The petitioner is an agriculturalist. Under the concerned scheme, the petitioner held an insurance policy, the premium of which was to be disbursed by the respondent bank by way of loan. However, the respondent bank stopped disbursing such premiums for which the insurance policy is at stake. Learned counsel contends of the bank contends that due to some technical glitches, some of the premiums could not be paid by the bank. It is also contended that since the payment is delayed, it is no longer possible to pay installments unless the insurance company extends the time for the payment of the same. Despite service, none appears on behalf of the insurance company, although the bank is represented. It has to be kept in mind that the petitioner is an agriculturalist. As such, it is not expected the petitioner would be equipped with the nuances of law and/or technicalities. In any event, since it is not the fault of the petitioner that the insurance premiums were not paid by the bank, the insurance company is required to extend the time for payment of such installments. That was one direction. Accordingly, this petition is disposed of, the number is given, is disposed of by directing the insurance company to extend the time for depositing the premiums by the bank. The respondent number 1 bank shall pay the due installments of premium on behalf of the petitioner under the said scheme to the insurance company. So this direction, insofar as the bank is concerned, was complied with.
They filed a modification application.
No, the insurance company came with a modification application after your lordship implemented the insurance company in the contempt. After 2-3.
We are also modification.
Your lordship is hearing the modification says that the matter should be remitted. I am on a different footing altogether. My humble submission.
Modify the order, then
that modify the order is
contempt may go, but the modification.
Modification would essentially mean subject to correction, that your lordship would have to subject to correction.
Drop the contempt.
The contempt or whatever, the writ petition has to be heard afresh on affidavits on terms.
Not necessary.
If kindly sees your lordship's various.
If on the basis of the writ petition averments, whatever was there, we can also modify.
Yes. Your lordship has immense powers, I am not on that.
Not immense powers, but modification rather limited powers.
With greatest of respect, kindly sees your lordship's orders passed in this proceeding.
In the contempt proceeding.
In the contempt.
Yes.
Compilation ta my lord ke dao. Jira amake tumi pathiyecho.
No, that file is here. You can give the date of the order.
I'll just give.
The cost titles take up 90% of the. Yes. Date of order.
I'm just giving. TNB contempt. The various orders kindly cease. Milord, your lordship was pleased to, in the contempt, first, add, kindly looks into the order of 16th May 2025. And the first order made in this proceeding is 24th February 2025, according to my humble understanding. The implement order of the insurance company, my lord, is recorded in the order of March 21, 2025. My lord, please come to CPAN 1998, March 21, 2025 order.
Yeah, all the orders are here, yes.
Yes. My lord, please see. At the outset, learned counsel for the alleged contempt, in CPAN, your lordship is passing this, no copy of the contempt, etc. However, the affidavit of service, etc. Learned counsel for the alleged contempt note, that is the managing director of the wrongly described as, she is not equipped with the learned advocate for the petitioner is granted liberty to impede the concerned functionary of the insurance company as a party to the contempt application and shall serve a fresh copy of the application of the said added party.
Yes.
Now, this was the order. Insofar as the present contempt is concerned, leave is granted to carry out the necessary amendments.
The liability was to be fixed as to who was the contender, them or you.
Now, then, Milord, on the next day, that is, Milord, by an order, 16th May 2025 kindly comes. On that day, the insurance company, through my esteemed senior Milord, enters appearance and files Can 1. And in Can 1, what is the pleading? Your lordship is pleased to record in paragraph 6.
16th May.
16th May order, Milord, kindly cease.
We'll see 16th May on 8th of May.
We'll see it. No problem. Because I wanted to tell the Honorable Judge, J, there is no contempt. Whatever, Milord, because whatever, Milord, I indicate to your lordship what is troubling me. On going through the various orders, it transpires that, Milord, my client, whosoever he is, has complied with your lordship's order by remitting the money.
That was the only day.
They came and submitted that we can't encash, we are returning. Your lordship desired that they hold on to the checks. They wanted them to produce it and hand it back to us. Thereafter, Milord, there's an order here in the proceeding which obliges them to carry it in court.
We have.
No doubt about it. But the question is that our portion of the order, which binds us, Milord, according to my humble understanding, Milord, rightly, wrongly has been complied with. Whatever the order was, Milord, I am looking only straight, Milord, at the order.
Yes. For contempt, you have to do that. But modification, it depends on the outcome of the modification also.
Lordship will keep it, Milord, on
8th of May.
8th of May, your lordship indicated.
On 8th of May.
Oh, there are other matters, yes. So 15th of May.
He's saying that 8th of May I cannot do. He's aware what will I do on 8th of May.
What? 8th of May.
The 15th of May, man. 15th of May.
Hard in part. List the matter for further hearing. List the matter for further hearing on May 15th, 2020. May 15th.
ছুটি নেই কি রবীন্দ্র জয়ন্তী ছুটি চলে গেছে সে কি আনবিলিভেবল কেন হলো
9 তারিখে করে দিয়েছে
কেন এরকম কেন করলে তুমি
8th May, what?
রবীন্দ্র জয়ন্তী
9th May this time. This year.
We do right.
Milord, happy Milord, long vacation. We are returning on 16th.
It's not a vacation anymore.
Milord, it is for us. No adverse order.
A vacation from here.
That is your lordship's choice.
No. For 2 weeks I'll be in Port Blair. That's what.
Oh, acha.
So there we don't know whether they'll add up. So that's why I said may not be a.
In Port Blair,
this is inspection, my lord. This is
Excellent comment there.
I'm grateful.